ನಾಳೆ ಬರುತ್ತಲ್ಲ ಸರ್?
ನಾಳೆ ಬರುತ್ತೆ. ಫಾಲೋ ಅಪ್ ಮಾಡ್ಬೋದು.
See, please, please.
Yes.
May it please, my lords. May it please, my lords. I seek to move a memo for urgent listing, my lords. For this is a modification application which we have filed, my lords. In light of applicant having third stage cancer and his counting days, small accommodation for change in visitation rights, my lords. My lords may kindly hear it because it's extremely urgent, my lords. For list for tomorrow.
Yes.
Much.
Your Ladyship.
In fact, I've not got custody over the month for over a year. Dasara vacations, I got 3 days custody, but the husband will not give me custody of the minors. Moving a memo.
You're moving a memo for not giving you custody, or you want modification of the order?
I'm not, my interim application has been rejected in the trial court.
Yes.
So kindly have it day after.
This is a matter
Not day
where
after, in the next week, whenever it's convenient to the court, it will come.
Because I've requested for custody during the Christmas break.
When is Christmas? Day after tomorrow? No. So please wait. Yes.
Your Ladyship.
this is a matter where Lordship had intervened in the chamber and it could not be settled. However, the winter vacation has been granted 50%
It
to
will
the
come before
father.
vacation.
Plus, I just don't want it on the 17th, on the last few days, because there are a lot of matters. So any date this week, 11th,
See,
12th, I'm
because I
okay.
have lot of matters, so
Yes.
many adjourned matters.
Plus, this was
Please
taken
give
up.
the memo. No, please give the memo to the court officer.
All right.
As per the convenience of the court, we'll take.
Not
it.
a
Yes.
problem, my lords.
Yes.
We are for
Grateful.
respondent in this, my lord, vacating state actually, they are not complete the stay order also.
What does
I
that
am the
matter?
bank,
What does that matter about?
GM rest, my lord, property, the,
GMRS, this court is not having the roster.
no, my lord, before this court only give the order also.
What is the order?
The interim order is that 25% payment,
You know, if it is a DRT matter, someday before 19th, yes.
On DRT matter, 3/12, this court was not sitting. The matter was posted on that day, urgent to January. There is some urgency.
By January date is
3/12
given
It was posted.
in a fresh matter.
Court,
Is it a fresh matter?
pending matter, 3/12 it was posted before this court because of the not.
You have an interim order in your favor?
Interim order, yes, brother.
Then what is urgency?
Urgency that the petitioner is suffering 80,000 monetary loss because of the violation of the interim order passed by this court, because there is a status quo order to be maintained that has been violated by the respondent by subletting the premises. So urgency is that it has to be held early. 3/12 it was posted, but
We'll see, we will see, we will, see. Yes, yes.
Your Ladyship, this is a DRT matter.
Take the memo as per the convenience of the court, someday accommodate, will accommodate that.
7th of January it was posted, January.
That's what I'm saying, before 19th, whenever it is convenient to the court, we'll take up the matter.
Your Ladyship.
What is that? Why you are taking? Don't take the memos without mentioning, yes.
Your Ladyship, this is a DRT matter. The DRT proceedings are listed on Wednesday, the 11th. There is we have an order in a writ petition acting in our favor. Against this, the petitioner preferred the present writ petition, and by way of interim order dated 23rd September of this honorable court, it's operating against me. The matter was listed on 17 November, but this honorable court was not sitting on that day. Kindly have it on Wednesday, Your Ladyship.
Take that memo, we will see. Yes.
Your Ladyship, Wednesday, please. Your
No.
much obliged.
Day after tomorrow. E-action is scheduled on 10/12.
Yes. Yes.
My lords.
My lords, the challenging surface proceedings, my lords. My lords, sale notice has been challenged here, my lord. I am for the respondent bank, my lord. The interim order has been,
Which year is that?
my lords, 2025, my lords.
When was the interim order?
Interim order is from February, my lord.
It can wait till January also.
My lords,
My lords, DRT matter, we are representing for the State Bank. Last occasion, the court ordered that make the valuation of the property of the mortgage property. We are ready to argument. It's an interim order is there, and the petitioner are using of the benefit of the interim order. Kindly posted for the argument. Valuation of the property ordered by the honorable court. We are ready to argue and file a valuation.
It came up on the last week also, this matter.
11th of,
Yes, then it is some survey to be conducted, that's why the matter is adjourned.
please, my lords, we are ready to argument. We are ready for the argument for the
When is it posted, that matter?
11th of this month, 11th of November. 11th of November.
Thereafter, it was never listed. Next week sometime. Yes.
Fresh matter, my lord, the bank has taken the
Fresh
possession.
matters will come in the
2 weeks
list.
back, it was listed, my lord, not
I have already
listed.
instructed the branch to list all the matters which are adjourned, the fresh matters. It will
The
come.
house has been taken possession, my lord. That's the reason
If it's already taken, we can do it today, tomorrow, next week also. Yes. Call the list. No adjournments, call the list.
List number
One
one,
submission,
for orders matter.
Serial number 72, it's a part of matter. It's the last matter in today's list. Mr. Mahesh, who's handling the matter, is out of town and he's on the Indigo. We had specifically requested the office not to post it today. Unfortunately, it's got posted today. It may be taken up on 11th, please.
70?
72,
Smita N.
yes.
Have you informed the other side?
Yes,
I'm
I
the
have.
other side. my lord.
Yeah,
I have.
Maybe taken up
It
on
is-
17th or 19th.
On 11th, please. On 11th or 12th is also. Don't push it so far, sir.
List this matter on 16th.
I'm
Lord,
ready.
Serial number.
On a
I'm
Wednesday,
ready.
on a Wednesday or on a Wednesday, my lord, senior counsel has been engaged. He has another commitment on this, on
On
Tuesday.
11th, please, may I request, that's a Wednesday.
15th.
I'm great.
Serial number 59, my lord. I'm checking urgent. Serial number 59.
Call the adjournments.
Page wise adjournments.
One submission, my lord. On matter for being spoken to, there is no liability as such. Your lordship order other day passed, there was no liability, only 50% deposit. But order, my lord, stay order, my lord, 50% permitted to withdraw.
Yes.
Kindly, my lord, sorry, my lord.
Problem is when that order is passed, you will be there or your colleague will be there.
I am there, my lord.
Then you should have told the court, you should have asked the court that it cannot be. No, again, repeatedly posting the matters.
My
Is
lord,
it
I
not
was-
that I have passed the orders in
My
your
lord, even, my lord,
absence?
I think court officer also checked, other day we checked. But there is no order as such, my lord, for permission to withdraw.
How will the court officer know? How will you know that there is no order of not to withdraw? You will not write the orders. Yes. List it tomorrow, day after tomorrow.
Cooperate, my lord.
Already over mentioning.
Page,
Fresh matters will come. Yes.
My lords, apologies, my lords, one fresh matter, there's an
All
urgent.
the fresh matters will come. Don't mention. Yes. Call the list.
page one, for orders matter, serial number one. Samarth Prakash.
For the appellant in this matter, my lords, it appears to oversight, the interim order which was granted has not been recorded, my lords, have deposited 50% of the amount, more than 50%. And that way no interim order has been granted. I've deposited the sum of rupees 5,35,491 and the award amount is 7 lakhs, my lord.
This is long back. This order is passed on 18 to 2020.
Please, my lord, we were under the assumption that it was recorded. We deposited the money and that's when the office informed us that there's no interim order.
Where is the stay petition? When the stay petition itself is pending, how will you get an interim order?
Please, my lords.
IA2 of 24 is pending.
Please, that's what we were under the assumption that it was heard because a delay came to be condoned, my lords.
What is this about?
My lord,
Is it a case of death or injury?
Injury, my lords. Case of injury,
much
my
is
lords.
granted?
Minor head injury was there. The bus, there's no insurance. I mean, there is no damage to the bus also, my lord. So the accident itself is being questioned. So there's a delay of over 6 days in the filing of the complaint, and the bus has been framed in this, my lords. Hence, we challenge this.
How much is the compensation about?
7 lakhs, my lords.
How much?
7 lakhs. 7 lakhs 7 lakhs 86,000.
I also file an appeal for seeking enhancement, my lord.
Then counsel for the appellant KSRTC
Please, ma'am.
submits that the vehicle is not involved in the accident. There is no damage to the vehicle. The vehicle has been implicated in this case. Earlier, on
18-2, my lords.
18/2/2025, a coordinate bench of this court has condoned the delay, and all the while, they are under the impression that the stay petition is also not ordered. On verification, it is found that there was no stay in this matter. Then counsel appearing for the respondent claimant submits that they have already also filed an appeal seeking enhancement of the compensation. Considering the same, there shall be stay of all further proceedings. What is this check for rupees 5,35,000?
They have deposited the amount assuming that the stay was granted, my lords. 5,35,000.
This has to be returned. It must have been elapsed long
No,
back.
my lords. It's 1911, my lords, recently.
It's very strange, your submissions.
No,
You say an interim order that is granted in the
because I
month
recorded
of.
that interim order was granted.
No. In the month of February 2025, you say that you have given a check.
No, my lords. We are under the assumption that there was an interim order granted. We deposited this month. It's all
That's what I'm
belatedly.
saying. You deposited the amount in the month of November.
Oh, no, in November. Yes, my lords.
How can it be?
I've informed, I've
So
recorded
you're
that this.
assuming so many things. KSRT is assuming so many things.
No, there's an error from my end, my lords. Maybe I've.
It's already a check for an amount of rupees 5,35,491 is deposited before this court. Hence, there shall be stay of all further proceedings. Admit, post for final hearing, call for the TCR.
Should be permitted to withdraw that amount.
They're questioning the liability involvement. Yes.
Cell number 2, Ravi Shankar CR.
Apparent minute. This the lordship 81,000 is award, but part by limitation. And your lordship has already ordered in 80/35 of 2025.
It is submitted that the insurance company is on the question of liability. And though the amount that is awarded is below 1 lakh, still the appeal is maintainable. Considering the submission, the office objection is overruled.
Stay notice.
IN number 1 of 25. Considering the insurance company is before this court, questioning the liability, and then the issue of when did the accident take place? Before amendment or after amendment?
After amendment.
The is on the liability. There shall be stay of all further proceedings on the condition that they shall deposit 50% of the amount within 4 weeks. Notice to the respondent. Yes, sir.
Number 3. Cell number 3, Pradeep.
Password. Yes, 4.
Cell number 4, Rajshekar S.
For
A week's
petitioner,
time
my lords.
default order.
My lords,
Number
it may be
five.
disposed, my lords, because there is a conditional order and petitioner is not complied it. It may be.
For the respondent.
I am for the petitioner. Our party has not complied the order. It may be disposed, my lords.
It may be disposed.
Total 20.
On 19/7/2022, an order was passed on the condition that the petitioner shall deposit an amount of rupees 8 lakhs within 2 weeks from 19/7/2022. Learned counsel appearing for the petitioner submits that the order of the court is not order dated 19/7/2022 is not complied with. Next paragraph. The present petition is filed questioning the notice dated 17/7/2021 issued under section 13(2) of the Surface Act. When a notice is issued under section 13(2), petitioner has to give a reply to the respondents. On such reply, the respondents are bound to consider the same. The writ petition as filed is not maintainable, and also they have failed to comply with the interim order. Accordingly, the writ petition is dismissed. Next.
Lord, serial number 5, appearing for the petitioner's counsel, my lords. Lords, principally a contention had been raised saying that the property in question is mortgage in respect of only one of the loans and not the multiple loans is contended. Lords, now they have placed a document. Now they have placed a document, my lords, to claim that there is a loan. This mortgage is extended for the other loans also. Lords, we have filed our rejoinder, my lord, saying that this document is apparently a manipulated document. Can I request this matter can be taken up either tomorrow, my lords, or on day after tomorrow? Lords, I will argue this matter. Tomorrow, can I request, my lords, there is some. I have to take my mother for some. No, I'm not asking for any time, my lords, because of my.
Two occasions, Lord, they taken a time before this honorable court. In all the occasion, they are taken time. I'm the.
No.
I purchased the property in the 2023.
This
No
matter on the
possession has
top
been
of the
brought.
list tomorrow. No further adjournments will be granted.
Tomorrow, my lords, I'm so grateful.
Yes.
Cell number 6.
So interim order, my lords, requires to be extended. till
Interim order
tomorrow.
earlier granted is extended till tomorrow.
Lords, I'm so grateful.
Cell number 6. Rajeshwara PN.
My lord, this is a matter wherein, my lord,
No,
the
these are
sufficient
all-
measure
these are all
has
one
been-
and the same.
6 is something different.
6.
6 is Kavita D.
Kavita D.
Yashoda, alva?
Yes.
6 alva? My lord, my sufficient, my lord, measures still before this honorable court, interim order granted, interim order not complied.
No representation on behalf of the petitioner. List this matter for dismissal tomorrow.
Great.
Cell number 7.
Yes.
My lord,
For the
I
respondent, my lord.
I filed an affidavit, my lord, stating that I am ready to close the loan, entire loan, on or before 31st March 2026. My lord, right now I am ready.
Let him submit. Yes.
My lord, right now I am ready to pay 10 lakhs. My lord, they have taken, let me complete.
Let him complete. I'll hear you.
They have taken physical possession of the property, my lord. I have no alternative accommodation for me and my family. My lord, right now I'm ready to pay 10 lakhs. My dues is only 37 lakhs as.
It's coming up for the first time.
No, my lord.
It came up earlier.
Earlier interim order was granted, which I have
On
not.
3/12/2025.
My lord, till now the
1
DD has
minute, Mr. Counsel. Please wait for your turn. The petition has filed an affidavit on 26/11/2025. And it is submitted that today he'll deposit an amount of rupees 10 lakhs.
10
Have you
lakhs.
done so?
No, I'm ready to pay today itself. I have a DD, my lord.
No. It is not about ready. You said so on that, on 3/12/2025 when the matter came up.
No. I'm ready to, I will give, kindly pass over. I'll give
What is
it.
the outstanding amount?
37 lakhs.
12,000 rupees.
37 lakh?
12,000 rupees.
Now today you will pay 10 lakhs. The remaining would be 27. When will you pay 27?
My lord, in 3 installment, I'm ready to pay. Before December 31st, January, and last installment with interest, I'm ready to pay.
February.
February. No, March 31st, before March 31st.
Kindly pay to the DD 10 lakh rupees. 10 lakh rupees, till now they were not paid.
No, I have a DD, my lord.
DD is ready. You can take the DD today.
Previous date, they said that.
No, DD is ready.
I
my
will
lord.
pass over now. I'll pass over. Have you filed that affidavit before the court?
Yes, madam. My lord, I filed
That you will complete it, you will clear the entire amounts by February.
Yes, my lord. In my affidavit, I have stated.
Where is that? Have you received that affidavit?
No.
Afternoon, give the DD to him. I'll dispose of the writ petition.
Much obliged.
Number 8. Mahabaleshwar.
Same for the respondent, please. Respondent matter, please.
The senior counsel is arguing the matter, my lord. He's engaged in another court.
My lord, there is.
Ask him to come.
Please pass.
Great.
Yes.
Cell number 9.
Appearing for the respondent, my lord, kindly pass over the case.
I represent the petitioner. Let it be passed over.
Yes.
Cell number 10. Cell number 10.
I appear for the petitioner, your lordship.
Lordship, the petitioner in the above case prays that this honorable court be pleased to permit him to withdraw the petition with liberty to file a fresh petition, my lord.
The present writ petition is filed, questioning an order. Where is the impugned order? Order that's passed in C miscellaneous number 561 of 2023 on the file of the first additional principal judge family court at Mysore. Office has raised an objection with regard to the maintainability in view of section 19(4) of the Act. Then counsel of the petitioner's office that they may be permitted to withdraw the writ petition, and I am with the liberty to file an appropriate petition. Accordingly, the writ petition is dismissed as withdrawn with the liberty to file an appropriate application within 1 week from the date of receipt of the copy of the order. Registry shall return all the documents.
Cell number 11, Vijay Kumar.
In this case, I am appearing to petition, my lord.
What is this council submission?
That the R3 is the owner of the property and is the proprietor also SLV POAP Gypsum Sales and Works factory. But he's taken the loan from the mortgage of this property of this company. Company means he's the owner of the property. So the office raised an objection stating that the workers have to made a party. But there is no any dispute between the workers and the owner. The third respondent is the owner of the property, sold the property in favor of the petitioner for 1 crore 5 lakhs. So in view of this, the office objection by the office, raised by the office, is not necessary to make the parties of the laborers, those who are working. But it is a closed. The factory is also closed now. And this, in respect to R1, R2, we are made an officers as the party to the proceedings.
Why they are insisting for this? Ask them. Let's find out. Ask them why the worker should be made a party. Yes, tomorrow.
One submission, ma'am.
The respondent should, the office should clarify why the workers shall be made parties to this petition. Yes.
No problem is this, ma'am. Just only 2 minutes. I will take this honorable time. The third respondent is the owner of the property. But he sold the property in favor of the petitioner, Kumari Kirti, yes, for 1 crore 5 lakhs. But out of it,
I'll take it up in the afternoon.
pass over, madam.
Yes.
Cell number 13, Samir Fias.
2 o'clock.
Passovers will be called after 2:30, not 2 o'clock.
Kindly pass on.
Serial number 12 was not called.
12. Siddharth Suman.
Yes.
Siddharth Suman, I called.
Serial number 13, I appear for the petitioner.
12.
Yes.
Please. This matter which had come up last week, my lord, the office objection was with regard to maintainability, where it's a third party, my lord, who has challenged the order passed by the family court. This is pertaining to certain CCTV footage and certain personal information
Who are
being
you?
sought for. My lord, the petitioner is one of the friends, my lord, of respondent number 2 and 3. Respondent number 2 is the husband. Respondent number 3 is supposed to be the paramour, my lord. The respondent number 1 is the wife. She files a petition for divorce. I had already, in the sense, respondent number 2 had already filed a petition for divorce previously.
You're the friend of the parent.
I am the friend, my lord. My lords, may kindly see what is sought for in the
Of the husband
of
and
the husband. Both. My lord, of the husband as well as the paramour. My lord, it is our contention that there were about 25 of us that day. My lords, may kindly see what they have sought for in the application and what was allowed also. My lords, may kindly come to page 62. This is an application to summon CCTV footage, visitor entries, logs, everything, my lord. Insofar as, my lord, what is sought for in 1 and 2, my lord, I may not be really aggrieved. That is not per se pertaining to me. But my lords, may kindly see 3 and 4. We were 25 of us who had gone that day, my lord.
3 and
3 and 4, my lord. My lords, may kindly see page 62.
visitor entry logs and copies of identification proofs
submitted during the time of check-in during stay. Then thereafter CCTV footage for the period between so and so, so and so. Malad, that is where there was a concert, something called Digital Bangalore, which was in Prestige Golfshire. We had about 25 of us who had all gone together, Malad. And in that, Malad, in the particular, in respondent number 2's room, Malad, 25 of us, Malad, we have gone for a party there itself. Now what they have sought for is, Malad, may kindly see, common areas of the premises, including but not limited to corridors, lobbies, and all other areas in the vicinity allotted to the aforesaid individuals during their stay. Everything is sought for. Now, 1 and 2 Manad is specific to respondent number 2 and 3. 1 and 2 Manad, respondent number 2 also furnishes the details with regard to his bookings which are made. That is already given. Despite all of that, Manad, the learned family judge says, no, all of this can be sought for. But if it is sought for also, even if third party faces a sin, that can be blurred. That is not there in the operative portion.
That will clarify now.
Please, that is not in the operative. No, just one more issue here. Issue with regard to whether CCTV footage itself can be summoned or not. That, my lord, is subject matter of proceedings before the Honorable Supreme Court. That, my lord, Sachin Arora had dealt with it. I'll just pass on the judgment. I have produced all the subsequent orders where, my lord, the Honorable Supreme Court says, see, whether or not this can be pulled even with regard to people who are parties to the proceedings, that had to be considered there. I'll just take, my lord, to certain orders which are passed. This is the order which is challenged. I just want to point out, my lord, because where, my lord, the coordinate bench of this Honorable Court.
What is the prejudice that is going to?
Let me be very as discreet as possible. We've all been parting there. Manad, we have high network individuals, we have politicians, we have all these details are coming out. Manad. I don't want people to know who I was with that day. Manad. I have nothing to do with this. Let them file, let them do whatever they have to do. Manad, may kindly see, I'll just take my loss to the MC petition. They had also filed, this is I number 6. I number 7 was with regard to certain other hotel details that they don't seek for. They seek for this, Manad, in a lot of urgency. Manad, may kindly see, I'll just take my loss to the Malad, may kindly come to page 37, Malad. This is the MC petition. Malad, I'm not even going on to the merits. I have nothing to do with the merits. But my lords may kindly see why this particular information was sought for is because, Malad, they want to basically break the ecosystem to find out who was there with so-and-so person. That's it. And if, Malad, all these records are then called for before the Honorable Trial Court, this will be then utilized, Malad. Because everybody, Malad, there are 25 of us there together. We've all gone to that room together. I don't want this information to come out. My lords, may kindly see page 37, paragraph 19, my lord. Respondent number 1 and 2 have also travelled together on at least 2 known occasions from 17 to 19 January 2025 to Pune and again on 17th to 18th February 2025 to Mumbai. In Mumbai, the two resided together at Star Sahara Hotel. These facts further demonstrate the ongoing relationship between so-and-so. This is not sought for. This IA number 7 is emerald. This is not sought for. Why don't they ask for this then? In a lot of urgency, Manad, so basically the respondent number 2 had come on caveat. Manad, in a lot of urgency, this IA was pressed for, asked only for this particular bookings. Why was this not sought for then? They say that 30 days it gets over. It doesn't go in 30 days, Manad. For 1 year they return it. Only this was sought for. This is only to get the information of people who were there that day. Nothing else, Manad.
Yes, what do you say?
Lord, the CCTV footage, may I file my own. Lord, the petitioner, Madam,
take that.
The petitioner is a very close friend of my husband. My husband, my lord, the respondent in the matrimonial proceedings has not challenged the order. This is, my lord, a proxy who's challenging the order on his behalf. Lord, your lordship may kindly see the.
No, as you were saying, they have their own apprehension.
But I have not sought any record with relation to third party. Kindly see the order. My learned friend has not read the order. The order challenged is only with reference to the respondents in the proceedings, not with regards to any third party. No, this is a friend who's trying to protect.
Their apprehension is if that CCTV footage is placed. So like according to them, there are about 30 people involved in this.
Yes.
So everything will come to light. Maybe that's not, that will lead to another case.
Look,
I don't want that.
Lord, proceedings before family courts, Lord, are completely confidential. In fact, this Honorable Court has passed a judgment that even documents before family courts cannot be accessed by any third parties. It is only by the parties. The fact that my learned friend has received documents, before I go to that point, my learned friend is the one who appears for their husband in all proceedings.
Yes.
In all
yes,
proceedings.
I'm not even shying away from the fact.
The fact of
How will I know about this? I know
between,
because he's told me this.
I will, sir.
Sorry.
The fact that there is collusion between the petitioner and my husband is apparent from the fact that the counsel who has filed this petition and representing the petitioner herein is the very same counsel who represents my husband in all proceedings.
Circumstances, you cannot say that yours is a independent cause. What
I'm
they
not
say
saying that,
there is
Manoj. I'm still.
No, there is a collusion between you and the husband has to be
Assuming for
accepted.
the sake of argument, there is collusion, my lord. I'm not saying I have no relief against respondent number 2 and 3. My lord, no notice may be issued to them also. I'm only saying this, my lord, as far as 3 and 4 is concerned, only those two reliefs. And so far as respondent number, in so far as the resolution number 1 and 2 is concerned, I'm not even touching that. It does not concern me. I'm only concerned with the CCTV footage and the visitor entry logs, my lord. Why is all of that being sought for? That is, my lord, third party information. Why do you want to pull all of that inside this?
My lord, I've asked for, can you see the order, my lord? The order passed by the court.
No, let's go again to your application.
Yes.
What specifically you have asked?
My lord, I've asked for their check-in details.
Let's see that.
Yes,
Wait, just now he is referring to some, IA.
2, my lord.
Where is that?
62.
Page 62.
Let's go to that.
Yes.
Accommodation details of, this is fine.
1 and 2, my lord, no problem.
Details of the person who booked the room, mode and date of booking together with contact details for these two rooms only, for the room booked for respondents.
No, when you get this,
yes,
where do you want the next one?
No, the next one.
No, 2.
2 because, my lord, there is a possibility, my lord, that there are 2 separate rooms booked for which my husband has paid for both the rooms. Therefore, I have sought payment details for both the rooms. Who has made the payment? So you need to establish my entire marriage has come tumbling down because of this relationship. Number 3, guest registration form for those rooms, visitor entry log for those rooms, copies of identification proof submitted at the time of check-in for those rooms.
It's not for those rooms. It doesn't say that at all.
No, kindly see the order. The order is only with reference
No,
to
if
respondent
that is
number
the
2.
case, we'll clarify to that room.
Yes. No, my lord, so then what about the CCTV footage? We've all gone there. We've all gone to that room.
No. If they ask for the CCTV, even
Please.
if you're not before the court,
Please.
or 30 of you have not gone,
Please.
when the CCTV has to be given, it will record everything from so and so time to so and
Everything,
so
my lord.
time.
So which is my lords may kindly see common areas, lobbies, every single thing, my lord, in the vicinity of that room. Why, my lord, third party? Now, what does he want to establish? He wants to establish that there is adulterous conduct in so far as fundamental
As
2 and
far
3
as
is
them,
concerned.
they want
As
to
far
know
as
the
they are-
information as far as them.
So, my lord, R1.
When they were moving in the common areas,
Please.
that's what they want. So
My lord,
they will
may I
give
just-
they will give the details
Please.
wherever those parties are present.
Please.
And as the others are concerned, the
Now,
image
my
should
lord,
be blurred.
everything, my lord, it's already reached court. Everything has been sent. Every single thing has been sent.
It's already with the court.
It is already in court.
I do not know how my learned friend knows what has been sent because everything is in is a sealed cover kept in safe custody.
No, I'm presuming that that's it. Everything has been sent. Whatever has been sought for has been sent.
Let us not take for may I make the submission? Let's assume not the respondents to the matrimonial proceedings are found to be affectionate in public areas, and the petitioners also present along with them. But what prejudice would cost the petitioner? Not ultimately what the court is looking at is only about those conduct of those two people. But this is very clear that the petition has been set up not by the respondents in the petition.
No, what do you say about accept the parties to the MC?
Yes.
Wherever the other people are there in that CCTV footage, let that be blurred.
That's what the court has said.
It's
But
not
he
there
says
in the
it is
order.
not reflecting in
That
order.
is the order of the court.
It's
Please
not
come
there.
to that.
Not page 28. May I read para 15 from page 27, just that one paragraph. Para 15, page 27. On careful perusal of the application, it appears that the petitioner, by filing this application, has sought information about the parties to the proceedings and not about third parties. The petitioner has made serious allegations against respondent number 1 with regard to his adulterous relationship with respondent number 2 during the said period in the said resort. The petitioner has not sought for any information with regard to third party in the application. These documents are confidentially maintained by the said resort authority. Section 14 of the Family Court Act allows the Family Court to receive and report any report, statement or document as evidence to help resolve a dispute for the just and complete adjudication of the matter. Even respondent number 1 has admitted that he stayed in the said resort along with respondent number 2. Therefore, what prejudice would be caused to respondent number 1 if the information sought in the application is summoned? If at all any third party appears in the said CCTV footage, it can be blurred from visuals. The information as sought by the petitioner.
It's not in the operative portion, my lords.
We will add it.
I will just before I can go into that aspect, my lords, may kindly see the order which was passed by Delhi High Court, which was challenged before the Honorable Supreme Court. That is still the Honorable Supreme Court is seized of the matter, and they say do not touch it till we pass the.
That's by the husband.
Orders.
That is filed by the husband.
My lords, may kindly see. I'll just take my lords to this. The operative portion, my lord, insofar as the Honorable High Court is concerned, they also, my lord, consider the coordinate. of this honorable court, where it was a third party whose call records were sought for. In fact, my friend also appeared in the very same matter. Third party had gone and challenged it before the Honorable High Court, saying that, see, my call records are being sought for here. I am not even a party to the proceedings. So here, my lord, you may not come and ask for it directly. You're asking for CCTV footage, knowing for a fact that there are about 25 other people. You may not name me, you may not pinpoint and tell me that, yes, so-and-so person was there. But what you cannot achieve directly, you're trying to achieve indirectly. That is basically what you're asking. Now, what are you trying to establish? Adulterous relationship. But respondent number 2 has already filed details before the Honorable Family Court, saying that, see, yes, we had made these bookings. Yes, she was also present, but there were 20 other people.
Correct.
That is what he wants.
So what they want to,
they want
to
information.
demonstrate, what
Please.
they want to demonstrate is not casually, that's not a friendly, casual relationship, but it is something else that they want to establish by the CCTV footage.
Well, so which is why, anyway, Malad, this is not something which they're seeking for CCTV footage inside the room. That is not there anyway. That will never be available.
Not necessarily outside also, like
Please.
they
So
want to
there,
demonstrate.
that is where, Malad, we all feature.
Why should we stop them from doing
That
that?
is where we feature, Malad. Where 25 of us have gone in and out of the room, Malad. Why should, now, what my learned friend said is that, see, yes, respondent number 2 and 3 may be together, petitioner may be with them. What is there? So what if we, Malad, I may be with 100 other people. I don't want that to come out. Why
So
is that being?
what will happen?
Malad, there are certain reasons why 25 of us have gone there together, Malad. There are certain reasons why we want
That's what the court
specifically.
needs to understand what it is.
Malad, again, let me just go into this, Malad. I would say that why am I being dragged into something which I have nothing to do with?
No, you are not being dragged. They are only trying to establish their case. In the process, if you are also with them, that is not, you cannot say that
My
I'm a
lords
third
will have to
party.
look at. My lords will have to look at the intention behind the entire thing. My lords has seen. Like I said, my lord,
As you said now,
please,
that nobody can know what's happening inside the room.
Please.
So
please.
by what is happening outside the room, in the corridors.
My lord, who I go inside that room with also is very important for me, my lord. Who I go with inside that room is also very important for me. I'm not saying that I'm in some other relationship order, but I'm saying, my lord, we're 25 of us. We've all been going in and out, my lord. Why are we being pulled into all of this? That's the entire intention, my lord. My lord has seen IA number 7. In fact, I've not produced IA number 7. IA number 7 is with regard to the Star Sahara Pune. They don't ask for it. They only ask for this. Because in that, Manad, this masala is not there. There are no 25 other people. In this, Manad, they want all of this information, Manad, to use this tomorrow to then ensure that they get a settlement. That's it. It's only to ensure that this other ecosystem who is there with respondent number 2 is then broken. I have information pertaining to so-and-so, so-and-so. I have information pertaining to so-and-so, so-and-so. Ensure that your friend does so-and-so, so-and-so, so-and-so. And this will be closed. That is it. That is the entire intention. Why didn't they press for I number 7 then? They have not pressed for I number 7. Only I number 6, Manad, with what tearing hurry. Manad, they ensured that yes, this was taken up. They ensured that it kicked up a ruckus saying nothing doing, this will be deleted, that will be deleted. Manad, it will never be deleted. For 1 year, the CCTV footage can be kept. May I just take my lords to the Delhi High Court judgment, Manad, which Manad was called into question before the Honorable Supreme Court. That, Manad, my lords may kindly come directly to paragraph 42, but just so that my lords as a precursor, this is with regard to same CCTV footage itself. I'm only on the CCTV footage part, Manad. My lords may kindly see what was sought for was a CCTV footage from one hotel Fairmont, Jaipur between so-and-so, so-and-so, just to establish this adulterous conduct.
No, I'm looking at this Sachin Arora.
This, same. This is Delhi High Court judgment, which was then called into question before the Honorable Supreme Court. Honorable Supreme Court has seized of the matter as of now. My lords may kindly come to para 42. Vishwas Shetty is what my lord coordinate bench of this Honorable Court holds, saying that a third person's information can never be sought for. He has nothing to do with it. 42, my lord. May I take my lords to 42 minutes, please? Before I conclude, I may also refer to the decisions of so-and-so, so-and-so and Vishwas Shetty. Vishwas Shetty is important, but find that the same are not applicable to the facts of the present case. In Surjit Singh, the Punjab and Haryana High Court, after noting that virginity of wife was not the issue in the matter, declined to interfere with the family court's order rejecting the husband's prayer to get his wife medically examined to prove her virginity by holding the amount to a roving inquiry. In the present case, respondent has not only raised a specific plea of adultery against the petitioner, but even otherwise, she has sought only information.
No, this is altogether a different case. In that, straight away they've asked for the call records of a third party.
Please. Which is why, Manad, here you're not asking it directly. You're asking for something, Manad, which you cannot get directly, indirectly, by asking for CCTV footage, everything.
The whole problem is there is something for the petitioner
Please.
Who is a third party that he doesn't want certain information regarding him.
Please.
Should be public.
Please.
But in the process, you can't stop them from having, to prove her case. She wants to place all the evidence on record. Why should we stop them?
Malad, so respond. So as far as relief 1 and 2 is concerned, Malad, I have no objection. Like I said, Malad, I can never even talk about that because that doesn't pertain to me.
No,
They
you have an
got those
answer in
details.
your arguments itself. No, they want the CCTV footage in the corridor
Please.
pertaining to them.
It will not be so, Manoj. My lords may kindly see what is the order.
That's
Order
what
doesn't say that.
I will clarify that.
May I I'll just try to convince my lords a little more
No,
on this.
nothing else. Like,
Please.
I'll clarify that.
Please.
The CCTV footage pertaining to the common areas, the corridors and everything
Please.
shall be given pertaining to these people.
These people, in the sense, Manoj, will never be a situation where, Manoj, only if they find 2 of them together, only with anybody, with nobody else, Manoj, I have no problem. Will they find something like that is the question. If they want to prove that only 2 of them were spending time with each other.
I am not able to understand this. In all the cases, we'll have, when we call for a CCTV footage,
Please.
there will be everybody, not only
Please.
in this case.
Please.
Whoever, then all those people will come to the court and say, because I am also going around in the corridor.
I will just point on. I'll just point out. I'll just try to convince my lords with this, and then my lords may then.
Yes.
My lords may just read a little further, Manoj, because Vishwas Shetty's case is very important. In Vishwas Shetty, the court was dealing with the husband's prayer seeking for call details not only in his wife but also the alleged paramour. The court rejected the prayer seeking call details of the wife's paramour by holding that the same would amount to infringing his right to privacy. In the present case, the respondent has admittedly not sought for any details pertaining to the petitioner's friend or her daughter, and therefore this decision would not also forward the case of the petition in any manner. Now, this, my lord, was challenged before the Honorable Supreme Court. May I just take my lords to what the Honorable Supreme Court says, my lord?
Where is that?
My lord, may kindly come to 76 of my compilation, my lord.
Yes.
My lords, 76, these are just the daily orders. My lords, may kindly come to page 78, towards the bottom, my lord. In view of the fact that the ongoing earlier orders, the details sought for in the parties concerned are in a sealed cover. It is ordered that the same on receipt shall not be opened without further allowance of
Nothing,
court.
this is nothing, this
Please.
is not an order.
Please, my lords, may kindly come to a little further, my lord. Because permission was then sought for to get access to this. My lords, the Honorable Supreme Court refuses that. My lords, may kindly come to 86.
Yes.
I number so and so is an application for directions filed by the respondent wherein the prayer is made to direct the family court to opening the sealed cover containing whole records and so on so on. So we are not inclined to entertain the aforesaid application. Accordingly, the stands dismissed. So what I'm saying, my lord, insofar as this is concerned, the honorable this is the argument which was canvassed. My lord, I appeared for the husband there. I'm not shying away from it. This was the argument which was canvassed also, saying that till the honorable Supreme Court is seized of the matter, till any decisions are passed in that, please do not summon anything, because this can have far-reaching consequences not only for the parties to the proceedings. Here, my lord, it was the parties of the proceedings who have gone and challenged it. Here, I am coming as a third party, saying that, see, this is what it is. This is what I apprehend. So I'm just saying, no, as of now, it is kept in a sealed cover. It is not, because we filed a memo to the effect saying that please keep it in the sealed cover till anything is decided. Oh, court itself. I'm sorry. We didn't have to. The honorable court itself has done it on its own accord. Now, the only issue is, how do we then now blur everything else inside? Is it possible to even blur something like that? Because that the order may say that yes, you have to blur it. Is it practically possible, Manad?
Why not?
At least I don't think so. I don't think so.
Why it can't be blurred?
It can be.
Even in the court proceedings also. Now, for example, if the live proceedings, if a party is appearing, we are blurring that image of the party, and we are still the live telecast is going on.
I don't know how practical it is possible, Manoj, because here, as far as blurring everything else around, I don't know how practical it is. If my lords were to say that yes, this order would then be restricted only for CCTV footage where only 2 of them are there together, Manoj, let them. That, Manoj, I would not have any objection.
Not like I mentioned, my lord, in the lobby area, if the respondents are found along with other people, the other people's faces may be blurred. What my learned friend is saying, only when those 2 are found, only
No, that's not.
Absolutely, I have no objection.
Well, as far as the order is concerned, I think what he says is that is there in the discussion, which doesn't form part of the operative portion, that we will clarify.
What happens here, my lord, in the order also, if my lords were to kindly see the operative portion,
yes,
I would say, my lord, as far as 1, 2, 3, and 4, because there are 4 parts of the relief. 1, 2, and 3, my lord, to a certain extent, 3 also, what the learned trial judge says is, see, let it be only pertaining to 1 and 2. But then, my lord, this also has visitor entry logs. Now, visitor entry logs, my lord, that is pertaining to third parties. if it is pertaining to third parties, because here, my lords,
For visitor entry log as far as this petition is
not so, my lords, may kindly see here. See,
We will say, we'll clarify
Please.
that. Why they
Visitor
want the
entry-
entire world's, the registration log?
Absolutely not. But it's possible that my husband has booked a room in his name and the second respondent has gone to his room as a visitor. Therefore, visitors of that room.
Whenever the name of the petitioner, name of the respondent find.
My lords, may kindly see.
have no interest.
Be
We
called
have
for.
no
My lords,
interest
may
in any
kindly
third
see
party.
31, my lord, because this is where some confusion also starts. Page 31, that's the operative
Read
portion.
the operative portion.
Please, I'll just read the. My lord,
Start
one
reading
and,
from page
1 and 2, I will not, my lord, 1 and 2, I will not go
Accommodated
into.
details of
I will not
so-and-so,
go into that.
who
because
booked
I'm
the
not-
room, yes.
Please, I'm
Then
not on
three.
that. 3, guest registration forms, visitor entry logs, and copies of identification proofs submitted at the times of check-ins during such day pertaining to the respondent number 2 and 3.
That's what is so clear.
Please, now my lords, may kindly see visitor entry logs pertaining to the respondent 1 and 2. This is, my lord, with regard to their rooms, who's entered their rooms as well. If my lords were to clarify saying that visitor entry logs does not pertain to third parties and it's only them, my lord, I have no problem. I don't want, my lord, the entire list is there.
I think it appears to be very complicated.
We have so many couples who have come around. There are husbands and wives who have come there. Maybe husbands and wife, maybe somebody else may have also come around. I don't want all of that to come out. Why should that come out?
No, this court is one, with great respect to my learned friend, my lord, these kind of prayers, not in a proceeding, matrimonial proceeding, where the entire proceeding is confidential, documents are not available to any third parties. No trial can go on, my lord, if these submissions are made.
No, he wants to
But
prove this.
ultimately, the purpose of all this filing these applications is to show that your husband is living a adulterous life.
True.
So whatever that is required to prove it, you can have. In that process, again, you cannot give rise to another MC to be filed.
My friend and I not have one more
by some other party.
I'm not saying that, Manoj, but I'm only just saying that see, this,
Yes.
Manoj, this goes
We'll
late in the night,
clarify.
Manoj.
We'll
We're about 25 of odd, Manoj, we partied
yes,
late,
please
Manoj. I don't
come.
want that to come out.
Please come.
My lords, see, just 4 before I can
Yes.
conclude. 4, my lord, 4 if my lords were to kindly see. This, my lord, is not, so this, it says that areas in the vicinity of the room, lobbies, corridors, everything put together, my lord. So even common areas, everything. Though, my lord, there's a small caveat in the end.
I'll clarify that pertaining
Please.
to where the respondent number 1 and 2 are visible.
Please.
Only those and the other remaining others, it will be blurred.
Like if they are visible, my lord, if they're by themselves, because what he wants to prove now here, it's not disputed that yes, 1 and 2 were there, my lord, together. I'm not saying together in the sense they were living in the room together or whatever it is. I'm saying, my lord, they are together. There are about 50 or let's say 25 or 30 or how many of people together, my lord. If they are found alone, because what is he trying to prove?
No, alone.
My lord, what is he trying to prove, my lord? He's trying to prove adulterous conduct.
No, for example, when all of you are together
Please.
and the manner in which they are behaving,
Please.
which demonstrates that they're living in, I mean, their relationship is not just like friends, then we cannot say that. I'll say, wherever these two are found, respondent number 1 and 2, everything can be given, and if there are other people in that, in those CCTV footage, let their faces be blurred.
Please, and may I just add one more thing, Manoj? Let this continue to be in a sealed cover, Manoj, because that is what is there. As of now, it's kept in a sealed cover. As of now, it's kept in a sealed cover.
What is the purpose of passing this order
Manoj,
now?
as of now, it's kept in a sealed cover.
No, if that's the case that we
Please.
have to wait till the Supreme Court passes an order,
Manoj,
why should we clarify it now?
this is something which has to be looked at the time of evidence. We are very, Manoj, as of now, the MC case is at a very, very nascent stage. But right in the beginning, Manoj, this was sought right in the beginning. It was sought as an ex parte order. I'm only saying, Manoj, let it be in a
Two
sealed
things.
cover.
If we have to keep it in a sealed cover and keep it forever, there is no reason to clarify this order.
I do understand, Manoj. The only issue is this. Now, what is it going to be used for right now, Manoj? Because as of now, what is it going to be used for? Because as of now, we're in a very, very
So
nascent
if
stage.
you know that it is not to be, unless now the trial commences till such time, nothing can be done.
As of
Let
now,
it
it's in the
be,
sealed
let
cover,
it
Manoj.
be.
As of now, it's in the sealed cover because
Let
the
it
Honorable
be.
Family Court itself
No,
has.
I will not say till what time it will be in a sealed cover.
Please. Then, Manoj, I won't invite any attention on that, Manoj. Then my lords may it's in a sealed cover. Let it be in a sealed cover till whenever it is.
I will not say anything. I'll only clarify this order.
Please.
Yes. Agreed with the order passed in I number 6, dated 31st October 2025. A third party is before this court. The respondent number 1 has filed. No. Which respondent is this?
Yes, respondent number 1 has.
Respondent number 1 has filed the MC 6606 of 2025 seeking divorce seeking divorce against second respondent, who is the husband, on the ground of cruelty, and the third respondent,
And adultery also.
cruelty and adultery. And according to the first respondent, he's living in an adulterous life with the third respondent. The petitioner before this court is a friend of one and two.
For 2 and 3.
1, 2, and 3.
2 and 3.
Is a friend of 2 and 3.
In fact, my lord, one also, my lords, may record it because we are all friends. I'm a friend of everybody, my lord.
All 25.
All 25, including, my lord, the wife.
Petitioner is a friend of all the respondents.
That's not even the claim in the petition.
It is.
According to the land council, for the petitioner submits that the third party is a friend of respondents 1 to 3. The IA number 6 is filed seeking the following relief. At page number 62, there is a tabular form to extract. At 62, Lanka, the court, considering the said application filed by the wife, had passed the order. Operative portion of the order reads thus: extracted from the operative portion at paragraph number 17. Land counsel appearing for the petitioner submits that petition is a third party, as on that day, along with the respondents number 2 and 3, about 25 persons have gone to the said resort. Now, by filing this application, the respondent number 1 is seeking the details of the all other parties, which is irrelevant for consideration of the dispute between the first and the second respondent. It is submitted that this order is nothing but violating the right to privacy of the petitioner. He had relied on the judgment of the Delhi High Court in case of Sachin Arora versus Manju Arora, reported in 2023 SSC Online Delhi 2692.
And even Vishwas Shetty, my lord, because Vishwas Shetty is.
Please pass on that. He relied on the judgment of an order passed by this court in Vishwas Shetty versus Preeti K. Rao, reported in 2022 SEC Online Karnataka 1597, where a coordinate bench of this court
Or paragraph 11 and 13, my lord.
he relied on paragraph number 11 and
13.
11 and 13.
Well, what may also produce para 10. 10 is relevant. Husband sought records of the paramour without making any allegation of adultery against the wife, nor filing any proceeding against the wife.
10, 11, 12, and 13 extract. Basing on this, land counsel submits that the court ought not to have passed such an order, where by virtue of this order, all the details pertaining to the 25 persons who have gone to the who were there in the resort will be placed before the court. It is further submitted that in the order it is stated that where in the CCTV footage, if the third party's faces shall be blurred, but when it comes to the operative portion of the order, no such thing is mentioned. He draws attention of the court to paragraph number 18 of the petition. Where is that?
My lord, with regard to the other bookings, my lord, my lords may kindly come to page 37, para 19, my lord.
Page 37. He submits that In the petition itself, they have stated about that respondent 2 and 3 have gone to Pune. Is it so?
Bombay and Pune.
Bombay
They
and
say
Pune.
Bombay and Pune, these are,
Bombay and Pune, but they have not sought for those details.
it was sought for in IN number 7, not pressed, my lord. IN number 7, they sought for
Though
it.
they have filed an IA number 7, but they have not pressed for the same.
Clarification, Lord. We have sought for the hotel check-in details so far as item number 7 is concerned. But for CCTV footage, because it's beyond 30 days, we have said those CCTV will not be available.
They have filed an IA number 7, seeking the details of the booking and others, but the CCTV footage they have not sought. Correct?
Because beyond time.
Is submitted.
Yes.
CCTV footage was not sought. It is submitted that only with an intention to blackmail the third parties and to see that the dispute is settled between the parties. Such an application is filed. It is submitted that the similar matters are pending before the Honorable Apex Court, whether such an information can be given to the can such a CCTV footage can be sought for by the parties where the information pertaining to the third parties is pending. It is submitted that.
My lord, that is with regard to the parties itself. Whether CCTV footage can be summoned or not is what was. It is not with regard to third parties.
The CCTV footage can be summoned or not is pending consultation before the Honorable Apex Court, and it is submitted that the order impugned needs to be set aside. Next paragraph. Land counsel appearing for the respondent number 1 wife submits that the counsel who is appearing before this court is also representing the second respondent husband. Now the present writ petition is filed by him on behalf of a friend of the husband who is the third party to the proceedings. It is submitted that this clearly demonstrates the collusion between the parties. The husband, as a husband, do not want the CCTV footage to be on record. Hence, they set up the petitioner to file the present writ petition. It is further submitted that unless and until all these records are before the court, it would be difficult for the wife to establish that husband is living in a adulterous life. The family court has already clarified that the images of the other persons who are there in the CCTV footage will be blurred, and hence no prejudice would be caused to the petitioner. It is submitted that there are no merits in the petition, and the same needs to be the writ petition needs to be dismissed. Next paragraph. Having heard the counsels on either side, there is the material.
With the Lordship's permission, just one last submission I want to make. I've also challenged the locus of the petition. Otherwise, my lord, tomorrow there'll be a Pandora's box that's going to be opened. All proxy petitions will come before the court.
The land counsel, the respondent for this submits that the petitioner has no locus to file this petition, and if these kind of petitions are allowed, there would not be. It gives rise to these kind of multiplicity of litigations by parties who have nothing to do with the matrimonial dispute that is pending and to be adjudicated by the court. Expert. Having other counsels on either side, there is a material on record. The petitioner is a third party. According to the petitioner, if the CCTV footage and whatever all the reliefs that are sought in this writ petition, in the IA number 6 filed by the wife are placed on record, it amounts to violating the right to privacy. According to him, there are 25 other people. Altogether, 25 people have went to the resort. Now,
and the room of the respondent number 2.
And to the room of the respondent number 2. And if all these details are disclosed, it would it violates the privacy of the petitioner, and in fact, and the petitioner only with an intention to settle her disputes with the second respondent has come up with this application. This court has perused the order that's passed by the court. When there are disputes between when MC is filed on the ground of adultery, the burden lies on the wife to prove. And these kind of evidence is very much required for the wife to prove the allegations. The husband is not agreed by the order passed by the family court. And very interestingly, an advocate who is appearing for the husband in other proceedings comes before this court saying that he is a third party and a friend of the husband, and he is aggrieved by the order impugned. In one way, this court cannot rule out the collusion between the parties. Then coming to the affecting the right to privacy of a third party is concerned. In the order, the court made it clear at every, in the operative portion about only the information pertaining to the second and the third respondent. Considering the apprehension of the third party, though the order is very much clear, this court is clarifying the same as per the following order. 1. The information, the entire information, there is a operative portion, page number.
30 and 30.
The accommodation, as far as in the operative portion 1 and 2, both 1 and 2 shall be pertaining to respondents number 1 and 2.
Or 2 and 3 there.
I mean, it shall be between the husband and the paramour. Next, guest registration.
Alleged
My
alleged
friend is
paramour.
not holding brief for the husband.
Irrespective, it is still
Alleged
something which is
paramour.
disputed.
Yes,
I
yes.
can say is not.
Yes, guest registration forms, visitor entry, logs and copies of identification proofs submitted at the time of check-in during such stay pertaining to, that's already clarified. We do not require any clarification.
May I just here? I'll just point out what the issue is. Visitor entry logs and copies of identification proofs and so on. So during visitor entry logs can be anybody who's visited those rooms. That is why I'm
Pertaining
saying
to where
only that visitor
the,
entry
where
logs.
the name of the respondent number 1 and the husband, wherever the husband or the paramour of the husband name found, that shall be placed. Then 4, CCTV footage for the period from 3/10/2025 to 5/10/2025, covering the common areas of the premises, including but not limited to the corridors, lobbies, and other areas in the vicinity of the room allotted to respondent number 1 and 2 during their stay. It is clarified that in this CCTV footage, other than the husband and the alleged paramour, the faces of all other third parties shall be blurred. Accordingly, the writ petition is disposed of.
May I just request one with regard to collusion may not be written.
But that has to be. It has to be
Because
recorded.
I'm being as frank as possible to say this because I'm only agreed with that one portion. That is why
No, that clearly shows that
I'm not shying away from the fact that I'm representing.
I said that I have not completely said. It cannot be ruled out as it is submitted by.
That may be a little better because otherwise it may not really endure to my benefit anywhere.
The papers, how did he become aware of the order? Only
I've specifically mentioned also saying that respondent number 2 informed me of the same. I've specifically said that I'm not shying away from it. My lords, within only that one.
We'll see.
That one part on the
While
collusion.
correcting the order, I would like to frame it in such a way.
I would please grateful, my lord.
Tamim Fiaz, for petitioner. Vignesh Shetty.
May I please your ladyship?
Yes. What are your instructions, Mr.
Yes, I have. Lord, what had happened, my lord, I will take notice only on behalf of my lord respondent 4, that's Canara Bank, my lord, Ernakulam. Wherein, my lord, I am on mainly on my lord territorial jurisdiction. The loan sanctioned, my lord, in the Ernakulam. The sale note is issued from my lord Ernakulam area. The property situated at my lord Ernakulam. All the parties situated, my lord, residing at my lord Ernakulam, not in Bangalore. Therefore, my lord, there is, my lord, this
Why it is filed here then?
Please see, they can't file it here. That is my lord on the first and foremost submission before this. So either they have to go before the lord. Their assigned my lord sale notice issued by the Canara Bank ARM Ernakulam. At the most, my lord, they have to go before the DRT Ernakulam or my lord High Court at Kerala. Therefore, my lord, on first and foremost, my lord, they have to clarify the my lord territorial jurisdiction. Apart from that, there are so many other defendants in respect of sale notice, my lord, which I issued, my lord, to raise the sale. Report, my lord, my lord.
No, as far as the interim order is concerned, no, first submission I understand. You are saying with regard to the jurisdiction.
Please, ma'am.
The second submission with regard to the, whoever has issued this, now the interim order, if they are seeking the stay of the sale notice. So as far as that is concerned, only that's an interim order. So
order
other
is-
respondents we will see. So now on the maintainability of this writ petition before this court, let him argue.
Please, ma'am.
Yes, Mr. Counsel.
Yeah, my lord.
Take one more.
They,
In a similar
let my friend complete. I don't want to interrupt him. Once my friend has completed, I will
similar-
answer.
very same council, my lord, earlier filed in a similar writ petition before this honorable court. The very same contention because Canara Bank head office in Bangalore, therefore, my lord, I am before this honorable court. This honorable court, my lord, not shown any intelligence, then later they withdrew it. And my lord, that order also, my lord, I am permitted to my lord produce before this honorable court.
Yes, give that.
That's not a detailed order. They withdrew the petition in a similar set of facts. In that case, my lord, Chennai was obviously, my lord, DRT or High Court Chennai. But I'll just point out, my lord, the last paragraph, page number 4. The learned counsel, after arguing the matter for some time, seeks leave of this court, withdraw the petition, reserving liberty to the petitioner to approach the High Court of Tamil Nadu, because that is ARM Chennai. The submission placed on record, the petition according dismissed is withdrawn, the reserving the liberty to the petition sought for. I just point out, my lord, there, my lord, page number 2, Asset Recovery Management Branch, Coimbatore, and my lord, respond number 1 is board directors of Canara Bank here. In here also, my lord, similar in nature.
Yes.
Yes, my lord. It's a first fundamental principle of law that choice of forum is that of the plaintiff. The plaintiff is the dominus litis. He is the master of the proceedings. He is the carrier thereof. The choice it is, Supreme Court has said it, Ganga Bhai, forget about Supreme Court decision, fundamental principle of universal application. Choice of forum is that of the plaintiff, he being the dominus litis. And then when for the plaintiff being a dominant litis, in determining the choice of forum, he is not entirely free. He has to, there are other principles which are applicable, which concerning the determination of the choice of forum. That the principles are lex situs, if it is respect of a property, lex situs, where the property is situated. Lex res, that is where the respondent reside. Lex causae, where the cause of action has arisen. And in a given case, the cause of action may be in one place, the property may be in another place, and the respondent may reside in at another place. And then between the three concepts, lex res, lex causae, lex situs, the plaintiff as the dominus litis is free to elect any of the forums. Now, when it comes to Article 226 of the Constitution, there is a difference. Article 226 of the Constitution, may I take your ladyship may have Article 226?
Yes.
Article 226, yes.
Yes.
Article 2, may I read, my lord, ladyship, the Article 226. Notwithstanding, your ladyship got it?
Yes.
Article 226.
Yes.
Notwithstanding anything in Article 32.
Yes.
Every High Court shall have powers. Every High Court shall have powers throughout the territories in relation to which it exercises jurisdiction. Towards the territories in relation to which it exercises jurisdiction. To issue to any person or authority, including in appropriate cases any government within those territorial territories, directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them, for the enforcement of any of the rights conferred by party and for any other purpose. The first respondent in this petition is the board of directors of the Canara Bank. I have consciously made the board of directors of the Canara Bank as a party to the petition because by virtue of the notification dated 29/5/2015, may take your leadership to page 94. Page 94 of the paper book. The responsibility for the constitution of committees, which is contemplated under the in terms of the notification, may take your leadership to paragraph para 2, page 95. Committees for stress micro, leadership got it, page 95.
Yes.
Committees for stress micro, small and medium enterprises. Subject to any regulation prescribed by the Reserve Bank of India for this framework, all banks shall constitute one or more committees
No,
at such
you are arguing on the
locations.
merits of the matter. You are
No,
arguing
I'm
on the
only on
merits of the
the
matter of the jurisdiction.
I'm only on the jurisdiction aspect now. My friend raised a question of jurisdiction. My friend said that yes, only on the she said my friend said that it is the reputation is not maintainable for want of territorial jurisdiction. Subject to the regulation prescribed by the Reserve Bank of India for this framework, all banks shall constitute one or more committees at such locations as may be considered necessary by the board of directors of such bank to provide reasonable access to all eligible micro, small and medium enterprises which have availed of credit facility from such bank. So here the mandate the notification is addressed to the board of directors of such bank. My grievance is the Canara Bank, the board of directors of the Canara Bank failed to discharge its statutory duty. Not a single committee was constituted. Forget about my case. Not a single committee was constituted from 2029/5/2015 till the judgment in the Pronis case and thereafter in the case of Sri Sami Samar. That I get that is an admitted fact. And the Canara Bank said the same thing in a judgment of the Madras High Court at page leadership. I take your leadership to page it's page 450. May I take your leadership to page 416? That is a judgment of the Madras High Court, Madurai bench. Leadership got it. A.K. Karthikeyan. Your leadership got it.
What is the
A.K.
page
Karthikeyan
number?
at page 416.
No, I think this entire petition, the pages are till 253.
Volume 2 is there.
Another volume is there.
I'm so sorry. Maybe it has been divided into 2 volumes.
Next volume.
Yeah.
Third. 416.
Yes.
Page 416. This is the judgment of the Madras High Court, Madurai bench. A.K. Karthikeyan versus authorized officer Canara Bank. And may take your leadership to page number 432.
Yes.
Paragraph 11.
Yes.
In fact, the leadership got it. In fact, when a specific question was raised by the bench, whether the Canara Bank has formed any committee which is mandated under clause 2 of the framework for revival and rehabilitation of micro, small and medium enterprise dated 29/5/2015, it was submitted that no such committee was formed. This is my case only. Yes. Some other lawyer appeared because of my difficulty to travel to Madras. So to Madurai. It was submitted that no such committee was formed. Then coming again, my lord, at leadership at page 443, 433 at page paragraph 12. Further, in the above clause 2, subclause 2, it is specifically stated that distressed micro, small and medium enterprise shall have access to the committee. When no such committee was formed, then the stressed MSMEs like that of the petitioners were deprived of any such opportunity to approach the committee. The bank is contending that the petitioner has not raised the issue of the benefits under the MSME scheme at the earliest point of time. When there is no committee, not a single committee has ever formed, not only Canara Bank, for that matter, not a single bank or financial institution in this country has ever constituted a committee. When there is no committee, then such plea of the bank cannot be entertained. And my lord, that petition was allowed. Directly, I take your leadership to paragraph 23 at page 443. For the reasons stated above, your leadership got it, page 443. Yes, para 23. 23. For the reasons stated above, status supra, this court is of the considered opinion that the petition is entitled to relief. Hence, the writ petitions are allowed accordingly, and the sale notices are set aside. Respondent bank is directed to formulate the revival and rehabilitation scheme of the petitioners unit under the notification dated 2015 and as revised from time to time, and the same shall be carried out as per the notification dated notification of 2015 and revised from time to time. Leadership, let me talk out of record for this notification since 2000, because I had a small role to play in the formulation of this notification. Because I was representing some of the MSMEs. This notification was never given effect to. And initially when matters were taken up, then all those cases were all settled because the bank came forward and offered some OTS proposals. And then I also left the practice in the area of surfacing, etc. I started practicing mostly in Supreme Court. Thereafter, again, my lord, in 2019, I was banned from practicing the Supreme Court for 1 year for raising the issue of the Kitangin practicing in the same court. It was a issue of Justice Farid Nariman practicing before this the Court of Justice in the Supreme Court. Then I had to come back to Bombay. And then I started again taking up the issue of the MSMEs. That is the background. So in this country, in all humility, it should not be taken as I am praising my own page. I am the only lawyer who took up the issue of the MSMEs. And it is a matter of conviction, personal conviction, that this is the notification is the order of the parliament, reflecting the will of the people. And as a result of a consultative process which spanned over almost a decade from 2006 to 2015, where the Ministry of MSME, the Ministry of Finance, sorry, the Ministry of Banking, Department of Banking, the Indian Bankers Association, State Bank in particular, all MSMEs association, all were involved with the process of resolution of distress. This is intended to help MSMEs so that they don't perish. It is no way against the bank's interest. And the committee constituted, this committee constituted is actually a committee by entirely at the hands of the bank. Out of the 4 members, 2 members are from the bank itself. 1 member, the subject expert, is nominated by the bank. And only an outside agency is represented representative from the. Yes, coming back. Yes, I'll come back. Yes, sorry, I deviated. Sorry, my apology. Now the whole issue here is who was at fault. This repetition is founded on the premise that no committee was constituted. And the burden, the responsibility to constitute a committee is not on the branch manager. The notification mandates, I'm sorry, I'm again reading that paragraph, that the board of directors of such bank to provide, page 95. The board of directors of such banks to provide reasonable access to all eligible micros, etc. So the responsibility to constitute a committee, which is of a judicial tribunal, sans any of the trappings of a court, is of the board of directors of the banks and financial institutions. and not a single committee was ever constituted. And the board of directors is at fault. The managing director is at fault. So the resolution has to come. These matters need to receive the attention of the board of directors. Tomorrow, under section 36 AA of the Reserve Bank of India, I can seek even the cancellation of the banking license to the Canada Bank, because when a statutory provision is so blatantly violated, some stringent action is contemplated. Nothing of the sort we have sought. We have sought only a protection of the notification. All these steps which have been taken in violation of notification be set aside, and the committee be constituted, take an effort for resolution of stress. If that fails, the bank can recover. SurFace come, the IBC come, all recovery proceedings are permitted. So the board is at fault. And the board of the directors of the Canara Bank is situated at Bangalore. In the earlier case, then the court said, I will protect you. Then my client said, okay, fine, they are protecting you. Then my client agreed to that. That is the reason why, okay, I didn't press it. It is when the court said, Madamara, why don't you move the Tamil Nadu, we'll grant you interim protection. And that is the reason why that was agreed to. And that is, there is no law is laid down in that 2-line paragraph, which my friend has read out. That's a different issue. What I am relying on the constitutional provision and fundamental principles of law, which are of universal application. So the difference in this difference, the Constitution Article 226 vis-a-vis the fundamental principle of law as embodied in the CPC also is. Am I audible, my ladyship?
Yes.
Am I audible?
Yes, you are audible.
Oh, all right. Because sometimes there is my videos, my computer shows that the poor connectivity. Yes. Then my ladyship, the whole issue here is Article 226. The all emphasis is on the territorial jurisdiction. So the reason is, my lord, the 226 is emanate from the concept of prerogative writs, the Chancery Court. And Chancery Court is what is Chancery Court? Where the king is symbolically present. And therefore, the king has got my lord, jurisdiction over all subjects within his territorial limits, or all subjects. So that the Article 226, the emphasis is on the law, concept where the respondent resides. Lex Reus, REUS, respondent. The Reus is respondent. Lex Reus. And then Article 226 was amended in 1963 after Ramana Rao's case, and sub-article 2 was incorporated. And then ladyship, after in sub-article 2, the concept of cause of action was incorporated. May I take a ladyship to page, Article 226.2. May I read ladyship? Article 226.2. The power conferred by Clause 1 to issue directions, orders or writs to any government, authority or person may also be exercised. So the power is to direction to any government, authority or person may also be exercised by any high court exercising jurisdiction in relation to territories within which the cause of action, wholly or in part, arises for the exercise of such power, notwithstanding that the seat of such government or authority or residence of such person is not within those territories. Now, my lord, earlier, my lord, but for 226.2, no writ will lie before the Kerala High Court, because the board of directors are situated beyond the territorial limits of the Kerala High Court. So therefore, the concept of cause of action. So the cause of action is a bundle, my lord, of facts, which would, my lord, the violation thereof will lead to certain rise. So the cause of action, the bundle of facts of the core of if they say bundle of sticks, the core stick is within the territorial limits of this court also. Cause of action is also as arising within the territorial limits. So cause of action is not a determinative factor. And it only says in addition to the consideration of the residence of the respondent, if the cause of action, if the cause of action also can also be taken into account. And Article 226 is then in that sense different from my lord, section 16 to 20 of the CPC. May take your leadership to the CPC. Section 16. Can you give section 16 CPC? Yes. Yes. 1 second, leadership. Section 16. Yes. Section 16. Suit to be instituted where the subject matter situate. That is, my lord, the leadership will concept or less sitters. I'm not reading to, my lord, not to tax your leadership's time. Then suits of immoral property situated within the jurisdiction of different courts, any of the courts. Then, so section 18, place of institution of suit where the local limits of jurisdiction of the courts are uncertain. And section 19, suits for compensation of wrong to persons or movables. There the concept of lex res, whether residence is. Then other suits to be instituted where the defendant reside or cause of action as arisen. So therefore, these three, all the three concepts, lex res, lex cause, lex situs, stand embodied in section 16 to 20 of the CPC. And the Article 226 takes a slight difference, and the reason being, the 226 is nothing but reincorporation of the concept of chancery jurisdiction, prerogative, King's Court. And therefore, in my humble opinion, my lord, the paramount factor, determinative factor, where the respondent reside, and the board of directors, which has been tasked with the job of constitution of a committee, that's the core. Which since no committee was constituted, others failed. So the principal default is on the part of the board of directors. So leadership subject to what my friend has to say, and then in all my petitions I have arrayed the Attorney General as a party. With my life I am doing for the first time. I am in the bar for 43 years. I am doing for the first time because this is an issue which is of such a paramount importance, and judgments came to be passed contrary to the express provisions of a benevolent legislation, and without battle lines are drawn, swords are crossed, without hearing the affected parties. And why I say is, there are many of the judgments were, to use a very soft language, it is so weird. For instance, I have produced along with my petition.
If your submissions on jurisdiction are completed, so that I'll pass an order.
Leadership, yes, then what I didn't complete it. I have to say 2 or 3 sentences more. I was on that.
On jurisdiction.
That why only on jurisdiction aspect only, because on this issue, the Attorney General need to be heard. Attorney General, the reason is, the other day, the additional Solicitor General said Attorney General cannot be made a party. In fact, look at the English jurisprudence. All cases are Attorney General, all cases of public importance.
Regard, if I may submit, my lords.
No, let me complete. Madam,
Because
let me
Attorney
complete
General is
it.
a party.
No, let me complete it. After that, you can reply. See, if I am online, if you interrupt me, then I will not be able to complete my argument. Let me complete it.
It is
The court
pertaining to
decided.
the Attorney General only.
Yes, let me answer it. The court may decide against me. I'm almost. I have my job is to present my case. Court decide. Whatever is the decision, we accept it. There's absolutely no problem. I would say I never expect any order in my favor. Out of record, I say. I have absolutely no problem. Let the court decide against me. Let me just say wanted to say. That's all. There's a misconception. The Attorney General was a custodian of public interest in all quiet proceedings, and in all anything involving public interest, only Attorney General could move the court. And therefore, you will find in the English law, Attorney General versus so and so, any number of judgments. And you will find so and so versus Attorney General. I will, for any of the English books, for instance, Evereston Estoppel, Kasparov Estoppel, all the index, the citation index will show there were so many cases. Attorney General versus so and so. So and so versus Attorney General. So Attorney General is a necessary party, even where any substantial question of law is involved, even assuming that nowhere the state is involved. For instance, a disciplinary proceedings against a lawyer. That was a specific case. I don't exactly recollect the citation. The judgment was passed. Then Attorney General impleaded. Attorney General actually filed an appeal saying that the issue concerning the disciplinary actions on an advocate is a matter concerning public interest on a substantial question of law. Therefore, Attorney General has a right to be heard. Attorney General filed an appeal. So, Attorney General is the sole repository of public interest. And in any question involving interpretation of a statutory instrument or involving any question of any substantial question of law, Attorney General is required to be heard. And in addition to here, in this case, Attorney General, the Union of India is a party, the Ministry of MSME is a party, and therefore Attorney General is a necessary party. Yeah, there are two ways to do it. In every petition, that we follow the system from CPC Order 27 A of the CPC. May take your leadership to Order 27A of the CPC. 27A of the CPC. 27A of the leadership. Yes.
We are not,
So,
we have not
take
gone to
leadership.
that stage now. We are not on the merits of the matter. We are on the jurisdiction.
No.
For that, it is not
I am only I am only on the issue of Attorney General. Only on the issue
So
of
that is
only
not,
on the
that is
issue
not
of the.
relevant. That is not, I'm not going to adjudicate on that now. If
No,
your arguments on this are
my
over,
only, I only say very briefly. All that I wanted to say is here the territorial jurisdiction aspect, whether the reputation is bad, non-maintainable, because the property is situated in Kerala or the branch is situated in Kerala. That is an issue involving substantial question of law involving interpretation of Article 226 and particularly Article 226 1 and 2. Therefore, Attorney General is also required to be heard. And I take your leadership to Order 27A of the CPC. 27A of the CPC. Yes, in my new books it's only 27A shown. 27A. Yes. Suits by yes. Yes, 27A. Sorry. Suits involving 27A is 27A. Suits involving substantial question of law as to interpretation of the Constitution. Your leadership has CPC.
yes, yes.
Yes, chapter 27A.
Yes.
Suits involving a substantial question of law as to the interpretation of the Constitution. And before that leadership, it was the Government of India Act. Or as to the validity of any statutory instrument. Notice the Attorney General or the Advocate General in any suit in which it appears to the court that any such question as is referred to in clause 1 of Article 132 read with Article 147 of the Constitution is involved, the court shall not proceed to determine the question until notice has been given to the Attorney General of India. If the question of law concerns the central government and to the state government and the Advocate General of the state, if the question of law concerns to the state government. And then, my Lord, 1A, procedure in suits involving validity of any statutory instrument. In any government in which it appears to the court that any question is as to the validity of any statutory instrument, not being a question of nature mentioned in Rule 1 is involved. The court shall not proceed to determine that question except after giving notice to the government pleader, if the question concerns the government, or to any authority which issued the statutory instrument. If the question concerns authority than the concern an authority other than the government. So this section says shall not proceed to determine that question. So notice is mandatory. So I have made the Attorney General as a party. Notice can be issued if it can be deleted from the party and I have no problem. But notice has to be issued to the Attorney General.
Yes,
Even
please
on the
come.
question as to the determination. And why I say so, I am repeating the leadership. I never done it. In my more than 43 years of practice, I have never done it. This is the first time I am doing it. Make Attorney General a party to proceed.
The
Because this
present
is an
petition is
issue.
Yes. The present petition is
Can I,
filed seeking the following release. Extract the release from page number 53 to 58. The interim relief that is sought as follows. Extract the interim relief. The brief facts of the case are
Page 65 is sanction letter. Page 65 is a sanction letter which loan granted in my lord Ernakulam.
the petitioner is a proprietor of Mrs. Genuine Agro Spices, a sole proprietorship engaged in the trading of agriculture produce, within bracket spices, including export thereof, established in 2011 and having ODM registration certificate number ODM KL 02 0003 223, issued by the Ministry of Micro, Small and Medium Enterprises, Government of India. The company, the petitioner company is situated at Pazamaktam Pivo, Pulinchod, Ernakulam, Kerala. It is stated that the respondent number 1 to 3 sanctioned a working capital of rupees 1200 lakhs under the sanctioned memorandum dated 28/2022. The respondent number 1 is the Board of Directors, Canara Bank, situated at Bangalore. Respondent number 2 is the Canara Bank, represented by its Chairman and Managing Director, JC Road, Bangalore. And respondent number 3 is the Authorized Officer and Chief Manager, Canara Bank, Panampalli Branch, first floor, Anji Parambi Complex, Panampilya Nagar, near South Overbridge, Ernakulam. And they were fully secured by the collateral securities. That is A to F as A to G as stated in paragraph number 4 of the petition, which are situated at Ernakulam district. And it is also stated that the respondent number 4 to 5 sanctioned credit facilities of rupees 36.5 lakhs and rupees 5 crores under the sanction letter dated 10/2/2022. For the said loan facilities, the collateral securities are stated at paragraph number 5, that is A to D, which are situated in Kerala. The respondent number 4 and 5 is The Board of Directors of City Union Bank Limited, represented by its Managing Director and Chief Executive Officer, situated at Narayana number 24B, Gandhinagar, Kumbakonam, Tamil Nadu. And the fifth respondent is Citibank of India, Gandhinagar, Kumbakonam, Tamil Nadu. And it is also stated that the respondent number 6 to 7 has also sanctioned the credit facilities of 3 crores, 6 crores, 8.35 crores, 8.35 crores and rupees 8.35 crores under facility letter dated 12/4/2021. For that, they have mortgaged the properties A to G, which are situated in Kerala. The respondent number 6 to 7 are the Board of Directors of the Standard Chartered Bank, situated at Chennai. And the 7 is Authorized Officer, Standard Chartered Bank, situated at Ernakulam. It is stated that the petitioner is a MSME registered under the MSMED Act 2006. Section 9 and 10 of the said Act, read along with the notifications issued from time to time by the Government of India, provide with a framework for the promotion, facilitation, development, and the protection of the business of the MSMEs. The Reserve Bank of India in exercise of its powers under the Banking Regulation Act 1949 and being the regulator of banks in the country, issued notification dated 17/3/2016 giving directions to all banks in India to implement the Government of India MSME notification dated 29/5/2025, albeit by watering it down. Hence, they are seeking, questioning challenging the provisions of the RBI notification that water down or restrict the provisions of the MSME notification dated 17/3/2026. In the writ petition, it is stated that the petitioner is constrained to invoke the jurisdiction of this court under Article 226 of the Constitution of India due to extraordinary circumstances. It is stated that in the present case, not only the High Court, but even the Supreme Court, instead of coming to the rescue of MSMEs, which are the backbone of India's economy, providing 60% of employment, 35% of GDP, and 45% of the exports, have given an interpretation to the notification dated 29/5/2015, which is contrary to the letter and spirit of the letter and spirit. It is stated that, and the petitioner has relied on several judgments and states that allowing the account to be declared as NPA and lost the challenge to recovery actions is contrary to the statutes and renders per incurium, and the interpretation needs to be reversed so that the justice can be done to the MSMPs. It is stated that when it comes to the cause of action, it is stated that the respondent number 2 and number 3 authorized officer arbitrarily declared the loan account of the petitioner as NPA on 27/6/2025 and issued the demand notice under section 13(2) of the Surface Act on 1/7/2025 to the petitioner proprietorship seeking repayment of an amount of rupees 12, 50, 60, 266 01. And then the third respondent bank issued the possession notice dated 10/9/2025 under section 13(4) of the Act, taking the symbolic possession of the mortgaged properties. Further, respondent number 4 has issued a show cause notice dated 13/10/2025 directing the petitioner to show cause against classifying the first petition, the classifying the petitioner as fraud, plaintiff's PAN card as fraudulent based on the internal audit report of the on the petitioner's functioning dated it is stated that when the several judgments are discussed in the had stated so in the petition. The cause of action arises when the respondent 3 bank declared the loan account of the petitioner as NPA and issued the demand notice dated 1/7/2025 and further issued the possession notice and auction notices by the respondent banks. Questioning now the petition is filed. The cause of action for the petitioner to come before this court is the action of the respondent number 3 bank, that is, which is situated at Ernakulam. When the matter came up for hearing, learned counsel appearing for the petitioner, the respondent Canara Bank, respondent number
3, 1 to 3, but I am appearing on behalf of 3 now. I have instruction on behalf of
respondent number 3, Canara Bank, submits that the writ petition is not maintainable before this court, as the petitioner is questioning the action of the bank in declaring the account of the petitioner as NPA and issuing the demand notice under 13(2) and also a possession notice under section 13(4). It is submitted that the petition, the properties that are mortgaged to the bank are situated at Ernakulam. Loan was obtained at Ernakulam. And as the bank, the head office of the bank is situated at Bangalore, cannot be a cause of action for the petitioner to approach this court. And it is submitted that the petition has to be dismissed as not maintainable. Land counsel appearing for the petitioner submits that the writ petition is very much maintainable before this court. There are different cause of actions for the petitioner, and the petitioner, being the dominant litigant, can file the petition before the forum, which he chooses to do so. And there is no bar under Article 226 of the Constitution of India in filing the writ petition before this court. The learned counsel has referred to section 16 to 20 of the CPC and order 27 16 to 20 of the CPC and submits that there are different cause of actions in this case. But though the bank is situated, which has issued the loan is at
Leadership, minor correction, leadership. What I said is the focus Article 226 is based on the territorial jurisdiction. The respondent, the head office of the board of directors of the Canara Bank and the chief executive of the Canara Bank. Let me say one second. Only one. They reside in Bangalore within the territorial limits of this court. So Article 226 is territorial determined by territorial jurisdiction. So I am within the territorial limit. The Bank of Directors is before the territorial limits of this court. Therefore, the petition is maintainable.
Maintainable before this court. He has also submitted how the Attorney General is a proper and necessary party to this writ petition, as is questioning the the judgments of the apex court and also the procedure in which the borrower, MSME borrower has been declared as the account of an MSME borrower is declared as an MSME.
Ladyship, one word of interruption. What I'm seeking that the judgments of the Supreme Court in Pronet and Sri Samasamat are under per incuriam and subsidentio. Therefore, it's a issue where the
A vital aspect of a question of law that is involved, the presence of the Attorney General is very much necessary. As such, he has made the Attorney General as a party respondent to this writ petition. It is submitted that he has relied on the judgment of the Madras High Court, where before the Madras High Court, the Canara Bank has stated that they have not constituted a committee as per the guidelines of the Reserve Bank and as per the provisions of the MSME Act. It is submitted that as this involves a question of law and the particular fact that there is non-compliance of the directions of the Reserve Bank and also the provisions of the MSME Act and the bank head office is situated within the territorial jurisdiction of this court in Bangalore. The writ petition as filed by the petitioner is very much maintainable. Next part. Having heard the learned counsel for the petitioner and the learned counsel appearing for the first respondent bank,
third
respondent bank this bank peruse the entire material on record. The undisputed facts in this case are petitioner had borrowed the loan from the third respondent bank, fifth respondent bank, and also the seventh respondent bank. And he has mortgaged the properties that are situated within the jurisdiction that are situated within the state of Kerala. The petitioner has raised several grounds with regard to the MSMEs and also the judgments of the Honorable Apex Court and how the the provisions and other judgments. The relief that he is seeking is that the proceedings that are initiated by the bank under Section 13.2, under Section 13.4 are bad, and the same have to be interfered by this court at an interim stage, and later at the stage of interim relief. The contentions with regard to that the cause of action is a bundle of fact, and it is for the petitioner to, being the dominant signatures, he can approach the forum or as far as these submissions are concerned. The petitioner has reviled the loans from the banks at Chennai, from the banks situated at Kerala, and no doubt the Canara Bank head office is situated at Bangalore. For all the practical purposes, for the execution and for all other aspects, the major cause of action, that is the sanctioning of the loan, the mortgaging the properties that are situated at Kerala. The courts at Kerala have got the jurisdiction. Coming to the Bank of Canada, Canara Bank, that is the head office situated at Bangalore, that itself cannot be a ground for this court to say that this court has got the territorial jurisdiction to entertain the petition, to entertain the writ petition before this court. The petitioner as well could have approached the bank, they could have approached the courts at Kerala and could have filed a writ petition. It is not that. If he files a petition before the Kerala High Court, that the Kerala High Court has no jurisdiction to issue notice to the Canara Bank head office, just because the Canara Bank head office is situated at Bangalore. The cause of action, the entire cause of action as stated, is as arisen to the petitioner at Kerala, but not, but it cannot be said that because the head office is situated at Bangalore, this court has got jurisdiction. Hence, this court is of the view that the writ petition is not maintainable before this court and accordingly dismissed, giving liberty to the petitioner to prevail the appropriate remedy. Yes, next.
Cell number 14.
One way, the leadership may stay the surface action enable me to either file an appeal or to approach the Kerala High Court.
No. Yes.
The leadership may record my submission and pass an order
Yes,
rejecting also no problem.
While this court is dismissing the writ petition, land counsel for the petitioner makes a submission that this court may stall the proceedings for a limited period, giving an opportunity to the petitioner to avail the appropriate remedy. This court is not inclined to pass an order when this court is of the prima facie view that this court has no jurisdiction to entertain the petition. Question of passing any interim order will not arise. Yes, next.
14.
Apologies, my lordship.
Chikayu.
There are multiple objections due to urgency. I would move the matter, my lord. Lords, there is one auction notice scheduled in the next.
Why you can't comply with the objections? As many as 17 objections, and why should we?
It's a voluminous petition, my lordship. I filed it on the Friday, my lords. This is a clear case of no default, my lords. It is a misuse of the sections under the Surface Act that the bank has.
Is the bank?
Canara Bank.
Yes, Mr. Vignesh Shetty. Where is he?
Notice may be served to the counsel who appears in consumer matter, my lords.
Not necessary. Counsel is here. Give him the papers. Let him get instruction. Pass over.
Cell number 15. Hearing on employment applications. Ajay Prabhu for appellant.
Lord, A number 2 may be heard along with main matter, Lord. Lord, this is a appeal over Lord ECA award. Lord, main point of
What is to the respondents? Yes,
Number 16.
Lord, I sought for stay. Lord.
Who are you?
I'm for employer. Lord. I'm the employer.
On what ground you are before the
Lord, the employee has not established the fact that he is the employee of the.
Have you contested the matter?
Lord?
Have you contested the matter?
Yes, Lord. I have contested the matter. We have taken specific ground that he is not my employee.
The case of death.
Lord?
It's a case of death.
No, my lord. It is injury.
Let's see. Let's see the order.
Please. Even my lord, substantial question of law is that.
Let's see where is that issue with regard to the employer-employee relationship.
Please, my lord, para number 12, my lord. Page number 16.
Read.
PW1 has produced a spot merger which is marked as Exhibit P4. As per Exhibit P4 on 30/12/2018, the merger has been conducted. It is in a criminal case, my lord. It is yet to be adjudicated. Conducted Bhishma Metal Works factory for the incident dated 22/11/2018. So it clearly goes to show that the.
What is the other evidence placed by him
Nothing,
to show
Lord.
that he is working?
Nothing. He has not produced any documents, my lord.
What is your contention recorded?
My lord, it is not. My lord, it is totally ignored.
Have you filed your objections?
Yes, my lord.
Then counsel for the petitioner submits that the respondent has failed to establish the relationship of the employer and employee without
And my lord, the Bhishma Metal in which he is thought to be worker, it is not industry at all.
It is submitted that has failed to establish the relationship And Bhishma Metal Works is not an industry at all, but without considering all this, just on the ground that the criminal case was registered, court has granted the compensation. Yes, there shall be stay of all further proceedings.
Till number 16.
We already deposited the amount.
Find in this case, my lordship.
Antramasi.
This case of injury, my lordship.
Anantaram, yes. You are for the?
Appellant, my lordship. Case of injury, the respondent also.
Yes, notice to the respondent.
Respondent also filed an appeal, my lordship, connected.
List
Same
along
cause of
with, notice to the respondent, list along with so and so.
Till number 17.
Registry is directed to call for the records. Yes, 17.
13. Anup Sitaram Rao. 17. Anup Sitaram Rao.
The appeal is filed by the insurance company challenging the liability matter. The accident is of the year 2023, subsequent to the commencement of the new act. The driver did not have a driving license. The liability is
They
fastened.
submitted that the accident had taken place after the amendment to the act, and the driver of the vehicle is not having a valid driving license, and the principle of pay and recover will not apply. But still, the court had fastened the liability on the insurance company. There shall be stay of all further proceedings 50%. 4 weeks notice to the respondent.
Till number 18.
Notice to respondent number 1.
Notice to R1 is dispensed with. Notice to the other respondent.
Lord,
Yes,
R2, my lord, Oriental Insurance.
we'll see. Notice to the other respondent.
Please.
Till number 19.
Appear for appellant, my lord. CH-20 also filed appeal, my lord. In connected
With so and so.
In connected case, I filed the application for releasing of amount, my lord. Kindly give date.
In this matter, notice to the list this matter along with so and so next week someday.
Please, please, ma'am.
Next.
18.
Yes, 20.
Till number 20.
My lord, in this case, I appear for the appellant, my lord.
Notice to the respondent. Next,
Till number
21.
21.
Much
Notice
obliged.
22.
In this also, I appear for appellant, my lord.
21 notice to R1.
R1.
Memo is filed seeking dispensation of notice to R1 dispense with notice to the other respondent. 22.
22.
I appear for appellant, my lord.
Notice.
Kindly notice my appeal issue.
Yes,
Much obliged, my
23.
Number 23.
Notice.
Tejas.
Notice.
Till number 24.
Yes.
Appeal by the insurance company challenging quantum and negligence, my lord. 26 lakhs change is awarded.
Case of death.
Case of death. We'll deposit 20 lakhs, my lord. 20 lakhs with
Land
interest.
counsel for the appellant insurance company submits
Filing
the
memo for dispensation of notice to R5.
memo for dispensation of notice to R5 dispensed with. The land counsel in IA number 1 of 25. Land counsel for the appellant submits that the insurance company has awarded an amount of rupees 26 lakhs.
26 lakhs.
26 lakhs as compensation. It is submitted that the compensation that is awarded is on the higher side, and there is a negligence on the part of the deceased. All these aspects were not considered. Hence, there shall be stay of all further proceedings, 20 lakhs, 4 weeks. On such deposit, they are entitled to withdraw.
Obliged.
Till number
Notice to the respondent.
Yes.
Yes,
Till number
25.
25. Shripad V. Shastri.
In 25, memo is already filed seeking dispensation of notice to R1 dispensed with notice to the respondents. Yes, next.
HDFC, my lord, HDFC, my lord, one
We'll see, we'll see.
submission.
Yes, next.
26. Samir
HDFC,
Hassan.
my lord, HDFC, any advocate?
Yes, RPFC. Next matter, 26.
Samir Hassan.
No representation. List this matter after the vacation. Yes, 27.
Till number 27.
My lord.
Lata
On the last date of
Shastri.
hearing, this court has directed the petitioner to approach the bank, my lord, with its proposal. The petitioner has approached, my lord, in the said proceedings. They have told us the due amount is 137 lakhs, my lord. The only thing what we are seeking is that, my lord, the ground on which this particular amount is brought on record, my lord. We are just seeking the documents from the bank.
That is between you and the bank. Why should we entertain all this? Give it to me. The outstanding liability in the said account is, there is 1 crore 37. 1 crore 37 lakhs in view of the ongoing writ petition and as per direction of the Honorable High Court
Honorable Court
to
directed.
submit an OTS offer so that the account may be settled amicably.
Yes, my lord. The only thing is that we are seeking is that on
Now
grounds.
see, how they have arrived at a conclusion, it is not for this court to decide. And neither you can say, because they have, as per the, whatever, this thing they will do. If you have any complaints against OTS scheme, it is for them to decide, isn't it? To approach the bank, we'll dispose of this.
My lord, kindly have it for tomorrow. We'll argue the matter.
What you'll argue? What is that latest question?
Sale notice.
Huh?
Sale notice are not
Then-
challenged, my lord. My lord, kindly have it tomorrow, my lord, please.
Unnecessarily writ petitions from 2022.
No, my lord.
DRT, and what is the jurisdiction of this court to entertain this petition? Still the courts are showing indulgence, and you want this matter to be adjourned.
My lord.
List this matter, finally day after tomorrow, no further adjournments will be granted.
Interim order, my lord.
Interim order earlier granted is extended till then.
Cell number 28. 28, Nataraj T.
That's appearing for the petitioner.
For the respondent
That's
number
seeking
one.
for that's adjournment. That's senior, he's in hospital today. So any day by
List
Thursday
next
or
week-
Friday.
List next week someday.
Please. my lord.
Final date may fix, my lord.
Till
They are
12.
seeking time
They will
to,
give the date, they'll give the date, basing on the
Interim
matter.
orders may be extended.
It is submitted that the land council on record is not, well, list this matter next week, no further adjournments will be granted.
Let's
Interim
inter-
order earlier granted is extended till then.
Much obliged.
Then who moved the memo?
No.
Somebody has moved the memo.
Yes, yes.
You moved the memo.
not me.
You moved the memo and you seek the time.
Apologies.
Yes, next.
Cell number 29, Rakesh Kini.
I appear for the petitioner.
For petitioner,
For petition for the respondent number 3, my lord.
Velangani.
One and two, my lordship.
Yes.
It's time for the hearing, my lord. They have not served the copy, my lord.
Who are you?
I'm for the respondent number 3, my lord.
Who is respondent number 3?
Respondent number 3 is the one who took loan from this bank.
Sure.
I'm the petitioner. My property has been mortgaged. Admittedly, I'm not the borrower.
Then why did you mortgage the property?
I did not mortgage. According to the respondent bank itself, respondent number 3 had mortgaged the
Your
property.
property.
My property. My lordship, this entire property has been mortgaged to me bank.
Who is the owner?
Owner is the respondent 3. They both have some deal, but respondent means we are from the bank. We don't have any.
Please understand, when he has mortgaged the property, there should be a sale deed in his favor.
Please, my lord.
Is it right?
Yes, there is a Please, my sale lord, deed it is- dated 2013, in the year 2013.
Hmm.
Mortgage is dated 2019. They say they have mortgaged from respondent number 3.
What is the relationship between the third respondent and the petitioner?
Nothing, just he's a vendor, I purchased.
When did you purchase?
2013.
2013,
Yes.
you purchased.
Yes, annexure A
And
may kindly be
2019, he mortgaged the property.
alleged mortgage. If they had taken EC, my lord, or Khata, my name would be reflected. This My entire property has been mortgaged. entire property, it is there with him from 2001 onwards. From that,
Please tell
it is
the
a,
court, please tell the court, have you obtained the EC before getting this mortgage executed? A property which is sold in the year 2013, somebody mortgages. How can you say that he's owner of the property?
my lordship, entire property was mortgaged to me. There is no separate sale deed was given by him, and entire before 2001 onwards, whatever the mortgage deed, it is there.
Where is
And
your sale deed?
page number 15, my lord. And on the last date of hearing, my lord, this court, after hearing for some time, asked them to produce mortgage deed. That mortgage deed also, alleged mortgage deed also is not a registered mortgage deed. My lordship, fraud has been paid on the petitioners, my lord. So that they have not produced till date.
How can it
My
be?
lord- my lordship, they have given us MODD. They have given all the sale deed, original sale deed to me, they have given it.
Is it a registered mortgage or not?
No, it is not registered mortgage,
Not
but
required?
still we have means they have, once they give MODD, we are having a power on that. We are not transferred the rights, my lord. Rights holds the respondent 3. Between respondent 3 and respondent petitioner have done the sale deed. But before that also,
The
it was,
EC, have you filed the EC?
I have filed.
Where is the EC?
Page number 29, my lord.
I think bank affairs are something to be doubted.
Yes. My lordship, this is,
Come to page 29. What are your objections to this?
Page number 28 is a khata. Even if they have obtained khata, also my name would reflect.
Which is this bank?
Canara Bank, my lordship.
My lordship, this, they have entire.
No, now you pay, whoever has given this, no, from his pocket, let him pay this mortgage loan.
My lord,
We'll set aside this,
my lordship,
whatever that
one
has
short
happened.
adjournment. One of the documents also I am going to file it, which says that entire property has been mortgaged by respondent 3 to me. That,
How can
that is there.
Are you
before-
not understanding the court's query? A person who is not the owner as on 2019, how can he mortgage the property to you?
My lordship,
Please answer to that. Don't go to other things.
please, my lord.
Only tell the court a party who is not a owner of the property, can he mortgage the property just because he has some document?
My lordship, he has taken.
Pass over. I'm going to pass the orders in the
Lordship,
afternoon.
one submission, my lord. This
Yes.
property was mortgaged before even selling these properties. This 2001 onwards, the
Here is
loan
the
was.
mortgage.
My lordship,
Here is the mortgage.
mortgage is 2019 only. We
When
are
did he
done.
purchase the property?
He has taken in 2013, but here we are having it. Before also, the loan was continuing, my lordship. They both are partners and they have done it. And when it is submitted to us, it is continuing
I
from the
think
long time.
bank is not above law. They are also,
Please, my
what
lord,
all the
but
law you
I will
every
file
day
the-
tell the court that you are also bound by it.
Please, my lord, they have
First
given.
of all, I wanted to see that mortgage.
Please,
What
my
are the
lord.
documents that are given? What is that you have done? Have you obtained the EC as on that day? That is a bare minimum document before granting
I will
loan.
get it out now. It's I'll
List
be
this
there.
matter tomorrow. By that time, all the documents pertaining to this mortgage EC shall be placed before the court, or else the writ petition will be allowed on the ground. Yes, next.
Number 30, Ajit PB.
Speaking for the petitioner.
Any interim order is there extended? Yes, 30.
Your lordship, last time the interim order was granted based on me depositing 25%. I have deposited it.
What is the outstanding amount?
Outstanding amount is out of 23 lakh.
I told you. Yes.
Out of 23,000, I have deposited 5,82,000. I'm ready to pay the remaining amount also.
When?
If my
File an affidavit. You should have filed an affidavit by this time. Which is the bank?
Kotak Mahindra Bank.
Who appears for Kotak Mahindra?
Some advocate is on record. Shiva Shankara A. Shiva Shankara A.
I print the name. It's already there. Where is he then? Have you filed an affidavit?
I will
list this matter on Monday. By Monday, file an affidavit about when are you going to pay the remaining amount. Learned counsel for the petitioner submits that the petition is ready to pay the entire amount, clear the entire amounts, and in that regard, he'll file an affidavit. No representation on behalf of the respondent. List this matter on Monday.
Cell number 31. Bharat K.
Petitioner counsel is unwell and is admitted to hospital. May be taken up any day after Monday.
Small clarification, that's all, if the property is mortgaged or not to this account. Money,
Any day after Monday, madam.
finally, allowed.
Finally.
Wednesday, list this matter finally on Wednesday.
Please.
At the request of petitioner that the council is unwell, no further adjournments will be granted. Next one. Yes, 32.
Cell number 32. 32.
But I appear for the petition. I appear for the petitioner, madam. I appear for the petitioner in this case, madam. This honorable court directed us to approach the bank for reconstruction of the loan, madam. We have approached it, but the bank has said they will abide by what the court passes the order.
My lord, what had happened? My lord, sale is held before this honorable court. Sale, my lord, challenged before this honorable court.
Where is the third party? How can after sale is conducted?
The sale agila.
No. Sale is not yet conducted.
Then go. We will give liberty to you to go to the bank. Why for that? Why should the writ petition be pending?
No, what they are saying is they are not going to entertain anything unless court passes some orders. We have approached it, madam. That is what they said,
The
madam.
court will not pass any order.
They have already taken possession, madam. That is the problem.
Why should we entertain the writ petition? Please tell me one legal ground, then we will entertain.
Madam, we have been paying.
What is the ground on which we should entertain this writ petition?
Madam, even despite they declaring NPA, madam, they continue to receive money from us, madam. Around 50 lakhs have been paid by West, my lord, to the bank subsequent to the NPA being declared.
What is outstanding as on today?
My lord, 2 crore 10 lakh 14,797.8. 2 crore 10 lakh 14,000.
No, to regularize the account, what is the amount?
Regularization, my lord, 42 lakh 40,077 as on my lord 29/11/2025 plus some expenses.
Yes,
So you are ready to pay that amount?
we will do that, my lord.
Last
We'll do that,
edition, we made
madam.
the very same.
No, come up with an affidavit before this court. Please, what is the exact amount today?
That is
You
42.
please ascertain from the bank.
Have it tomorrow, my lord, because I only given, I considered
We'll
this
do
as
this.
honorable court.
No, what we do is, I'll have this matter tomorrow.
Great.
No, why I'm saying pass over is, if you can tell the amount,
I'll tell.
or you inform to him,
I'll
and
tell
I'll have this matter on Tuesday.
Kindly pass it over. I'll take the instruction, I'll make a submission.
pass
Let
over.
them for an affidavit
Pass-
tomorrow.
pass
Great,
over.
great.
Much of it, much of it, much.
Cell number 33,
Appeal of petition,
Bill
Your
the
Lordship.
hearing.
Kindly a date may be granted because
M.A.
during the
Rajendra.
pendency of this case, they have taken physical position. Those documents are not procured yet. Kindly a week may be granted and I'll submit it with an IA.
No, if they've taken physical position, then
Yes,
go
Your
to the
Lordship, but
DRT.
Your Lordship, what happens is in DRT and DRAT, the scope is only narrowed down to the measures of respondent bank with reference to
You're on
surface.
odd ground before this court.
Your Lordship, measures are also included, but on main thing that they had to charge 29,000 EMI. But what they have done is they have charged 44,000 after moratorium period of COVID-19. Kindly, Your
Why
Lordship,
can't the DRT decide all this?
but Your Lordship, these conditions are already made before the DRT.
Which bank is this?
This can be
Bank of India, who appears?
Bank of India.
Who are the panel councils of Bank of India?
That Vignesh Shetty is there and Divya. Bank of India. That one. Only one he has given.
Only one advocate.
He gave it that details. No?
Yes, Mr. Vignesh Shetty, serve the papers on him. He is directed to take notice on behalf of the respondent bank. List this matter after vacation.
Much obliged.
Cell number 34. Cell number 34, Krishnamurthy N. Krishnamurthy N for petitioner.
The petitioner, my lord, this is with respect to the petition filed by the petitioner, wherein she has filed for divorce and she's filed for divorce, my lord. IA number
What
1.
is the impugned order?
My lord, for a direction to,
Dispose of the matter.
no, my lord, for maintenance, my lord.
Where is that impugned order? That's what I'm asking.
My lord, this is only for a direction to pass orders on the interim application filed before the trial.
When
court.
was it filed?
December 2023, my lord.
December?
23.
Till now, no orders were passed on IA.
My lord?
Till now, no orders were passed on
No, my
IA. Which court is this?
Objections also have been filed by the respondent, my lord.
Which court is this? Principal Judge Family Court.
Yes, my lord.
For third additional, the writ petition is filed seeking a direction to the family court to hear and dispose of I number 4 filed on 18/11/2023 under section 24 of the Hindu Marriage Act. When counsel for the petitioner submits that though the objections are filed by the respondent, so far the IA was not considered by the court. Next paragraph. This court has repeatedly issued directions to the family courts to dispose of the IA within 1 month once the objections are filed. But why this matter is pending from December 2023 till now is not known. The Registrar Judicial is directed to call for a report from the third additional principal judge why an IA that's seeking interim maintenance is pending from 2023. List this matter on 15th of December.
My lord, within certain date, the order may be passed on top.
I'll pass it on 15th. Yes.
35,
Petitioner, madam.
Ishan,
So
SK.
challenge the order of the family court, my lords, where the order of interim maintenance has been granted against the petitioner husband.
How much is granted?
15, my lords.
Huh?
15,000.
What is your income?
My lords, 20,000, my lords. I filed the income tax returns, my lord. Kindly turn to page number 26 of the ink page number, my lords. The learned trial court, my lords, has considered my IT returns. It reflects 2,44,000. So if it's divided by 12, it will come up to 20,000, my lords. In that 15,000 has been awarded to the respondent wife. My lords,
When
kindly
counsel
turn
for
to.
the petitioner submits that the income is 20,000 per month, and the court had granted 15,000 per month as maintenance. Children are, child is also there.
Two children, my lords.
Two children are with the wife.
Wife, but I am paying the school fees. That is it.
Submitted that the court, without considering the said aspect, has granted an amount of rupees 20,000, considering the same, 15,000, considering the same, there shall be stay of all further proceeding on the condition the petitioner should pay an amount of rupees 10,000 by 5th of every succeeding month, arrears also at 10,000 within 8 weeks.
My lords, one submission, my lords. The impugn order says the maintenance amount has to be paid from date of application, my lords.
That is what it is in every case.
My lords, but no reasons had been assigned why it should be paid from the date of application, my lords. Since the date of application, my lords, kindly turn to page number 22, my lords. A date of application was filed on 10/11, my lords, and orders.
Generally, it relates back to that. If it is saying from the date of order, then they should give reasons, not for that.
Otherwise, also, my lords, why? Because she's not prosecuting, my lords. She's not even cross-examined me. My cross-examination has been nil. It is posted for her evidence also in the MC proceedings. She's also not prosecuting.
We are concerned only with the IA,
please,
not with other things.
But the conduct also, my lord, she also equally qualified.
We will see.
My health issues.
Yes, next. Notice petition is permitted to take out hand summons on the counsel appearing to the respondent and file a memo to that effect.
Number 36.
If the memo is not filed by Jan, give some day in January,
Less
the
than,
stay granted
my
by
lord,
this court.
7,500, my lord. Humble request. My medical ailments has not been considered, my lord.
Then how wife and two children will live with 5,000?
My lord, I'm paying the school fees also. She's also equally qualified, my lord.
School fees, leave the school fees. How will they sustain?
My lord, she says.
Sorry.
7,000, my lord.
Number 36.
For the petitioner, my lords, before this court challenging the order under section 24, my lords.
How much is granted?
20,000, my lords. No specific.
What
20,000.
is your income?
My lords, before delving into it, my lords, the specific facts would be considered, my lords. Page number
Will
26.
consider all those facts once the wife is before.
No, because the petition itself is disposed of, my lords, and in the advent of disposal of the petition, the IA was also disposed. That was pending from 2015.
So how can you file a petition against that? The interim order has merged with the final order.
There is no connection given to that, my lords. That itself.
Necessary, but once nothing is pending, you can't file a writ petition before this court.
No, but because this application, the order was.
If the order is passed along with the main order, this has merged with that.
That's not merged, my lords.
It is deemed to have been merged.
No, the order must be looked into, my lords.
How can it be looked into when the main MC itself is disposed of?
No, that is the error committed by the trial court, my lords.
That's not an error. Now you will question it before the appellate court.
No, my lords, 2015 was the application filed, and they have not pressed that application. In spite of not pressing that application, an order was passed on that.
Have you questioned the order passed on the main MC?
Yes.
In that you will question this also. You will
Because,
seek an interim direction with regard to this also. Because you can't maintain a writ petition when the main MC itself is disposed of.
My lords, before the same may be considered, my lords, until then the order may be stayed.
The petition is filed questioning an interim order on maintenance, and along with that the main writ petition itself, main MC itself is disposed of. When the main MC itself is disposed of, question of entertaining this writ petition will not arise. Petition is at liberty to question to seek appropriate orders before the court where the appeal is pending. Yes, disposed of.
Cell number 37. Cell number 37. Sriram Timappa Nayak.
Yes. Maintenance order is passed, my lords. 25,000 per month.
25,000 per month.
25,000 per
What
month.
is your income?
66,000, my lords.
Then what's the difficulty?
The problem is my mother and father both are suffering from brain hemorrhage, and right now he is suffering from stroke.
Only
and I
wife or children are also there?
There are two children, my lords. Two children, the education expenses were taken care by me before. It was 50,000. Now what the lower court has done is, even without looking at the documents, 1 lakh per children per year has been ordered.
In this order?
Yes, my lords, for education expenses, and 25,000 per month has been ordered.
I am ready to
One
pay.
thing, pay the 25,000 as far as the educational expenses are concerned.
I'm ready to pay around 15 to 20,000 per month, Maharaj. I don't mind. But the education expenses, they're without any documents, they have put 1.5
How
lakhs
much according to
per
you?
year.
What is the reasonable
Maharaj,
amount
50 to 60,000 is the reasonable amount, Maharaj.
for each
Per
child?
year, for each child.
The land counsel for the petitioner submits that when the petitioner salary is
6,000 rupees.
66,000 and he has to take care of his parents.
And I've produced medical
who are
documents also
suffering
to the
with,
tune of
severe health
52,000.
ailments. The court had granted maintenance of 25,000 and 1 lakh educational expenses each, which is on the higher side. Considering the submission, they shall stay of all further proceedings on the condition that the petitioner shall continue to pay 20,000 by 5th of every succeeding month and shall continue to pay 50,000 each educational expenses. And the arrears of maintenance at 20,000 shall be paid within 8 weeks from the date of receipt of the copy of the order. Notice petitioner shall take out hand summons and file a memo to the
Caveat was there. I've served the copy also on the.
Caveat is there. Yes, notice.
I've served the copy.
There's no notice. The judge said list this matter after vacation. Yes.
Number 38. Tausef Ahmed.
Your Honor, the matter may be kindly heard tomorrow, my lord. My senior is not doing well.
What is this about?
This is arising out of a securitization act. They have come to the High Court directly without approaching the DRT. Now, on the eve of the fifth auction, they approached this honorable court to get.
When is the auction?
Sorry?
When is the auction?
Auction is completed on the same day when the interim order was passed. When the matter was listed here, the online auction took place there. And even before the communication.
Property is sold.
Property is sold.
Is the matter tomorrow? We'll pass orders tomorrow.
Very good.
Interim order may.
At the request of land counsel, the petitioner,
The
no further adjournments will be granted. It is submitted with the land counsel appearing for the bank that already the property is sold. Yes, by the time the interim order is passed.
Please. In the same day, it was confirmed also. This honorable court has only stated the confirmation. Sorry, the word used is finalization, but it is already confirmed.
By the time the order is.
Yes, order is communicated. It's already by 1 o'clock itself.
It is submitted that by the time the order is communicated, the auction is conducted and also the same is finalized. Yes, 39.
Cell number 39.
As for the petitioner, my lords, the petitioner has availed a loan of rupees 5 lakh from the
This is
respondent.
the bank.
My lords, it's an institution, my lords.
Take out notice.
Let's kindly, already it has been taken, my lords, possession, but at
Where
least.
is that? No, I will
It's in the
not
pleadings, my
grant,
lords.
I will not grant any interim order without
No, my lords,
notice to the.
at least to take permission for the petitioner to take the movables that has been taken.
Once he comes, we'll pass that order.
At least the movables, there are
I'm
documents and
saying,
other.
if you take out hand summons by
Please.
tomorrow and file a memo, immediately it will be listed.
Please, my lords.
Then counsel for the petition is permitted to
The
take
date
out
may be
hand
given.
summons on the respondent and shall file a memo to that effect. Once the memo is filed, list the matter.
Please.
Yes.
Cell number 40. Kalyanas.
Bring for petition.
Appearing for respondent one, my lordship. There is no claim against us. There is no claim against us. Union of India.
It is
Union of India.
It is, my lord.
Who are the respondents? State Bank of India. Who appears for State Bank of India? Who is the counsel?
State that Vignesh Shetty's name only he gave the.
His name is there.
Yes, ma'am.
Mr. Vignesh Shetty is directed to take notice on behalf of the. This is 33051.
33051.
You appear for Union of India, Suresh HS.
Yes, ma'am.
Mr. Vignesh Shetty is directed to take notice on behalf of the bank. Land counsel for the petition says the copy of the petition on the council. List this matter somewhere next week. Yes.
Cell number 41. Cell number 41.
Yes.
Kashina.
Lord, out of securitization act, my lord, possession is taken. Now, my lord, I have submitted a request, my lord, saying that I am ready to clear all the pending dues.
Which is the bank?
It's, my lord, the Mr. KV Lokesh is representing, my lord, in the earlier proceedings of another property.
Oh, he appears for this bank.
Yes.
The KV Lokesh is directed to take notice. Petition is shall serve the copy of the writ petition. List day after tomorrow.
Kindly. Tomorrow.
Cell
Day after tomorrow.
Yes, I'm ready to file affidavit.
That's what, if you're ready, you file it by the time the matter comes day after tomorrow.
Obliged.
Basing on that, we'll dispose of.
Obliged.
For 42,
Yes.
42,
In this case, my lordship, the
duration.
decree for divorce is allowed.
Hmm.
It's an expert order. We filed an application put to set aside. It is also dismissed. Only if it is notice is done, we will compromise the case.
If it is no, notice is given, they'll come for compromise.
In this case,
Is it a ground to give notice?
notice. If notice is taken, they will
It
come.
is MC number 4 of 2017.
Yes, ma'am.
Petition is who, husband or the wife?
Yes, yes.
What is it?
I filed an application for
Where is that order? Let's see the order.
page number 15, my lordship, the degree of divorce. The person is
Not
allowed.
decree of divorce. Where is this miscellaneous application and the order in the miscellaneous?
Application, last order is page number 96. Typed copy is there.
Page number?
96, last page.
93.
It is dismissed. The application filed
No
by me.
represents the cause of the petition. It is noticed that already 2 more times have been given.
Application filed by me is rejected.
So why should we issue notice?
Only thing is we will compromise the case. The reason is there. We engaged the advocate. It is in
No,
Shumaga.
ex parte judgment and decree. Again, you file miscellaneous. Miscellaneous also, you won't appear before the court. Court has dismissed. Why should we order notice?
No, if they come before the court, we will compromise the case. For that reason only, I am humble request. The
What
reason,
compromise you will do?
we are ready to live together. Or any we are ready.
Who filed for divorce? He has filed for divorce.
She has
If
filed
you are
for
ready, if she is not ready, that's why she has taken divorce.
My humble submission, if notice is ordered, we will compromise the case. We will try to compromise the
These
case.
kind of notices we shouldn't order. Why there is you have not appeared before the court. How many times?
In the trial court, he has engaged the counsel by mistakenly. He has
Petition absent on 5/3/22,
Although he is from,
18/4/22, 35/22,
is
19/9/6/2022. Finally, 5/7 it is dismissed.
Here the question, our petitioner is from Bangalore. He is the petition, the case is in Bhadravati. For that reason
Notice to
only-
the respondent.
Cell number 43, Narayan Bhatt.
Short accommodation, my lord, till day after tomorrow, my lord.
Bank of Baroda, who will appear?
I will serve my,
Baroda.
It is served.
no, I will serve my lord on bank.
Who appears?
Vignesh Shetty only, Bank of Baroda.
You appear for Bank of Baroda. Mr. Vignesh Shetty is directed to take notice. So the papers day after tomorrow. Next 44.
Cell number 44,
I'm seeking for a passover, my lords.
Passover.
cell number 45,
My lords, in 45, I'm filing my memo for retirement, my lords.
Then we have to, the interim order we will vacate then. Any interim order is there?
No, my lords.
No interim order.
First
We'll
time
give
the
that.
matter is coming up.
Take that memo. When did you give the no objection certificate?
No, man.
More
Today we.
details. More details.
No, my lords. He wants to engage another counsel, it seems, my lords. So I'll just.
No. For you, permit you to retire, there should be some material on record. Showing that you have given no objection or you have.
The
you
no
know, given
objection.
some-
Should I file it, my lords? I'll
Yes,
get an.
show
I'll-
that. Show that. When did you give this? Not even a date for that. And that is also with you. Will not permit you unless and until you come up with the petition shall file an appropriate.
I'll file it during the course. Passover, my lords. I'll just file it right.
Yes, password. Neither the date, nothing in that.
I'll file it.
cell number 46, Nagaraj Shetty, for petitioner.
And there should be a received signature should also be done.
Client is here only, my lords. I'll file it right.
Yes.
I may be permitted
Then
on.
I'll adjourn this matter, no Passover, we'll adjourn it by Wednesday.
I just file it off, my lords.
Yes. 46.
My lords, I may be permitted to appear, my lords, the counsel on behalf of my lords, the petition. So on an earlier occasion,
Which is the respondent?
lords, Bank of India, my lords. Bank of India.
Bank of?
Bank of India is the respondent. Lords.
Is
Page-
Bank of India who appears? Mr. So-and-so is directed to take notice on behalf of the respondent bank. Please serve the papers on.
Please, my lords.
Let him get
My
instructions.
only short prayer is to consider my case for one-time settlement.
Whatever it is.
Please,
There should be a
please.
scheme. There should be, you must
Yes,
be
sir.
the.
To show my bona fides, my lords, on an earlier occasion, on 2 occasions, my lords.
So-and-so is directed to take notice. List this matter day after tomorrow. By the time you please get instructions.
May I seek indulgence instead of day after tomorrow, my lords, could it be on 11th, my lords? Instead of 10th, I am requesting for 11th.
Yes, 11th.
Please.
Yes,
Lords,
next.
in the same stage, my lords. In the same stage, my lords, preliminary hearing itself.
There only it will come.
Please.
Yes.
Grateful.
Cell number 47.
I appear for the petitioner in this matter.
Yes.
This is a husband's petition, my lord. The wife had filed an application under section 24 of the Hindu Marriage Act. And the husband, she is working as a lecturer in a school and she is getting 21,000 as the income.
That is on record?
Yes, my lord.
That is on record?
Yes, my lord. And
How much
another
is
thing,
granted now?
the court has granted 30,000. Actually, the husband lost the job because of the problems that he faced.
No,
All
no.
the documents, emails,
30,000 court has granted. What is his income?
it was 1,25,000 and now nothing,
No,
zero.
when the order is passed, after that he lost.
No, before that only.
Was it
It
brought to
has
the
come
notice of
on
the court?
record. It has come on record.
Let's see.
At page 339, my lord.
Page?
339. Continuously remained absent for duty and he was unauthorizedly absent from duty and he was strictly advised to report to duty immediately and submit an explanation on or before 14/5/25. And if the petitioner fails to report the company, they would be.
Any children in the wedlock?
Page is
Children.
Children, one daughter is there. Ma'am.
Aged about?
Aged about 5 years, I think.
Lend counsel for the petitioner submits that
22 lakhs is the arrears
He
it
was
comes
having-
to, my lord.
he was having, earlier he was working 1 lakh and odd. And during the pendency of the proceedings, he had lost the job and he's not in a position to pay the amount of rupees 30,000 as ordered by the court. Considering the submission, they shall be stay of all further proceedings on the condition that he shall pay 10,000 per month. And the arrears also at 10,000. Within 12 weeks, notice to the respondent. Petitioner shall serve the hand summons on the counsel appearing to the respondent. Shall file a memo to the effect, give a date in January. Even on that count also, the stay granted by this court stands vacant.
Cell number 48.
Yes.
Adi Prasad.
Petitioner, Your Lordship, I've challenged the order dated 19/9/25 on IA 18 and 19 for recall of cross of PW1. It was recalled once and on the very first date, the counsel was absent due to ill health.
It
The
has come up
stage is
earlier
closed.
or coming up today?
Yes, Your Lordship.
The other connected matter has
Yes.
come. When is it posted to?
After the notice.
On this is petition is permitted to take out
Lordship,
hand
stay may
summons.
be granted, Your Lordship. Friday is the
Petitioner
order.
is permitted to take out hand summons. List this matter and file a memo to that effect. Once a memo is filed, list this matter along with give that number. Other number. Yes, 49.
Cell number 49. Satish TV.
For the petitioner, this is the guarantor petition. Challenging the sale notice. Tomorrow is the sale is fixed.
Why should we install the sale notice? What is the ground?
Ground, my lords, the bank is not initiate any legal proceedings against the principal borrower.
That's not a ground.
Directly initiate the.
Because the liability is coextensive. They can do against any of them.
That's reasonable time may be granted. Entire outstanding
What
amount.
is the outstanding amount as on today?
As on today, 30 lakh.
30 lakhs.
30 lakhs.
50. When will you pay that amount?
Within 12 weeks. One property is already entered into sale agreement for the clearance of this.
Yes, counsel for the respondent.
According to my information, Mills, the outstanding is more than 56 lakhs.
No, my lords, the loan amount is above 90 lakh. But outstanding dues are 30 lakh.
My my
Tomorrow,
liability is,
Manoj, I'll get the correct information tomorrow.
No, instead of tomorrow, we'll take it, inform the council, whatever is that outstanding amount. If he comes up with an affidavit that he's ready to pay the amount.
Because
we'll-
tomorrow is the auction, Manoj. If
Tomorrow
he
is the
doesn't
auction.
deposit, then the auction, let the auction go on, Manoj,
Not to finalize.
not to finalize, if he deposits the entire amount.
The land counsel for the petitioner submits that he is ready to pay the outstanding amount.
for the
According to him-
regularization.
Not for the
According to him-
regularization, Manoj.
Huh?
This is a business loan.
Hmm.
It cannot be regularized. Is it not? It
That's,
is not a home loan, Manoj.
This is, last installment was released in the year 2024, my lords.
All those things will not go into, because they have no legal grounds.
13-2
on that.
notice was issued in 2024.
The petitioner submits that he is ready to clear the outstanding amount. According to him, the outstanding amount is 30 lakhs. Land counsel appearing for the bank submits that the outstanding amount
More
is
than 56 lakhs.
56,000.
56 lakhs.
56 lakhs. The land counsel for the respondent shall inform the counsel for the petitioner what is the outstanding. If the petitioner comes up with an, it is submitted that he'll come up with an affidavit by Tuesday. List this matter on Wednesday. The auction shall go on, shall not be finalized till Wednesday.
That's Wednesday I am filing them. Tuesday I am not in station.
Hmm?
Tomorrow I am not in station.
Wednesday.
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 I said Wednesday. He will inform you. That is also not acceptable over phone.
Huh.
Yes.
Okay.
Huh? Huh.
Then,
Yes.
Sale number 50 for admission matter.
Yes, admit
My
finally
lord,
it is here.
Please, my lord.
Sale number
51.
51.
Also same.
Sale number 52.
Same.
Sale number 53.
Notice.
Sale number.
Rate for stay. Our liability is fixed at 30%. So I will deposit 50% of our liability.
What is your, you are on the question
My
of
lord, this is on the question of liability. My lord. The person who was driving the vehicle held no driving license. This after the amendment.
it is submitted by the land council insurance company that the person who is driving the vehicle is not having a valid driving license. In spite of the same, the court had fixed the liability on the insurance company. It is submitted that the liability of the insurance company is 30% of the compensation amount. Considering the same, the insurance company shall deposit 50% of the liability that is fixed on the insurance company within 4 weeks. Notice
One-
to the respondents.
One submission, my lord. Same insurance company, same office, both the vehicles were insured with the same company, my lord. So that's why my humble submission is, other vehicle, my lord, 70% fixed. We are not challenging that. That's why my humble submission is,
That's what I said, your liability.
no, 4 and 5 notice may kindly be dispensed.
Memo is filed seeking dispensation.
Yes.
Give the memo.
I will give it. Just
Memo is filed seeking dispensation of notice to respondents 4 and 5. Dispense with the risk of appellate notice to other respondents.
Sale number
Is 54.
54.
Problem.
Appear for filing this
Notice.
case. Much obliged, my lord.
Sale number 55.
Yes, 55.
Sale number
Day after
55.
tomorrow, my lord.
Hmm?
Day after tomorrow.
Why?
My lord, senior not in station. Yesterday, my lord, my relative
Next
expired.
All day after tomorrow I cannot take. The list
Next
will be,
Next week.
what is there any interim order in this?
No, sir. Now the petition has been dismissed on the ground of adultery. Now the.
The RPFC matter.
Sir?
RPFC. it
Yes,
is.
yes.
List this matter after vacation, next 56.
Sale number 56. 56. K. Vishwanatha. For petitioner.
No representation. List this matter after vacation.
Sale number 57.
Petitioner in this case.
Harish.
56, yes.
125 proceedings, my lord.
What is the amount granted?
13,000.
13?
13,000, my lord.
13,000 is granted. What is the salary?
Sal number is coolie, my lord. The mason and they are stated in the map.
Land counsel for the petitioner submits that the petitioner is a mason and the court had granted 13,000, which is on the highest HCM. He shall be stay on the condition that he shall pay an amount of rupees 7,000 by 5th of every succeeding month, and the arrears also at the same. Notice to the respondent. Yes, next.
Much obliged.
My lord, 125 proceedings.
Default
Your-
order and all same on.
125 proceedings, your lordship.
Huh.
Directing me to pay the 5,000, your lordship. He is working as a coolie, your lordship. Children are custody of the petitioner, your lordship. Last occasion, he was arranged the marriage of his daughter, your lordship. He got the loan
But 5,000 is a very nominal amount.
He has got only 300 rupees, my lord, in APMC yard he is working. She has admitted the same, your lordship.
It is submitted that the court has granted 5,000 as maintenance and the petition is taking care of the two children and in fact he has got one of the daughters.
Daughter, your lordship, last year.
Performed one of the daughter's marriage and it's difficult for him to pay 5,000. 2,500 arrears also at the same time.
Much of it.
Within 12 weeks. Yes, next.
58.
58, my lord, again led by senior counsel in this matter.
Yes. Yes.
58, I appear for the petitioner's counsel, my lord. Lord, there was an order passed by your lordships. My lord, what has happened is I have purchased a property. My lord, two persons own the property, husband and wife.
Yes.
Wife's husband had, my lord, mortgaged this property in favor of a bank, a consortium of banks. And later on, my lord, that money was not paid, but the property was sold to me. Ultimately, it was held by the tribunal that I have acquired 50% interest in the property, not 100%. My wife's share I have purchased, but as far as husband's share is concerned, my lord, there were claims as far as banks are concerned. Lord, I did not know about it. I purchased it. I filed an application to implead myself in the DRT proceedings. DRT, my lord, rejected that application. Against that, I have come up now before your lordships. My request that I made to the other side was, look, you're a bank, you're a consortium of banks. You're only interested in the money. Why don't you give me an opportunity to make good that money and transfer that 50% to me? Either you buy my 50% or you allow me to buy the 50% that the bank has a claim.
When was the property mortgage?
Lord, long back, my lord, it's not very clear as to when exactly it was mortgaged. But if your lordship looks at the trial court order, I mean the DRT order, your lordships will get that at page 85. It starts at annexure K, page 81 at 85. 85 is order.
Yes.
Please come to page 86, para 4.01. The sale deed executed by Rajshekhar Murthy on 16.
So where will you get that? Page number?
86, para 4.01. The sale deed executed by so-and-so on so-and-so in favor of Anant Rai Mehta and his wife Prabhavati Mehta defines them as co-owners with equal shares. In page so-and-so, the demand notice sent to AP Mehta and so-and-so has been returned with postal remarks so-and-so. Shri Mehta filed objections dated so-and-so to the demand notice. So the demand notices have been served on D2, D3 and D4 itself. Both certificate holder banks have stated that Prabhavati Mehta is not liable to them in any way except as legal heir of AP Mehta who died on so-and-so. No notice to LRs was issued by the recovery officer on so-and-so and the same was published in Economic Times on so-and-so. The alienation of the scheduled property by Prabhavati Mehta in favor of Bindu promoters took place on so-and-so, subsequent to the service of the demand notice. Further, the scheduled property was also attached at a later stage under Rule 51, so-and-so, to pay the arrears. As such, the alienation of the share of the property belonging to Mehta to Bindu promoters is non-existent in the eye of law. The half share of Mehta in the scheduled property has not been identified so far. Skip the next paragraph and come to that. Claim of the certificate holder bank over half undivided share of the scheduled property is upheld. The scheduled property will continue to be in attachment in totality because the half share of each certificate holder and the objection has not been identified. I have half share. I have constructed.
Yes.
So your lordships passed an order last time directing the bank to have some official who could sit and negotiate with my client, my lord, and find out whether it's possible to buy the. And that's all I'm interested.
No, such order is passed.
In fact, my lord orally directed me whether any settlement bank is interested in your money. In fact, I tried to.
He says that he has a difficulty. Nobody is listening to him.
The difficulty here is, my lord, it's not only Bank of Baroda. It is also, my lord, State Bank of India. My lord, kindly come to, my lord, respondent number 3 is the State Bank of India. My bank alone may not able to take a decision. That is the difficulty which I have. And in fact, my lord, kindly see the, my lord, relief sought before this honorable court. That order passed by the, my lord, DRT. That is at, my lord, page number, my lord, 88. In fact, my lord.
No, who represents the other bank?
State Bank of India, my lord. I don't know whether notice served upon anybody or.
He's the counsel representing all the banks.
No, I took notice only on behalf of Bank of Baroda and.
No,
Vijaya
that's
Bank.
what order sheet says.
State
That
Bank
he
of
has
India,
entered
so far
appearance.
State Bank of India, you don't represent?
I represent, but in this
No,
matter.
in this case.
I
So
saw-
who is the other panel counsel for State Bank of India?
My lord, this is erstwhile State Bank of Mysore, now taken over by, if your lordship looks at the cause title, page 5. It is erstwhile State Bank of Mysore, now taken over by Bank of India. Now, as far as Bank of Baroda and Vijaya Bank is concerned, they both have got merged.
So you are appearing for Bank of
Bank
India.
of Baroda and Vijaya Bank, when under the same lord, I can take
No,
notice.
no, Bank of India, we have to have. the
Bank of
other
Baroda,
counsel.
not India. Bank of India is not there here. Bank of Baroda is respond number 1.
Bank of Baroda and
Vijaya
Vijaya
Bank
Bank,
is respond number 2.
they
He
have merged.
represents. He represents.
He is also the panel counsel for State Bank of India.
But
Some
when there is
melody
some
I may-
conflict of interest, you can't.
Just have a
represent.
look at 22/7/20.
What's the name, Divya?
Lord, just have a look at the order dated 22/7/25.
So Divya, so and so is directed to take notice on behalf of the bank.
22/7/25.
Indian Bank, what is that? Union of
State Bank of India.
Bank of India.
Just have a look at 22/7/25 order, my lord.
22.
7/25.
Yes,
Your lordship gets
on
that?
behalf of land
Ah.
council so and so. Is
For 1
appearing
to
for
3.
respondent 1 to 3.
No, I'm not embarrassing him, but I mean,
Milord, I may take a different stand in this matter, Milord.
Yes.
It's not
fair enough.
but to assist you.
So,
But would your, as far as 1 and 2 are concerned, would your lordship pass an order directing somebody responsible from the bank?
No difficulty. My lord can, my lord, my.
Because I don't know to what extent my
we'll
friend
see,
would be
we'll
able
see,
to.
let other bank also come.
Allah, let it be done.
Respondents- No,
My lord, if your
respondents
lordship-
1 and 2, Mr. Vignesh Shetty appears. For the third respondent, so and so, what is the name you said? Divya? Is directed to take notice and serve
Pardon, my lord.
serve papers on her,
Yes, yes, we'll do.
on the third respondent. Let's just matter next week.
Please.
Date will.
They'll give the date.
Some date may be given, my lord.
Yes, it will be indicated looking at the board. Yes.
59.
I'm for the respond in this case.
Yes.
There is a due of 1.5 crores.
Mm.
No amount has been paid from the last 5 years. Last payment made on 31st March 2020.
Stay. There is a stay.
Action has been stayed on 18/8/2022.
18th August 2022 state.
My lord, senior is out of station, my lord. Kindly have it after vacation, my lord.
No, will not have it after vacation.
Not
One
compared.
submission, my lord. Parties agree to pay the outstanding amount.
If you are agreed to pay the outstanding, who stopped you from 2022?
Since 2022, same
18/3/2020.
submission is making, my lord, not paid the amount. They have
Finally,
obtained the interim
Tomorrow,
order.
day after tomorrow, you can choose either of the dates, not beyond that.
Parties agreed to pay within 1 month, my lord.
Same
Affidavit.
submission has been
Where
made.
is the affidavit?
I will file, my lord.
This is matter day after tomorrow. By the time, the petition shall come up with an affidavit with regard to the payment of the outstanding amount. Or else he shall go ahead with the argument, or else the writ petition will be dismissed on that ground. Yes, 60?
K. Ravi Shankar.
Yes.
Beg to appear for respondent bank in 60 and 60.1.
Hmm.
That's my only submission is objections and ready. We shall file it in the due course of
This
the
has
day.
been
I think
going
you also
on.
asked it the same, made the
No,
same
my lord, on the
submission.
last occasion, my apologies, I could not appear before my lord. On 4/12, the matter was listed. I was on my legs before the coordinate bench during that time, my lord. All I seek is, my lord, we'll file the objections today. I'll serve a copy to my learned
The
friend as well.
residential house has been, which it is not the case plot, it is not a secured asset. It is not the property which has been sold in my favor in the year 2006. Subject matter in the Panchanam, they have seized it, my residential house.
My lord, there are certain survey which has been conducted, which are produced along with my statement of objections. I just.
You are not a
I
borrower.
I am not the borrower.
Intend to place it on record, my lord. I shall make.
When they have taken possession of the property?
2016, 20 under, the 14 order is 2024. 2006 is my sale.
Possession is taken?
Please, Milord.
Physical possession is taken?
Taken.
But anytime next week at your lordship's convenience.
But I am
shall make good
objecting
with my
for the
submission.
simple reason.
You can't, because we can pass an interim order if you're keep on asking for time.
But my lord, I'll place my objections on record today itself, my lord. I serve a copy to my learned friend as well.
Yes,
Let
yes,
them hand over it and let them argue leisurely. I don't have any objections for that.
My lord, I'll make.
Is the matter on Thursday?
Please.
The petitioner, the respondent shall file his objections by tomorrow. And the petitioner, if any rejoinder he wants to file, he can file. On Thursday, the matter will not be adjourned.
Highly obliged. Great.
61.
Yes.
Lord, I appear for petitioner, my lord. My lord, seek for a short accommodation, my lord. There's a briefing council traveling from Delhi. Due to the flight cancellation fiasco, he couldn't travel. May kindly have it on Wednesday or Thursday, my lord. It would be.
Yes, Wednesday.
I can't deny the fact that airports are in a state of chaos.
Yes, much open.
Wednesday.
Much
Yes.
open.
Remaining matters up to now.
Great.
But serial number 45 minutes, the client is here, madam. Given him the NOC, madam. That memo of retirement.
At 45.
45.
Memo of retirement is filed. Counsel is before the court. He submits that he has already received the no objection wakalat. List this matter next week on Tuesday. By the time if he engages the advocate, by the time he fails to engage the advocate, the interim order is there.
It's not
The
there.
petition will be dismissed on that ground. Yes.
My lord, one submission, my lord. Serial number
Next
8.
Tuesday, my lord.
Yes.
Serial number 8, my lord, is passed over.
I'm opposing, my lord.
No, I will not. I'll
But the
not
senior
hear
con is unable to
any
appear, my lord.
request for adjournments now.
My lord, tomorrow, maybe you taken up tomorrow, my lord. Senior counsel is not out.
My lords, there's one small urgency to have the matter listed at the end of the list, my lords.
Will you make a mention now?
My lords,
Sorry.
apologies, my lords. My lords, there's a urgency, my lords.
ಸರ್ ಮಧ್ಯಾಹ್ನ ಇದೆಯಾ ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲಿ 30 15 ಜಾಸ್ತಿ ಇಲ್ಲ.
ಬೆಳಿಗ್ಗೆ ಕೊಡಕ್ಕಿಲ್ಲ.
ಮೇಡಮ್ ತಗೊಂಡು ನಾವು ತಗೊಳಕ್ ಬರುತ್ತಾ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು ಬೆಳಿಗ್ಗೆ ಬನ್ನಿ ಹಂಗೆ ತಗೊಂತ ಇಲ್ಲ ಇವಾಗ
ಏಯ್ಟಿಗೆ ಒಂದು ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತು ಆಗಿಲ್ಲ ಸರ್ ಮ್ಯಾಟರ್ ಟೆಂಟೇಟಿವ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು 8 ಮೇಡಮ್ ಇಲ್ವಾ
ಏನ್ ಹೇಳಿದ್ರೆ ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿ ನಾಳೆ
ಮೇಡಮ್ ಮೇಡಮ್
ಬರ್ತಾರೆ ಅವರು ತಗೊಳಲ್ಲ ಮೇಡಮ್ ತಗೊಂಡ್ಬೇಡ ಅಂತ ಹೇಳಿದ್ರು
ಚೆಕ್ ಮಾಡಿ
ಲಾಸ್ಟ್
45 ಪಾಸ್ ಇವರು ರಿಟೈರ್ಮೆಂಟ್ ಮಾಡ್ತಿದ್ರು
45 ಫೈಲ್ ತಗೊಳ್ಳಿ ಪಾಸ್ ಓವರ್ ಇಟ್ಕೊಂಡವರು ಹೌದಾ ತಗೊಳ್ತೀನಿ ಅಷ್ಟೇನಾ ಬನ್ನಿ ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ ಮೇಡಮ್ ಏನ್ ಹೇಳ್ತಾರೆ ಹಂಗೆ ಕರಿತೀವಿ
ಪಾಸ್ ಓವರ್ದು ಫೈಲ್ ಅದಾ ಅದ್ರಲ್ಲಿರುತ್ತೆ ಯಾಕಂದ್ರೆ ಒಂದು ಆರ್ಡರ್ ಅಂತ ಎತ್ತಿತ್ತು 29/3/45 ಮಧ್ಯಾಹ್ನ ಇದೆ. ವಿಂಧ್ಯ ಮೇಡಮ್, ಅದು ಚೇರು ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ತಗೊಂಡು ಹೋಗಿದ್ರಂತಲ್ಲ ಅಲ್ವಾ? ಅದು ಹೋಟೆಲ್ದೇ ಸ್ಪೆಷಲ್ ಸಿಟ್ಟಿಂಗ್ ಇತ್ತಲ್ಲ ಅಲ್ಲಿ ತಗೊಂಡೋಗಿದ್ರಂತೆ. ಅಲ್ಲ, ಸ್ಪೆಷಲ್ ಸಿಟ್ಟಿಂಗ್ ಆದ್ಮೇಲೆ ಮೀಟಿಂಗ್ ಆಗಲ್ಲಂತೆ, ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಇದು. ಅಲ್ಲಿ ಮೀಟಿಂಗ್ ಆಗಿದೆ, ಇದನ್ನ ಎತ್ತಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರಾ? ಅದನ್ನೇ ನಾನು ಹೇಳಿದ್ದು, ಮೀಟಿಂಗ್ ಆಗಿದೆ, ಮ್ಯಾಡಮ್ ಚೇಂಬರ್ ಅಲ್ಲಿ ಒಂದು ಚೇರ್ ಇಲ್ವಾ, ಇದೇ ತರ ಈ ತರ ಚೇರ್ ತೆಗಿಸ್ಬಿಟ್ರಾ? ಅದೇ ಹಂಗೇನಾದ್ರು ಬೇರೆ ಕಡೆ ಶಿಫ್ಟ್ ಮಾಡ್ಕೊಂಡಾಗ ನೀವು ನೋಡ್ಕೋಬೇಕಪ್ಪ. ನಮ್ಗೆ ಯಾಕೆಂದ್ರೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೋದಾಗ ನಾವು ತರ್ಸ್ಕೊಂಡ್ಬಿಟ್ವಿ, ಆಯ್ತಾ? ಮೀಟಿಂಗ್ ಆಗಕ್ಕೆ ಹೋದಾಗ ತಗೊಂಡೋಗಿರೋದೇ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ, ಅಲ್ಲಿ ಏನಾಯ್ತು ಅಂತ ನಮಗ್ ಗೊತ್ತಿಲ್ಲ. ಯಾವ್ದು?
ಯಾವ್ದಿಲ್ಲ ಅಲ್ಲ
59 ಏನಾಯ್ತು ನೋಡು, ಇದು ಅವ್ರದ್ದೇ. ಒಂದ್ ನಿಮಿಷ ಇದೆ ಸರ್.
We are not audible to the video conferencing. Your Lordship may.
Just commission.
Ah.
This matter, my lord, senior counsel argument is
it be.
required. my lord.
Kindly see the
Maybe
three-
taken up tomorrow, my lords, tomorrow, my lord, because
Court
health
has
issues.
so many cases tomorrow. Every case can't be tomorrow.
That's the only request, my lord, the ground, my lord, senior is
Can you
not
see the
well.
order?
Why it is a passed over in the morning?
Because senior was supposed to argue in the VC, my lord, but he is unable to argue because of
Why?
his health issues, my lord.
My lord, I may permit you to 2 minutes.
Maybe
my lord, I
taken
just
up
point-
tomorrow, my
Who
lord.
is the senior counsel
D.R.
appearing?
Ravishankar.
He was there in the morning.
No, that is what, my lord, is not that.
No,
He
my
communicated
other
me that he
appear.
is unable to appear because of his health issues. He'll appear tomorrow.
My lord, I
Maybe
just
taken
pointed,
up
my lord.
tomorrow, my lord, the only request.
I may permit you to, my lord, argue 5 minutes, not 5 minutes, 3 minutes. But I'll just point out, my lord, 3 order passes.
This matter requires, my lord, senior's argument.
It is nothing but
Kindly.
abuse in the process.
No, you take orders from the court and whenever the vacate petition is moved or they want the stay not to be extended, then you keep on seeking
My
time.
lord, this case, my lord, the bank, my lord, has played fraud against the customer.
I'll point out whether what is the fraud.
This requires, my lord, senior's arguments.
My lord,
You should have
There
come
are
and
three
argued.
matters which is connected, my lord, and it's voluminous, my lord. That is the only request I'm making. Maybe taken up tomorrow, my lord, senior will address that.
my lord, I may permit to.
Why, as if court has no other work to every matter to pass over, every
Well,
matter
it's
to
a-
be taken up tomorrow? How many times this matter underwent
3
adjournment?
dates, my lord, one order dated, my lord, 9/6/2025. The subsequently, my lord, 17/6/2025, this honorable court, my lord, granted and my lord, in fact, last occasion, opportunity. And latest order, my lord, on dated 31/7/2025, Justice Shamprasad order, my lord, it is very clear. Next date of hearing, you have to argue. And again and again coming for this
No, my lord, kindly see the order sheet, my lord, 4/9, we have argued the matter and was directed to file the synopsis.
We have filed.
And thereafter, my lord, the matter was not listed.
My lord, I'll just
Lord,
point out, my
kindly
lord.
see the order sheet, my
I'll
lord.
just point out, my
Every
lord.
time, lords, we have argued the matter, my lords.
Then, my lord, I'll just point out, my lord. The issue before this honorable court, very same issue, my lord, they are taken before the DRT in 3 SA, my lord. In fact, I filed the, my lord, compilation of judgment as well as, my lord, the memo. Here, my lord, the limited scope, my lord, whether classification when PA, whether this court, my lord, DRT have a right or not, whether to decide, whether this honorable court only has to tell it. In fact, we filed 2 judgments, my lord, kindly come to, my lord, order passed by Justice Shamprasad on 31/7/2020. Kindly, for a moment, my lord, I'll just read. Order dated, my lord, 31/7/2025. Sri D.R. Ravishankar, the learned counsel for the petitioner, Sri Vignesh Shetty, the learned counsel for the respondent, bank are heard on whether there must be some interim arrangements given the interim order that granted in a coordinate bench in this disposed of petition. Sri Vignesh Shetty contend that the writ petition number so and so must disposed of of relegating the petitions to canvasses all the grounds in the pending applications before the DRT concerned in view of the decision of the FX court in the K. Virupaksha and others versus State of Karnataka and others 2024 SCC 440. Sri D.R. Ravishankar proposes to contend that court will have to examine the petitioner grievance against the declaration of the loan account as NPA in the light of the fact that documents which are directed to handed over are not handed over. The learned counsel also submits that the proposition of the exposed by the FX court in the F4 decision may not apply to the present case. This and the other submissions have to be considered essentially address the question whether the petition under WP number 24367 must be disposed of, relegating the petition to pursue the proceedings pending for DRT with a consequential decision of the other 2 petitions. Specifically, if it is brought out the documents as required by this court in WP number 1439 are yet to be handed over, when it is in the question of the present would be whether there should be any precipitation until the next date of hearing. Given the history of the litigation and the perfinness which is being fought, given in the history
Yes,
of
Mr. Vignesh Shetty, what is now?
No, my lord, I'll just.
What is the benefit of hearing your arguments now? Just
My lord,
like
he can't go. My lord, 3 adjournment thereafter. My lord, kindly before that, my lord, kindly come to my lord. The order passed by Justice Sunil Latte, one
this
9/6/2025.
matter at 2:30. List this matter at 2:30 tomorrow. No passovers. And if any request for adjournment is sought, without going into the merits of the matter, the writ petition shall be dismissed with exemplary costs. Yes.
Chair number 9.
My lord, I am
Lord, in
appearing
this
for the
case, I
respondent in
represent
this
the
matter,
petitioner,
my
my
lord.
lord.
My lord,
The first submission would be that in the cast title, cast list, my lord, my name may be mentioned. It is mentioned. The earlier advocate's name is also there, that needs to be removed, my lord. That is the first submission. The second submission would be, my lord, that on 25/11/2025, this honorable court has granted an interim order, my lord, directing the
Come to
bank.
the order, latest order on 28/11/2025.
Please, my lord, I will come to that. Before that, my lord, may I be.
Land counsel for both sides are present. Land counsel for the respondent submits that the auction was held on 26/11/2025, but the
Please, ma'am.
respondent has not confirmed the sale. She further contends that in the order dated 25/11/2025, the petitioner has not disclosed the dates on which he would pay the amount as undertaken. Land counsel for the petitioner submits that he will file the memo to that effect on the next date of hearing.
Please,
Where
my
is the memo?
My lord, I will file the memo. Memo is there.
First pass on the memo, we'll see there.
Please, my lord.
Remaining submissions later.
My
Do
lord,
that.
this memo, my lord, contains a document.
Given a copy to the.
Yes, my lord, I have already
Lord,
shared
they
the
are filing
document.
one
Not memo.
agri-
No, I'll submit to that, my lord. The facts, the background of the case, I need to submit before this honorable court. My lord, the auction
When
was
is it-
scheduled
when is the
on
interim order?
26/11.
Please wait. When is the interim order granted by this court?
My lord, that is on 25/11. May I read it, my
Let me look
lord?
at it. Let me look.
May I read it, my lord? Heard the learned counsel Shri Arun KS appearing for the petitioner. It is submitted by the learned counsel appearing for the petitioner that the e-auction notice has been issued in respect of the subject matter in which the claim made by the respondent bank is nearly 3 crores. In this regard, he referred to the possession notice produced at Annexure F and further submitted that the petitioner is ready to pay an amount of rupees 1 crore per month for consecutive 3 months hereinafter, and therefore sought for interim order of this honorable
Precisely
court.
the reason why the interim order is granted is you're ready to pay 1 crore in
I'm-
3
I'm-
installments.
May I complete, my lord? May I complete the submission?
That's the reason why, I have read it. I have read the entire order.
I will not read that, my lord. My lord, subsequent to this, the very next day, that is on 26th, as per their own admission, the auction has been conducted. In spite of the interim order of this honorable court and in spite of bringing the interim order to their notice also. It is not that we have taken the interim order without their notice, and subsequently on the very same day it has been intimated also. And on 26/11, when the auction was scheduled, when we produced the copy of certified copy of this honorable court, the officials have said that it is a duplicate copy. And they have refused to stop the auction. Now they are contending that though auction has been held, it was not been confirmed. My lord, in my humble understanding and submission,
Not going to that aspect. I want an affidavit before this court.
my lord, I will
with
file
regard to the payment.
my lord, I will come to that, my lord. I will come to that. I am not going anywhere. My lord, my submission.
Filed it long back.
My lord, I will come to that, my lord. Please bear with me for 1 minute, my lord. The first thing is they have violated the interim order, my lord. The second thing, their own official has introduced a buyer to the petitioner and got entered into a sale agreement. That is what produced before this honorable court by a memo, my lord, dated today's date, my lord. Now, my lord, my respectful submission is the agreement, the auction was held at the base price, that is 2 crore 10 lakhs. My lord, even the purchaser who has been introduced by themselves is ready to pay back the same amount and get the sale deed confirmed by the bank. Now that is the position, my lord. Hence I have filed the memo along with the sale agreement, my lord. One more submission is, my lord, on 29/10/2025, without invoking the provisions, without following the due procedures, my lord, as held as enumerated in section 8 and 9 of the surface rules, they have came and dispossessed all the tenants and taken the physical possession of the property, my lord. That is also not in dispute. Now, my lord, my respectful submission would be that in spite of the interim order, since they have violated, after the violation, my lord, after they admitted that holding of the auction on 28/11, we held a meeting with the bank officials, and bank officials are telling, my lord, since it is the matter is pending before this honorable court, might be an order to that effect to give effect to that sale agreement, my lord. Is my respectful submission, my lord.
Then again, we'll come back to square one. What is the reason
My
for,
lord,
basing on what an interim order is granted to you?
my lord, interim order has been granted based on my undertaking, my lord. I am not denying
There is
it.
no other legal
But-
grounds that the court has considered. Only thing that. So this order is passed on 25/11/2025. Where are we today?
My lord, we are, my lord, from that date, my lord, the undertaking was 1 crore per month. From that date.
It should be an undertaking.
Yes, my lord, I'll provide that, my lord. Now, since the bank officials have violated the interim order, my lord, I have been informed and instructed that as a via media, my lord, to settle the dispute amicably, this agreement may be given effect to. That is what the understanding, my lord.
No, my lord, we'll dispute this because we have not
My lord,
agreed for any agreement.
for a moment, my
Let me
lord.
make my submission,
No,
sir.
no, 1 second. I have not completed it. My lord, may I
I am
take the,
not, first of
may
all,
I
I am,
take the,
no, Mr. Counsel, I'm not, I'm only, first of all, what has happened after the interim order is passed is not what the court is concerned. I'm only concerned with on what legal ground you have come before this court.
my lord, I'll explain that, my
Please
lord.
let us go to that.
Before that, my lord, may I read 2 paragraphs, my lord, in the sale agreement which has been
Let's not
produced.
go into that. Please come to the writ petition and what is the impugned order. Why without going
My
to
lord,
the DRT,
my
you have
lord,
come
the
before
impugned
this court?
order, the order, my lord, which under challenge here was the possession notice.
Yes.
Subsequently, during the pendency of the writ petition, they have taken the physical possession.
All 13(4) notice, why should this court interfere? What are the compelling reasons without you availing an alternative remedy coming to this court?
Not on 13/4, my lord.
That is the prayer.
As on the date of filing of the writ petition, my lord, that was the prayer.
We are only concerned with that. We are only concerned with that.
My lord, subsequently, there are several transactions or incidents happened, my lord, which are not in dispute. On 29/10/2025, my lord, during the pendency of the writ petition, they have taken the physical possession. That is not in dispute by evicting all the 8 tenants, my lord. That is not in dispute. And the even the auction notice, my lord, which is scheduled on 26/11, no notice has been issued to the petitioner. That is also not in dispute. The third aspect is, my lord, in spite of the interim order granted by this honorable court on 25/11, 26/11, without adhering to the interim order,
Was
they
the
have.
respondent, was notice given to the respondents?
Pardon, my lord, it was long pending, my lord. It was pending matter.
Was the respondent there when the interim order is granted?
On that day, he was not there, my lord. On that day,
He entered appearance by that time.
yes, yes.
Is it so?
Yes, my lord.
We had
Kindly
entered-
appreciate the order sheet, ma'am.
1 minute.
Please, please.
My lord, we had entered the appearance. First date of hearing, the interim order was not granted to them. So we took the possession and thereafter.
Did you take the possession?
My
Is
lord,
the
the-
question.
29th October.
29/10, ma'am.
29/10.
29/10. When is this interim order?
Interim order is on 25/11.
Then,
My lord, after taking the physical possession, my lord, they fixed the auction to be held on 26/11.
please come to the interim order passed by the
Please,
the
ma'am.
previous bench.
Please, my lord.
Please read it.
Please, my lord. It is submitted by the learned counsel appearing for the petitioner that the e-auction notice has been issued. My lord, on that day, I had produced a memo quoting that e-auction, my lord, that is not taken on record. It is part of the records, my lord. Subject matter in which the claim made by the respondent bank is nearly 3 crores. In this regard, he referred to the possession notice. It was referred only the earlier notice only, my lord. Produced at annexure F and further submitted that the petitioner is ready to pay. This was my undertaking, my lord, based on which the interim order was granted, my lord.
My lord, let them not confuse this.
I am not confusing anything. It's all on record, black and
stay
white.
of annexure.
Why should I confuse?
There is no stay of annexure. If there is no stay of auction. It is only if any
Annexure if it is
precipitative
stayed
action
also,
is
it
not
was.
taken. It is not, there is no stay, my lord, of the auction. My lord, they'll move it at 10:30. The matter will come up at 2:30. That has not been informed to me.
If I may read the second paragraph, my lord.
I've seen this matter.
Still, my lord,
No,
the
from when
council
it is-
argues that there is no interim order.
No, from when this matter is pending before?
My
How
lord,
many
this has
times?
been filed on 19/8/2025, my lord.
19/9/2025.
19/8.
19/9.
Sorry, my lord.
19/9/2025.
19/9 was the first when it came before the court.
So
my lord.
no interim order is granted on 19/9.
Earlier, what had happened, my lord, when the matter came up,
15/10, this court has adjourned to the
I'll
respondent.
just explain, madam. On 19/9, what had happened? The respondent advocate submitted that there was no bidder and no auction will be held. Hence, my lord, the matter got adjourned for filing their objections. Till today, they have not filed the objections. In fact, my lord, I concede to that the copy was not served by the earlier advocate. I came now. I have given the today only. I have served the writ petition papers. That is also not in dispute. I am not on that, my lord. I am only seeking, my lord, a compassionate order, my lord, by this honorable court to consider that sale agreement, my lord, and based on which, my lord, the 8 families will be saved, my lord. That's the only.
That I will not grant. Because that is beyond the scope of this writ petition.
My lord, in that event, my lord, I may be permitted to read 2 paragraphs, my lord, in the sale agreement, my lord. My lord, at page 6 of the sale agreement, my lord, which is produced along with the memo today.
Yes.
Paragraph 5, my lord. I may be permitted to read. Page 6 of the document. May I read it, my lord? The vendor had availed a housing loan on the scheduled property with ICICI Bank, ICICI Home Finance Limited, and after the deliberations with the bank officials, that is one Sri Chandramouli, who had introduced the vendor to the purchaser herein, and acting on the said representations, the purchaser has agreed to purchase the scheduled property on the following terms and conditions. My lord, this is the day on which the previous day of the auction, my lord. The bank officials only took us to a subsequent intending a purchaser, prospective purchaser, and
Council, what is this agreement?
No, my lord. We
Have you
discussed
conducted
this.
the auction or not?
We have conducted the auction.
Who is the highest bidder?
The
One participant was there, only 2 participants.
only one, how many participants were there? One participant, my lord. They have quoted the 2.1.
No, if it is one, you will go ahead with the auction?
My lord, that was the.
No, as per the rules.
It is not concluded, my lord. We have not concluded.
No, you
That
have
is
to
what
again call for another notification. You have to issue another notification. Is it not?
They have not, it was an online bid, my lord. Bid has
What I
come.
am saying,
We have
only
not
one
confirmed.
bidder has turned up. With that, will you
We have
conclude
not
the?
concluded the.
So you have to again issue a notification, isn't it? So as
But
of
we have
now.
not concluded.
So
That
as
is what
of
my
now, no
submission
auction.
last date of hearing was.
Again you have to call for the auction note. Yes. So unless and until you file an affidavit before this court.
I'll file it, ma'am.
And by giving the dates.
Please.
We will not now let whatever is the interim order is there, let it continue.
My
Till
lord,
the next
my-
date of hearing, I'll list this matter on next Thursday. By that date, he files an affidavit saying that he'll pay that whatever 3 crores, that is 3 months, December, January, February.
Please.
Then we'll grant, otherwise I'll dismiss the writ petition because there are no grounds.
My lord, may I make one more submission? According to that direction, my lord, I'll file the necessary affidavit or undertaking, my lord. My only apprehension is that the 8 families, my lord, which are literally on the streets, my lord.
If you file the affidavit tomorrow, I will take up day after tomorrow.
Please, my lord, I'll file it tomorrow itself, my lord.
I'll take up day after tomorrow.
Please, my lord.
On 19/9/2025, not 19/9, on 25/11/2025, an interim order is granted recording the submission of the petitioner that he is ready to pay an amount of rupees 1 crore per month and the outstanding is 3 crores. And the court has passed an order that if the no coercive steps shall be taken. If the possession is taken, it may be restored to the petitioner forthwith, subject to the undertaking given by the counsel for the petitioner. Admittedly, no affidavit, no undertaking is filed by the petitioner so far. Land counsel appearing for the petitioner submits that the bank has entered into an agreement of sale.
No, no, not the bank, my lord. Not the bank. The petitioner, with the consultation of the bank official.
The consultation of the bank has entered
Please,
into an agreement of sale, which is denied with the land counsel appearing for the bank, and this court has not inclined to go into all those issues. If the petitioner files an affidavit by tomorrow about the payment of 3 crores, is it the outstanding or anything else?
Outstanding.
3 crores. If then the orders will be passed by this court. If the undertaking is filed by tomorrow, list the matter day after tomorrow. Yes.
Till that period.
Interim order earlier granted.
No, no.
They're not doing
that will be
anything.
extended. I am not on that. I am only asking, my lord, till that period, they should not conclude the.
It is, they have to, how can they conclude? Land counsel appearing for the bank submits that on the auction dated 25th.
Record ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅದು ಕೊಡಿ sir.
On 25th, 25, 11, what is that?
My
File
lord,
it
26,
while there
11,
is
my lord.
the.
I'll file it in the
Oh,
register.
yes.
Yes.
It is submitted that only one bidder has participated. Again,
Record
they have to call for the fresh auction.
Please.
Lord, what they are quoting, they are contending that 8 families, they are tenants, my lord. My lord, now they,
We
if
will
they
not
want
go
the
into all
possession
that,
back, they have to
provided-
make the substantial payment, my lord.
No, that's what, the first, whatever it
Please,
is,
please.
tomorrow, if you're filing an affidavit, provided you pay 1 crore first, on that, the provision will be restored. The remaining one crore, I mean, remaining 2 crores within 2 months.
Please.
Serial number
Yes.
11, Vijay Kumar.
What they say?
Instead of works, they have mentioned workers. But they have declared as workers.
It is the company. Company is made a party.
You made only a corporation of the company.
No, he says, no, K. Srinivas, proprietor of so and so.
They mean that the company itself is also a party.
You can as well do it.
Sorry.
It's not worker. They want to say the company. So instead of now you have to so and so company represented by its proprietor should be the cause title. Do it. You said K. Srinivas, son of late so and so, proprietor of so and so. It should have been SLOP, Gypsum Sales and Works, represented by K. Srinivas, it's so and so. That's how, that you please carry out the correction. Office objection with regard to the array of the third respondent is upheld. The petition shall carry out the necessary amendment. Yes.
On merit, my lord.
What is question before this court?
My lord, the third respondent is the owner of the property. But there is a SLV, POP and gypsum sales work. There was some factory, now it is closed. He is the owner of the property, 1,250 square feet of the property. But he has taken the loan.
Without notice to none of these respondents, I'll not pass any interim.
Please, my lord, just my lord, because the matter is very serious and also, just my lord, lordship may kindly permit me only 2 minutes. I will explain. My lord, if it is a fit case for granting the interim order, lordship may grant. Otherwise, I have no problem. Just because I brought it.
Thing is, I will take up this matter after 2 days. You please serve the notice on the respondent. The whole chaos that is all this created is granting interim orders without notice to the respondent.
I understand.
So please serve the notice. The petition is
One
permitted
request,
to
ma'am.
serve
One
and summons on the respondent and shall file a memo to that effect. Once the memo is filed, list the matter. Yes. And that also by the next date of hearing, we shall carry out the correction, the amendment.
My lord, one minute. My lord, the third respondent hand over the position to the petitioner. Now the petitioner in possession of the property from last 1.5 years. Now they put an action of the property. Tomorrow, my lord, at 3
Any
o'clock.
auction notification is issued.
No, they are not issued any notice. The third respondent colluding with the first and second respondent. My lord, just a per minute, my
Well,
lord.
if all these illegalities which you are stating, if they are correct, even day before, day after tomorrow also, we'll put the clock back.
It is true, my lord. What happened? Actually, my lord, after the hand over, only 1 second, my lord, because my lord, they are all 3 persons are ladies. In the house, my lord, if the
Whatever of the
clown from the,
submissions that you are making, I cannot take it on its face.
my lord, grant only 1 minute, my lord. Great respect, I am requesting honorable court. Only 1 minute, my lord. What happened? The third respondent hand over the position to the petitioner after taking 50 lakhs. But what happened? The petitioner father is a taxi driver, is a cab driver, and the mother is a maid servant, and the petitioner is working in some of the private working, and the daughter studying a BCom, MCom, sorry. Now, without the third respondent colluding with the first and respondent, he has taken 72 lakhs from the first and respondent, the third respondent, taken the loan, mortgage loan from the first and second, 72 lakhs. Out of which he has paid more than 72 lakhs, already paid from 2017 to up to 2022. Now, when the property was sold to the entered into the agreement with the petitioner, the petitioner paid to the bank till August 25th, 25 of this year, 83,100 rupees every month.
The property which is mortgaged to the bank is purchased by you.
Yes, he is not telling anything about the mortgage of the property.
That is not the problem of the bank or the financial institution.
That's correct. That's why, Lord, the petitioner ready to purchase the property, and whatever the amount dues to the bank, the petitioner also ready to pay.
Can such an order be passed? Can the bank give back the property to you when he has mortgaged the property?
But that's why, my lord, I made a party to the proceedings. If the petitioner, the
Yes,
respondent
please,
comes,
please, to do this, it will not.
the
change
hand
the-
summons, my lord.
That's what I said, hand summons.
Hand summons and give me the date.
Once the memo is filed, it will be listed, yes.
Chair number
Next.
14, Kaushika, you.
Beg to appear for the petitioner, my lord.
Yes.
Lords, the case in hand is the abuse of the process of law, my lords.
Let's know.
I'll walk through the.
Morning, have you heard the arguments of Mr. Redambra that you started straight away on?
Please,
Yes.
Lords, I am challenging the impugned auction notice, my lords. The whole case is that, my lord,
Come to the cause title.
please. Lords, R4, I have made a party only to seek necessary direction to dispose the matter as early as possible. I have made the state commission a party to dispose of the matter. There is one matter pending. I'll walk this honorable court through, my lord. There is a voluminous petition. Lords, 2021. The Lordship may turn to list of dates, page number 1. 2021, the petitioner herein takes a loan to start up a business under Pradhan Mantri Employment Generation Program. The whole scheme here is there is a 15 lakhs for purchase of machineries and 5 lakhs of FD, which will be compensated back by the central government, and 10 lakhs of ODCC account. Thereafter, my lord,
You have taken 37 lakhs, 5,000.
please, no, my lords, that is a valuation. The number 3 is valuation of my property.
You have taken 20 lakhs, 50,000.
That is subsequent home loan. Now, my lords, by what happens is, in 2023, in the month of February, see, about 6.5 lakh is debited from my account. That is, they call it as chargeback. I have a POS machine, which is a card swiping machine. The bank illegally deducts 6.5 lakhs from my ODCC account. That is where my account falls into NPA. Now, there was no notice given to me, my lords. It is all illegal. It is not even matching with my invoices. Mine is a counter sale business. I have sold the goods in counter sale. Bank says they have been charged back for not receiving of goods. Ideally, the people who would have sought for refund should have gone for the consumer court. Now, bank has illegally debited. I make representation. I send them a legal notice. I say this is illegal. You should not have debited and made my account fall into NPA. Thereafter, they bat no eye. They start the proceeding. They issue the notice. I go before the jurisdictional consumer court. My lords, I have won the case before the state consumer, and now the bank has now got an interim order of stay before the state commission. That the consumer forum has held that
all the deductions is illegal and directed the bank to refund. My lords, my whole life is destroyed by the action of the bank. My lords, my whole factory is now shut down. I am out. I've had to go for daily labor to earn bread. And subsequently, I've also approached the DRT. There was an order to pay 5 lakh rupees. I've also paid that sum of 5 lakh rupees. Now, my lord, the case in hand, I will let this honorable court. The housing loan, my lords, the sanction date is 33/2022. Total repayment months is around 30 years, my lord. Monthly EMI is around 14,205. Even to this month, my lords, the actual amount that I had to pay to the bank towards the housing loan is 6,25,000. Total amount, including the compliance of the order of the DRT, I have paid 8,10,000, my lord. My
Now,
lordship,
what has happened before the State Consumer Forum?
it is stayed by the State Consumer Forum. It is pending before adjudication, my lord. This
Then
is
how can you take this FSA proceedings further now?
No, my lord, there is no bar for me.
No, but 13-2, when they said, no, they say that the declaring the asset as NPA is bad is what is the order of
No, sir, my
the.
lord, I'll just point out, my lord. There are two loans. One is housing loan, one is, my lord, some OD. Even OD, my lord, till today, my lord, it is NPA only. It is not, my lord, regularized. He gone before the district forum, sought some order against me. Wherein, my lord, pursuant to that, my lord, Honorable State Commission stayed the proceedings. It's not a dispute. Now, as of now, my lord, the district forum order will not have any, my lord, effect. Now, my lord, in respect of, my lord, OD, maybe my friend is right, arguing, saying that, my lord, my housing loan is account is regular and I am paying up to date. That is, my lord, in OD, is already, my lord, account is NPA. Then, my lord, either he has to, my lord, he has to clear the OD and then he can say that my housing loan is regular. Therefore, now in this juncture, the sale notice which is sale before this honorable court. Earlier rounds of litigation, my lord, they filed an essay before the DRT, he suffered an order. Now, my lord, all of a sudden he can't come before this honorable court saying that, my lord, you are wrong. He can't say. The reason is this.
What happened after the order passed in SA?
Then pursuant to that, I issued a sale notice. This present sale notice,
He
which is
didn't
assessed
question
before
it?
this honorable court. He didn't question it.
my lords, that order was passed in 23 and 24. Subsequently, the bank is very well aware that
No.
this
The State Commission, District Commission's order is stayed with the State Commission.
please.
As on now, you are in the same position as you were on the day the SA order is passed.
Please, I'm in the same position. Now, my lords, the auction notice is passed. My lords,
What is that amount of outstanding?
Lord, my instruction today, Lord, I got instruction pursuant to my Lord, 21,35,000. They told me orally, as on today outstanding. 19 is the auction. Some money if pays, my Lord,
My lords,
I leave to.
the question here is, my lords, it is an illegal chargeback. That has to be properly adjudicated, my lords. Pursuant to that, I've already approached.
Adjudicated, and if it is found that they have illegally done it, it will be, that steps will be taken. As of now, there is no order in your favor, saying that NPA is bad.
That order is.
Because it's stayed.
Is stayed.
Stayed by
My lords,
the
pendency
State
of that, they should not press and
Unless and
coerce me,
until
my lords.
substantial, some amount substantially
Lordship,
is
I've
paid.
already paid 5 lakhs before
The
DRT.
property is
my
only
lords.
14,24,000 rupees, my Lord, which I indicated.
How much?
Lordship, the valuation report.
14,24,000, which I am indicating. Substantial money may be deposited, my Lord.
Lordship, that is also the abuse, my lords. My valuation report is there. My valuation report says it is 37 lakh worth of property. My lords, my humble submission is because of this chargeback, my lord, because of this OD being freezed, my whole business is shut down, my lords. And despite that, I have approached your DRT and I have paid 5 lakhs. Currently, my lords, my housing loan, I have myself paid excessive of 2 lakhs. When it was NPA, my home loan was regularized. Now this ODCC is by.
What is the scope of adjudication by this court?
Lordship, one is that direction has to be
The
given for
only
that.
thing to whom?
The respondent number 4, the State Commission to dispose of the matter at the earliest, my lords.
That I don't have any objection. My Lord may pass an order, will definitely will
And
assist
then,
the
my
honorable
lords,
court.
meantime that, my lords, I have a order favoring me, my lords. That has to be, I mean, some order of stay has to be granted by this honorable court, my lords, because I am.
You have to ask the State Commission to vacate the order, then automatically the other things will follow.
Please, my lords,
As long as that order of stay is there by the State Commission, we can't pass any order.
My lords, mechanically State Commission passes order for anyone who has.
When was the order passed for the State Commission?
It was order passed.
You should have filed a caveat before the State Commission.
Lordship, the client had approached me the last week.
Not you. That's about your client. When we are
Please,
referring you
well,
means your client.
He was not really
given, the proper advice is not given, my lords. This clearly falls on this
Now,
jurisdiction,
now
my lords.
then we'll do one thing. I'll tell the state commission, I'll ask the state commission to hear your vacate petition.
I don't think any vacate petition before the pending before the state commission.
Please,
You're
we
fine?
can't. My lords, it is only one, my lords, in state commission, the proceeding is only two hurdles. One
then
admission and
let it
final
be
hearing.
Not direct the
1 month, within 1 month,
Please.
then until such time.
interim order, my lord, unless either he has
Please,
to,
my
my lord,
lords.
as of now, my lord, there
This
is
is
no
a
bar for me
illegal
to-
chargeback,
No,
my
I'll
lords.
just point out, my lord, as of now, there is no bar for me to, my lord, initiate the action. DRT, my lord, already affirmed
The
my all
whole
the actions.
basis for
13
you,
to 13
the whole basis for you to initiate the proceedings under 13(2) is that because his account has been declared as NPA.
Please.
Such that whatever exercise that is done by you, the state commission said it is bad. I mean, the district commission,
That is, that's, my lord, that is a.
the calculation,
No.
they've
that,
made
my
the
lord,
calculation.
Now, as of now, there is no order from the district forum because there is a stay operating against the order made by the district forum.
No, we are
DRT
directing,
affirmed my
no,
all the
we are
actions.
directing the state forum to dispose of this matter within 1 month. Immediately after that, whatever steps you have to be
Look,
taken,
my
because
only-
it is,
my-
amount
my-
is not a substance. Please concentrate on the defaulters who are running into crores of rupees, not the small one, people with 40
My
to
lord,
50.
some money may be.
My damage, my lords, I had to
Some
shut
money may
down
be
the business.
deposited with me, my
I have
lord,
run
so-
to a loss of tune of around 50 lakhs, my lords. I am now doing daily labor, my lords. My whole factories, the whole, my lords, the whole intent of the Pradhan Mantri Employment Generation Scheme, my lords, it is ousted here because of the bank action, my lord. I have made representation. I have sent them a legal notice. They have not given any clarification. Ideally, my lords, there should be some kind of remedy for me, my lords. That is the reason I have reached the consumer forum. At this juncture, my lords, issuing the auction
Let's see the
notice,
consumer forum order,
annexure P, my lords,
page number.
page number, annexure P. Just a second.
Page number 81, petition.
Page number 301, my lords, 301. It's a voluminous petition.
Come to that particular finding.
Please.
About how the forum has said it is bad.
Please. Please. Now the, my lords, issues. I'll start with the issues.
Page number
Page number 317.
17.
317. 317.
Oh, it starts with, oh, it's essay. order.
81.
Yes.
317.
Yes.
Whether the opposite parties prove that the complaint pertains to the commercial transaction to the commission lacks, this has been answered. Second, whether the complaint proves that the opposite parties have committed deficiency of service. I'll go to that reasoning, my lords. Point number 4. As the ODCC page number 319, my lords. As the ODCC facility was sanctioned under the PMEGP scheme, the complaint's business falls within the execution provided under Section 2, Clause 7 of the Consumer Protection Act. In light of this provision, the complaint qualifies as a consumer under so and so. It is undisputed that a complaint was provided as the POS, point of sale, which is a system that allows business to accept payments from the consumer through debit or credit card transaction using so and so machine. This POS facility was linked to the complaint's ODCC account. Meaning that whenever consumers swipe their debit or credit cards to the POS machine, the corresponding amount was directly credited to the complaint's ODCC account. Thereafter, the point number 6. In the present case, the complaint was facilitated with the physical POS machine, which requires the customer's physical presence to complete the transaction. Customers must swipe, insert, or tap their debit card, which authentication finally happens on PIN entry or signature. However, the complaint was not provided with an online virtual POS facility. This is very important to be noted because it is, they say, goods unclaimed. Thereafter, the complainant alleges that the bank, without his consent, directly debited rupees 6,36,371 from his ODCC account, exceeding his limit upon 10 lakhs and raising it to 16,96,000. Upon discovering the unauthorized debits, the complainant immediately ceased transaction through the swiping machine and reported the issue to the bank. Despite repeated oral requests and formal complaint dated 28/2/2023, the bank failed to rectify the error. A legal notice was sent on 6/3, which was received by the bank on 7/3/2023, but no corrective action was taken. Instead, the bank allegedly ignored the complaint continue to charge the interest on the excess debit and eventually declare the complainant's account as NPA. Then the complaint contains that the bank inaction was wrongful debiting, accounting constitute deficiency of service, unfair trade practice causing him financial loss. It goes on, my lords.
Come to paragraph 20.
20. Despite the clear discrepancy in card details, the opposite party bank failed to verify or reconcile the inconsistencies before debiting the complaint's account. This lack of due diligence on the part of the bank demonstrates negligence and deficiency in service, further substantiating the complaint's claim. Furthermore, a so-and-so exhibit clearly establishes the complainant had submitted tax invoice copies of the actual transaction to the PaySwift service provider. Despite this, the opposite party claims that the complainant failed to provide the required documents to PaySwift, leading to the chargeback process, subsequent debiting of the complainant's ODCC account. This contradiction highlights the baseless nature of the opposite party's contention and demonstrates that the chargeback was processed without proper justification, further indicating deficiency in service on the part of opposite party. It is pertinent to note that the chargeback was initiated by the opposite party bank based on the assertion that the complainant
26, paragraph 26.
26. In light of the above discussion, it is evident that the opposite party has committed deficiency in service by debiting the complaint's ODCC account without providing fair opportunity to contest the chargeback, the failure to verify discrepancies in transaction details, the contradictory statement regarding the basis of the chargeback, and lack of due diligence in resolving the complaint's grievance further reinforce the arbitrary and negligent actions of the opposite party.
Liable to recredit 6,36,317 to the complainant's account along with 10% interest per annum from the date of respective debits. Liable to pay 1 lakh as compensation for mental anguish, 10,000 towards litigation expenses.
The damage cost, well, as 1 lakh is really meager. I'm actually giving up my 1 lakh there, and I'm seeking liberty to file a suit for damages because I've lost the complete business, my lords. My annual sales was more than a crore.
Lord, attending sale is on 19th. My lord, sale is on 19th. I have only one submission. Sale is on 19th. I'll take a my lord complete instruction. The reason is this, my lord, morning they served a copy. In fact, complete setup document is not served. I'll take instruction. What is the state commission present position? I'll make a submission. Sale is on 19th. We have time. Today is my lord hardly 8. So, my lord, have it.
This is the matter on 18th.
By the time I'll take it.
Matter on 18th, by the time land council, that time no arguments, whatever instructions we can.
No coercion, because I'm still in possession, my lords. They don't have physical
Auction is on 19th.
Please, my lords,
19th will take up this
meantime,
matter.
they're coercing me that they'll take the physical possession before that.
This is matter on 19th. This is matter on 18th. It is submitted that the auction is scheduled to be held on 19th. Considering the order that is passed by the district commission, holding that the declaring the debiting an amount of rupees 6 lakhs and odd, and declaring the account of the petitioner as non-performing asset is bad. The respondent bank shall not take any coercive steps till 18th.
Respect of only position and the money.
With regard to possession.
Grateful, my lords.
Cell number 32. 32.
Yes.
Good morning, this honorable court. Asked me to file an affidavit. They said that the amount will be mentioned.
47 lakh, my lord. In fact,
How much?
Just 47 lakh.
47 lakhs.
Plus, we have filed a suit before, my lord, if required to regularize, I have to withdraw the suit because before the DRT suit I filed, and I spent some expenses while taking the position of a property. That he has to borrow. That, my lord, I have to compute it. 47 lakh is as on today outstanding.
Then when will you inform him? Or else on the next date of hearing, when you inform the court, will say that amount shall be in the last installment. When are you going to pay this?
Anytime, Lord, because we paid 12 lakhs just before they took the position.
No, this is deducting that amount.
Yes, my lord, that they have directed that. That's what they're saying.
So, how many months? 3 months?
3 months I will do that.
By March.
Either he has to pay some money because the reason is this.
Some money will
Sale
do that.
notice which I published in the newspaper.
When is the sale?
Sale cancelled.
My lord, my lord, the other day, my lord, kindly recollect, my lord, I considered before this on. But if any possibilities we'll regularize, we'll regularize. And my lord, my bank has agreed to regularize the loan. My lord, in fact, the total outstanding is, my lord, 2,12,43,224.
So
And
this is the amount for regularizing the account.
Regularizing.
As on
Yes.
today, 47,05,000. If he's paying some money, my lord, at the earliest, at least in the next week, because my lord, last.
No, that's what we'll say. First installment would be this month only.
Yes.
First installment would be this month. So 47.
47,05,000 rupees
So
plus suit filing
in
expenses and
three
recording.
installments, first installment would be in this month, in the month of December. Remaining Jan and Feb. In the Feb installment, whatever you say, the amounts for your suit
Expenses,
expenses, that they will include in the last installment and pay. Land council for the petitioner submits that they're ready to, in fact, they approach the bank seeking a one-time settlement, and the bank is not coming up with the exact amount. Land council appearing for the respondent bank submits
One-time
that.
settlement is not possible. One-time settlement is not possible. Only we can regularize.
For regularizing the account, the bank is not coming forward with the amount. Land council appearing for the bank, respondent bank submits that. The amount as on today, outstanding amount as on today is 47 lakhs.
The
It is-
outstanding, my lord, is 2,12,43,224.
For regularizing the
For regularizing.
amount that needs to be paid is 47 lakhs.
5,000.
5,000. It is submitted that the bank has initiated had filed a suit, and also they have initiated the proceedings on the Surface Act. Whatever or the incidental expenses for the same, that also the petitioner needs to pay. That they, on the next date of hearing, he would be indicating what exactly is the said amount. The petitioner shall file an affidavit before this court. And before this court about the 3 months payment, about the time that he is seeking, for payment of 47 lakhs. The first installment shall be in the month of December, second in Jan and third in February. And in the February installment, whatever are the incidental expenses that are incurred by the bank, that should also be paid in the last installment. List this matter on when.
Day after tomorrow, my lord, I will consult him and I will file the affidavit. Day after
But
tomorrow.
by the time whatever, when the court is passing an order, immediately within 2 days, 3 days should be the, the date. for the first
Initial sum make, the first installment within this month only I will make, my lord. Initially, I will make some payment because they have locked the premises. That is the reason why. Let them open it, then I will do that.
Pay the first installment, they will open the lock.
Oh.
List this matter on 15th of December.
Much
My lord, there are buyers.
Hmm.
After passing an order basket, but we said we'll not, my lord, that's what we did.
List this matter on this 15th December.
Much
Yes.
Cell number 44.
40?
Husband petition against the interim order passed in BNM 144 of BNSS Act.
Hmm.
And wife is BE.
How much is granted?
25,000. Wife is a BE electrical and electronic engineering.
Is she working?
She is not working. At her contention, she is not working. And after the marriage,
How much the salary of the?
1,60,000.
There was a difficulty to pay 35,000.
No, it's nowhere in the petition. She stated that she is unable to work. And there is no awareness in
We will consider once the respondent enters appearance, because
No.
if it is a difficulty to the petitioner to pay the amount,
No.
we will grant interim order.
We-
But it is not difficulty. It is about, according to you, the entitlement of the wife. That we will decide after hearing her.
None, because matter is posted Wednesday, and there is FLW is also issued a large.
You should have paid it. by this time.
Conditional order may be passed and subject to result.
No, but your salary is 1,60,000.
60,000, 1,60,000.
1,16,000 or 60?
1,60,000.
Then 35,000, what is the difficulty to pay?
She is not, she is qualified. Instead of working, she joined as a political party leader, and she is the executive committee chairman of the BJP party now, after she left the
I
matrimony.
understand that we can only do provided the respondent enters appearance. We can
I
only
mean,
grant interim order on if you are not in a position to pay. You are in a position to pay.
Position is not disputed, your lordship. Only the,
Take out
I'll pay the 15,000, from the the order is from application from the May 2025. I'll pay it, but amount may be reduced, Your Lordship. Deposit the amount. From the May 2025, I need to pay the amount now from the date of application. And conditional,
It's only hardly, not even with that's 1 year salary, 1 month salary of yours.
that is
arrears.
true, Your Lordship, that Mary, I mean,
Just because you have a right to come before the court, court will not let him, he has the money,
I will-
let him pay.
I'll pay, I mean, Your
Notice to
Lordship,
the respondent, petition is permitted to take out hand summons.
then I
Yes.
may be permitted to serve the notice to the
Yes,
trial
yes,
court,
yes.
trial court advocate also,
Yes,
Your
yes.
Lordship.
Cell
Yes,
number
next.
62,
What is that number?
62, continuation of this. Cell number 62,
Yes.
Here for the petitioner.
Mm.
No, the petitioner is a borrower. He's
Where
a,
is the counsel for the respondent? Vignesh Shetty. He was here only just now. Any interim order in your favor?
no interim orders. It's on, in fact, withdrawal of OTS, though I have made the first 2 installments, the OTS was withdrawn because I could not comply with the remaining payment. My request from day one, even before, by negotiating the
Have you
OTS,
filed their objections, respondents?
no, they have not filed their objection.
Where is he then? Suddenly disappeared. He was in the court.
It's a short point.
That's what.
Yes.
If the counsel for the
Correct.
respondent is
I
also
understand.
here,
Yes, yes.
we'll be able to hear that. Inform him. I'll call the matter.
Great.
Yes. Next.
cell number 63, T.S. Venkatesh.
Petitioner in this case, Your Lordship. I'm challenging the order passed by in GNWC matter, Your Lordship. In this, the child visitation right has been granted on first and third Saturday, Your Lordship. Because the child is only 3 and this is a female child. I'm the wife of mother, Your Lordship. The respondent is the husband, Your Lordship. Petitioner is a Muslim and the respondent is a Hindu.
Respondent is a
Hindu. Hindu and petitioner is a Muslim, Your Lordship. Then this child is only 3.5 years old, 3 years old, Your Lordship. There is a female child. So,
Where is the order?
May I request your order is at page.
To meet his minor daughter.
Minor.
Child's visitation room. What is wrong with this order? Whatever is the age of the child.
Yes, Your
The
Lordship.
father has every right to meet the child.
Yes, no, Your Lordship, Your Lordship, kindly appreciate, Your Lordship. This petition is, after nearly 1 year, they have filed this reply, Your Lordship. No, what I'm trying to say, Your Lordship, if he has very much interest in the child, he could have approached the family court on the very instance itself. Nearly, they have taken most a year time to file the objections and also this application before the trial court, Your Lordship. In that context, and moreover, Your Lordship, may I while before conceiving, petitioner is some little bit hair loss and all these things, Your Lordship. He was not interested that she should conceive the child. He was very much against that point also, Your Lordship. In that she was very much not interested in the child. So, and moreover, 3 years child, Your Lordship.
If he doesn't meet the 3 years child now, she will forget who is the father.
I can understand. That
Totally
point.
false. It's a low.
No arguments are required in this. Yes.
I can understand that point, Your Lordship, but the question is that
And the court has granted the visitation room. No inconvenience to the mother also. That is given in the child visitation room. Child visitation room.
Oh, yeah, yes, Your Lordship, in the mediation center.
Please come.
In the mediation center itself, Your Lordship.
Agreed with-
Name date.
Agreed with the orders passed.
That, at page number 21, Your Lordship.
I have seen that.
That's the
Agreed with orders passed in number 5, where the court had granted visitation to the minor daughter in the child visitation room on every first Saturday and third Saturday from 11 a.m. to 1 p.m. The mother is before this court. Learned counsel appearing for the mother submits that the age of the child is 3.5 years. In fact, the father has taken time to file his objections for about 1.5 years, which clearly shows that he has no intention to meet the child. It is submitted that when the father doesn't even want the mother to conceive and he has not treated her properly. On all these counts, the father is not entitled for the custody of the child. And further, the court ought not to have granted the visitation on every first Saturday and third Saturday to the father. Next one, land counsel appearing for the respondent submits that the court had rightly, considering the facts and circumstances, has rightly granted the visitation to the father. There are no grounds to interfere. Next, having heard the counsels on either side, there is a material on record. When the father has filed an application seeking visitation, the court had granted visitation on first Saturday and third Saturday from 11 a.m. to 1 p.m. at the child's visitation room at fourth floor of Nyaya Degula building. The submission that is made on behalf of the mother that the girl is 3.5 years old, or the father has not treated the mother well while before she conceived or after she conceived, comma, that he has not filed the objections on time. All these reasons, these are not the reasons for this court to interfere with the order passed by the family court. When both the parents are living separately, in view of the differences between the parties, the non-custodial parent has a right to have the visitation of the child, and the family court had rightly appreciated and passed the order. This court do not find any reasons to interfere. Accordingly, dismissed.
Cell number 64. Satyap Kesi, Suresh V for respondent.
64, my lord. For respondent, the petitions, my lord, poor lady, my lord, her residential house, my lord, has been now, my lord, under Surface Act. Total outstanding, my lord, is 6 lakhs, my lord. And
How much?
loan was taken 6 plus 52.
Hmm.
The outstanding as of now, my lord, 5,37,000. Lord, the house property which has been granted to her by the government, my lord, under the, my lord, the homeless scheme. Now, my lord, they have taken the possession. They have now issued them, my lord, the possession, my lord, the sale notice saying that, my lord, on 21/8, not any other date, they will auction the property. I would only submit, my lord, subject to, my lord, payment of 50%. If lordship, my lord, grants stay, my lord, within 1 month, my lord, will pay the 50%.
My lord's total outstanding is 8,63,752. On 31/5/25 position has been taken, my lord.
8 lakh?
8,63,752. 52 as on date. And 31/5/2025 position has been taken, my lord. And 21.
2025.
Yes, my lord.
It's been long back.
Long back they have taken. Thereafter they issued them, my lord, the sale notice. They say that, my lord, 21/8.
No, after such a long time, no, at this point of time, we will not ask for redeliver of the possession. Whatever amount you pay now, and when you are going to pay the next amount, then that day we'll list the matter, and then we'll pass out.
My lord's one more. On 21/6/2025,
Let the auction may not go on. When is the auction?
Please. They say any day, they, my lord, they say any day, my lord,
on
not particular.
21/6/2025, they have trespassed and they enter the property.
Enter the property.
Yes, my lord.
No, when is the auction scheduled to be held?
Still, we have to take back the position, my lords.
Oh, then you are on the steps to take back the position, record the position.
Yes,
so when are you going to pay?
Lord, 1 month, not 50%, not. Lord, as of now, Lord, in the petition,
No,
they say,
50% now, remaining after 1 month. That's what you
she's
said.
a very, my lord, 1 month, my lord, 50% will pay it not within a month, my lord.
Huh?
50% of the, my lord, outstanding, I'll pay it in a month, my lord. The rest of the, if lordship, my lord, gives me some more time, my lord, will deposit. Because, my lord, she's a very poor, if lordship kindly see the photographs. Please.
Let him deposit the 50% of the amount by December.
1 month from today, my lord, 1 month.
1 month from today is not. If it is January 8th.
Please, my lord, please.
Remaining February 8th.
Lord, she's very poor lady, my lord, if lordship
Then
look
March
at.
8th.
Please, please.
So what you do, if by January 8th, if you don't pay the money, let them go ahead with the auction.
50% of that.
The land
File an
council.
affidavit. Let them file an
Let them file, yes.
We'll file it on
They have to return the position, my lords. On 21/6/2025, they have trespassed.
We will pass that order in the month of January. Land council appearing for the petition submits that. The land council appearing for the petition submits the outstanding is 8 lakh.
8,63,752.
According to you?
According to 5,37,000.
According to the land council, the petition submitted the outstanding is
5,37,391.
391. According to the respondent, the outstanding is 8,63,752. When counsel for the petitioner submits that the petition is ready to pay the amount with half of the amount within 1 month and remaining amount by 8th of March. And they'll file an undertaking, they'll file an affidavit of undertaking in that regard, considering the submission of the non-counsel for the petitioner. The petitioner, and on the condition that the petitioner shall pay an amount, half of, what is half of this amount?
Lord, that is, Lord, 2 lakh, Lord, 15,000, Lord, 2 lakh
No, no, no,
18,000
no.
somewhere. Lord. As far as, Lord, my, Lord, the
752,
statement
no.
is concerned.
We will not consider your half. He shall deposit 4,31,876 by 8th of January.
Lord, that,
And the remaining amount, along with the incidental expenses, if any, as specified by the bank, by 8th of March. If till such time, the bank shall not take any coercive steps. On 8th of January, if the first installment is not paid, the bank is at liberty to proceed. The bank is at liberty to take further steps without further reference to this court.
Lord, as far
This
as,
is matter on 9th of January. What is 9th of January?
9th of January, so Friday.
Friday. Yes, 9th of January.
Lord, as for the outstanding this month, that is his same, Lord. Let him file, Lord, the memo of calculation, Lord. So therefore,
Review.
Lord, so therefore, if Lordship would
We
say
will not
that,
decide what is the outstanding amount. That's for whatever
Lord,
bank
let
says.
him give him, Lord, let him place him, Lord, the memo of calculation before this court. Lord, I'll verify it, Lord.
The petitioner.
So therefore, if Lordship would say 4 lakhs, very poor lady, 3 lakhs, Lordship can say, as of now, 3 lakhs.
31,000, how does it matter? 4,31,000
No,
is.
I'm requesting, Lord, if
No. Next installment, when once you come up with all that, we can adjust that amount. 4,30,000. Yes, next one.
Cell number 65, Chandrasekhar L for petitioner.
I appear for respondents, my lord.
Yes.
I am yet to receive the papers. Tomorrow I am getting the written petition copies and the other papers.
No representation, none appears for the petitioner. This is matter after vacation.
Cell number 66.
Yes.
Petitioner, interim order may be extended.
Why? Why should we extend the interim order without arguing the matter?
Lord, in this matter, my lord, in this matter,
Uh,
we have taken the position on 15/11/2025. My lord, in the interregnum, this writ petition has been filed. My lord, they submitted that the petitioner daughter's marriage has been scheduled on 26th of the first week of January. Then court has directed us to consider on equity. And my lord, accordingly, they paid a sum of rupees 7,50,000. We restore back the position. My lord, even my lord, that has not been recorded. Court directed them to file affidavit when they are going to discharge the balance amount. 31 lakhs is the outstanding due. 2 years they have not paid the money, my lord. 2 years installment.
Land counsel for the respondent submits that the petitioners
My
have
client
not
is,
filed an undertaking affidavit.
Brother-in-law
Land counsel for the
passed away.
petitioner seeks time. List this matter on
2 years, my lord, they did not pay the
16th, on 16th of December.
much of it.
By the time an undertaking affidavit shall be filed by the petitioner, if the same is not filed, the stay granted by the court on 24/11/2025 stands vacated.
Much of it.
Yes. Interim order earlier granted is extended till then.
My lord, we have restored back the position.
Huh?
Position, we have taken the position. The position has been
Extended
given
in the
back.
affidavit and
Given back because the court told consider their grievances on equity. We agreed, but they have to pay the file the
This
affidavit.
is on that day. We will again give, you can, we'll
Yes, my
permit
lord,
you to
restore.
take
They have
back
to
the
restore
position.
back the position. 2 years they did not pay the money.
File the next date of hearing, if you don't file the
next date
affidavit.
ಅಲ್ಲಿ affidavit ಹಾಕಿ ಇದು ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ. Next date affidavit given.
Huh? That's what, if you don't file, we'll ask you to give back the position.
If such being the order, they will file the affidavit. Otherwise, they will
Client
not
is a
file the affidavit.
father-in-law is passed away today and not come.
File the affidavit, file the.
Let them file the affidavit.
Yes,
Great,
67.
Cell number 67,
I appear for the
Vaidyanath,
petitioner, my lords. We have challenged the e-auction sale, which is going to be held tomorrow, my lords. My lords, the petitioner is ready to deposit 50 lakhs, my lords, within period of.
What is outstanding?
Outstanding is as per the e-auction sale notice, 94 lakhs, 16,047.
16,097. You're ready to deposit how much?
50 lakhs. If they are undertaking, my lords.
No. When are you going to deposit?
Within period of 15 days, my lords.
When is the auction?
Tomorrow, my lords.
Then?
My lords, if it
On
is
the date of
paid-
auction, unless and until you pay the amount, how can that? Yes, Mr. Vignesh, why are you not appearing in the matters where your name and you appear where your name is not there?
No, it's not, sir.
Yes.
My lords, in fact, the petitioner had earlier approached the bank to settle the amount, my lords, whereas they informed
No,
him
tomorrow
to.
is the auction.
Please, my
What is the amount you're going to pay tomorrow?
My lords, at present, he is arranging funds, my lords. A week time may be granted, or 3 to 4 days time may be granted, my lords. He'll deposit the amount. 50 lakhs he'll deposit, my lords. That is the instruction he has given me.
Then we'll do one thing. We'll list this matter on 15th of December. Or by that day, exactly a week.
Please, my lords.
By that time, if you don't deposit the amount, they'll go ahead with the auction.
10
It is
days, my
submitted
lords.
that.
My lord, in
17th,
serial number 67, my lord.
Land counsel for the petitioner submits that the outstanding amount is 94 lakh 16,000 and all, and they need to pay 50,000. 50 lakhs.
Senior is online.
Your senior.
My lord,
Yes.
I'm sorry, my lord, serial number 67, my lord. My apologies,
Yes,
my
they
lord.
say that they're ready to pay 50 lakhs immediately.
My lord, one submission in this matter is, my lord, earlier round of litigation, my lord, we had passed 13-2, 13-4, sale was also conducted. They never challenged it, my lord. One submission is that, my lord. The second thing is, my lord, in the earlier sale, my lord, in fact, the entire deposit was made by the successful bidder. But, my lord, we had to return the amount because, my lord, possession was not handed over. Now, my lord, now, my lord, we have proceeded and we have issued a second sale notice, my lord. At this stage, my lord, my humble submission is, my lord, they can't make such kind of a submission, my lord.
No, anyhow, you are getting your money immediately.
My lord, they
What
have
is
not
the-
come
why should-
forward. They have not come forward for so many years, my lord.
Anyhow, they have come forward now. Let us give them a
My
final
lord, but let the
opportunity.
sale go on, my lord. Let the sale go on, my lord. Because, my lord,
Or not to
there are,
Not to finalize.
please, my lord, not to finalize. I'm obliged.
It may be given 17th, my lords.
It is submitted by the land counsel, the petitioner, that they are ready to pay 50 lakhs and the remaining amount, if a reasonable opportunity is granted by this court, and the outstanding is 94 lakhs 16,000 and all. Then counsel for the respondent submits that there's a second sale notice, and earlier round of litigation, when earlier the sale notice and the proceedings were initiated from 13-2, the petitioners have not questioned the same, and they have not taken any efforts to pay the amount. Considering the fact that the petitioner is ready to pay the amount, this court is passing the following order. One, the auction scheduled to be held tomorrow, whatever is the date, right, so and so, shall go on. However, the respondent shall not finalize.
My lords,
Number
one submission. Sorry to interrupt, my lords. My lords, in this, the position is also not taken, my lords, whereas they sought permission from the magistrate to take possession, my lords. Whereas their petition was dismissed, my lords, because the postal receipts were
Possession
not.
was not taken?
No, my lords.
My lord,
Physical possession
may
is
I
not
make one?
taken, my lords.
My lord, insofar as physical portion is concerned, my lord, in fact, your lordships, my lord, have passed an order very recently last week permitting us to take possession, my lord. The magistrate had dismissed the petition. Your lordships has allowed my petition, my lord, and my lord directed the magistrate to permit us to take possession, my lord.
petitioner, this is matter on 17th. By
Lord.
17th of December, no, by 17th of December, the petitioner shall place before the court the DD for an amount of rupees 50 lakhs, and when the remaining amount they are ready to pay, that also shall be stated by way of an undertaking affidavit.
Please,
If
E-auction
the
may be
amount,
paid,
the
my lords.
amount is not, if the amount is not, if the DD is not, if they do not pay the amount of 50 lakhs by 17th, by 19th, the petition will be dismissed. It is 17th, the petition will be dismissed on that ground.
E-auction may be stated.
No, no, let it go on.
Then
Yes,
number
next.
68, Sridhar Rakesh.
appear for petition.
I'm grateful.
Yes.
Here for respondent in this matter, my lords.
What is that?
I'm off service.
Memo of service.
Notice to the bank.
No, they're there.
Yes.
You appear for the bank.
Yes, my lords. I filed
Ah,
Wakalat
yes.
this morning.
Yes. My submission. There was a due of 23,66,657 mail.
20?
Lakh 66,657 as on 19/11/2025. Now the
23 lakhs,
66,657.
657.
Mail.
Yes.
Now the petitioner are ready to pay the whatever the EMI dues as on today mail. And the bank regularized it because of 30 years loans mail. Whatever they due till today, EMI, they're ready to pay that.
Lords, it may be taken up tomorrow. I'll see. I filed Wakalat this morning. I'll seek instructions.
Not tomorrow. We'll have it on Thursday. Get instructions. This is matter on Thursday. By the time the respondent.
The action scheduled today, man.
Huh?
Action scheduled today.
What happened to the auction?
There were no bidders today.
It is submitted that as there were no bidders, the auction could not be conducted. List on Thursday.
Cell number
My
69.
my submission may be noted.
Noted.
We are ready to pay the whatever the EMI
Then
dues.
council the petitioner submits that to regularize the account.
Yes, my lord.
Whatever is outstanding till today, they are ready to pay.
EMI, yeah, ready.
Lords, registry may be directed to show my name in the.
NFC.
What is your name?
Vivek is.
So and so
Vivek.
submits that he has filed wakalat on behalf of the respondent bank. Yes, next.
Cell number 69, final hearing. A.N. Krishnaswamy for appellant.
No
Somshekhar.
representation after vacation.
Cell number 70. Cell number 70.
Your lordship, I'm for the petitioner.
Where is the other side?
Respondent told.
You have an interim order?
Yes, your.
Yes, list this matter after vacation, no representation. Oh, this only notice is, this is matter after vacation.
Cell
Yes,
number
next.
71, parted matter.
Yes, what has happened to this?
PG.
Lord, I appeal for the petition. The matter has still not come up
Before the Supreme Court.
Yes, ma'am.
It is, list this matter in the month of February. It is submitted that the matter is still pending before the Honorable Apex Court. Yes. Done?
One passover message.
Which one?
Passover.
Yes.
I apologize for the
Cell number 62.
Pay for the
Bill number?
petitioner, 62.
Yes.
My lord, the borrower petitioner, my lord, is an agriculturist trying to step into the shoes of an entrepreneur, took a loan of about 12.6 crores, about 3 loans with respect to solar rooftop project. Now, when he took the project, what happened was the rates were fixed at 9 point change per unit. By the time the project was set up, it fell to 3.2 rupees, because of which payment schedules were disturbed. But as on date, as against 12.6, 24 crore, 12.6 crore, 24 crore is paid. So they were in talks with the banks also. Bank agreed for an OTS. Now, under the OTS, it was agreed that about 12 crores would be paid, 12.7 crores would be paid as a full and final settlement. But the schedule that was given, there are about 5 properties which are with the bank as against the loan. One is a commercial property. So my only request to the bank was, you release that commercial property first, then I can monetize it, because rest are all agricultural properties. So as against the OTS of 12 crores, I paid 5.4 crores. That is the initial deposit of 2 crores, first installment, second installment. But I did not get this commercial property release, because of which I couldn't monetize the remaining. So the period was over. That is, the 90 days period was given, 3 months period was given for the entire OTS, and that expired and it was withdrawn. So I'm before this honorable court. One is, my lord, a revival of the OTS. I know that I'm before this court against the tides, but the fact is, Your Honor, that I'm not a fly-by-night operator. I'm a very established family, agricultural family. As against 12 crores, I've paid 24 crores as on date. And I'm willing to pay under the OTS. All I'm asking is, you please revive the OTS, give me a time structure, a little more reasonable time structure, release the commercial property first so that I can monetize. That's all my request is.
You can come to the relief sought before this honorable court at page number 32 from the same. Annexure J, page number 99, dated 24/2/2025. Pursuant to this request, pursuant to petition request, my competent authority considered under one-time settlement offer foreign rupees, my lord, 12 crore 75 lakh rupees. My lord can find it in my lord page number 99. There are certain, my lord, one-time settlement offers, it work like this. In a particular time, he has to pay it. That is called as, so it is not one, it is again and again he can come before my lord bank and he can give a request. It is not so. for a particular purpose, and our competent authority accepted that we are waived certain interest and other components, and we are given benefit of under one-time settlement. It's not in the case that we in fact we are not given a one-time, we are given, which is not complied. It is not in dispute, my lord. Now, my lord, he is coming for this honorable court and seeking this relief prayer before this honorable court is not maintainable. In view of the recent judgment in the honorable Supreme Court in the case of the State Bank of India versus Arvind. Kindly see the prayer sort. My lord, just I'll clarify once again, my lord. Page number 99, which I, my lord, considered his request for one-time settlement offer, and we given time. Within particular time, he's supposed to pay, my lord, the entire 12.75 crore, which is not paid. Therefore,
No, what is this issue? What do you say about prayer C?
Prayer C, when the Secretary of Direction responded to release the commercial properties, no, it can't be done. This kind of prayer, my lord, he can't seek before this honorable court. At the most, that's what my lord, honorable Apex Court says in the case of my lord, State Bank of India versus my lord, Arvind. 3.1 and 7.1. The directions can't be issued against the bank. At the most, either he has to come before the bank. With all fairness, we'll consider once again his one-time settlement offer. That is something different. It's between me and my lord, my borrower.
No, in fact, to my learned friend also may be aware, in fact, the Adalat, we had put forth this request, and before the Adalat, the bank officials were also very fair in saying that, yes, we will do it. But finally, when the letter came from their head office, this was not there.
But ultimately,
Release of the commercial
they
property.
They don't take it. No, but I think this prayer is, how can they grant, even if they, I mean, they want to do it also, they can't do it.
No,
mortgage, how can they, release a particular property and say that you.
No. So
you
that is what they
monetize
normally
that?
do. So what normally they do, if you now may kindly see the OTS letter also, it says that you pay first two installments, we release a property. Then you pay remaining, we release the remaining property. So there is a structured way of releasing the property.
Well, that's what which my one
So
time.
in that case, then he is entitled for release of the C property.
That is what my OTS says, my lord. I cannot dispute it. My lord, kindly.
Because then everyone is a winner. Everyone is a winner. If my commercial property is released, everyone wins. They also get their money. I can also get my.
Clause 2, rupees 10.75 crore to be paid as per the schedule below.
No, Mr. Shetty, please get your instructions properly. Anything to be done so that they will also monetize that and pay the amount.
I'll take instruction. I'll make submission.
Because they are a well-rooted family in that village. They don't want to be called as defaulters, and that is why they are also.
This relief can't be granted. The reason in view of honorable Apex Court. Let them give one more proposal. With all fairness, we'll consider.
Then let the matter be kept alive. I will give a proposal. Within a week, I'll give a proposal.
The petitioner.
And be considered.
Considering the submission of the land council, the petitioner. The petition is permitted to. No, that's what I'm saying. The petition is permitted to give his proposal for one-time settlement, and the bank shall respond to the same.
A time frame can be.
Respond to the same within a period of 4 weeks.
Great.
Within a period of 4 weeks, and the same shall be.
4 weeks from the date of.
The response shall be placed before the court within 4 weeks.
Grateful.
In accordance with law, my lord.
In accordance with law. No, I didn't say to consider. I said only said response of the bank.
In fact, now what courts say is that even consider simpliciter is also means in accordance with law. There cannot be a consideration. In the meanwhile, let them not precipitate because there should not be any.
In the meantime, the no
That maybe by this time I put the property for auction also. That is if I have tomorrow. If instruction, I'll make submission.
No, whatever stage it is, let them not precipitate.
I'll just make this submission.
Because otherwise, the entire exercise becomes futile.
Now it is not in dispute. They are not settled. They are not compliant the one-time settlement offer. Now they can't come and argue that aspect. That is a case I would do.
Great.
No.
ಒಂಚೂರು ನೋಡ್ಕೊಳ್ಳಿ ಸರ್ ಅದು ಹತ್ರ ಏನಾದ್ರು ಶಿಫ್ಟ್ ಆದಾಗ ಒಂಚೂರು ಆಮೇಲೆ ಒಂದು ಲಾಂಗ್ ಲೀವ್ ಮೇಲೆ ಒಂದು ವಾಪಸ್ ಬರ್ತಾರೆ ನೀವು ಇವಾಗ ಬಿಡಿ ನೀವು 2 ವಾರ ಸಿಟ್ಟಿಂಗ್ ಬೇರೆ ಕಡೆ ಹೋಗ್ಕೊಂಡು ಇನ್ನೊಂದು ಚೆಕ್ ಆಗುತ್ತೆ ಅಲ್ಲಿ ವೇರಿಯೇಷನ್ ಆಗಿರುತ್ತೆ ಎಷ್ಟು ಸರ್ ಡಿಸ್ಕೌಂಟ್
very clarification. Okay.
ಜಾಸ್ತಿ ಇತ್ತು
ಸರ್ ಈಗ ನನ್ನ ಕೇಸ್ ರೆಡಿ ಮಾಡಿದ್ದೀನಿ ಅಲ್ಲಿ ಪೆಟಿಷನರು ಇದರ ಬ್ಯಾಂಕ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಾವು ಟೆನೆಂಟ್ ಓನರು ರೆಸ್ಪಾಂಡ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಪೊಸಿಷನ್ಗೆ ಎಂಟ್ರಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ನೋಟಿಸ್ ಬಂದಿದೆ ಆಲ್ರೆಡಿ 2 ಟೈಮ್ ಬಂದಿದೆ ಈಗ ಫೈನಲ್ ನೋಟಿಸು ವಿಕೆಟ್ ಮಾಡಿ ಅಂತ ಅದಕ್ಕೆ ಇಲ್ಲೇ ಬರುತ್ತೆ ಕೇಸ್ ಅದು ಕ್ಲಾಸಿಫಿಕೇಶನ್ನು ಇಲ್ಲ ಹೌಸ್ ಅಲ್ಲ ಬ್ಯಾಂಕ್ ಲೋನ್ ತಗೊಂಡಿದ್ದಾರೆ ಅವರು ಓನರ್ ತಗೊಂಡಿರೋದು ಇವರು ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಮನೆಯಲ್ಲಿ ಸೊ ಓನರ್ ಗಾಟ್ ಅಬ್ಸ್ಕೊಂಡೆಡ್ ಸೊ ಪ್ರಾಪರ್ಟಿ ಬ್ಯಾಂಕ್ ಅವ್ರು ಬಂದ್ಬಿಟ್ಟು ಪ್ರಾಪರ್ಟಿ ಸೀಸ್ ಮಾಡಕ್ ಬಂದಿದ್ದಾರೆ ಸೊ ದೇ ಆರ್ ಪುಟೆಡ್ ನೋಟಿಸ್ ಎವ್ರಿಥಿಂಗ್ ಅನ್ನು ಹೋಗಿ ನೋಟಿಸ್ ಆಗೋಗಿದೆ ಬ್ಯಾಂಕ್ಗೇನು ಓನರ್ಗೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ದೇನೆ ಸೊ ಅಂಡರ್ ರಿಪೇಟ್ ಇಲ್ಲಿ ಬರುತ್ತಾ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಅದು DRT ಅಲ್ಲಿ ಮೋಸ್ಟ್ ಬರುತ್ತಲ್ಲ ಇಲ್ಲೇ ಬರುತ್ತೆ
ಅದೇನೇನು ಸ್ಪೆಸಿಫಿಕೇಶನ್ ಇದೆ ಸುಮ್ಮನೆ ನಾವು ರಿಪೀಟ್ ಕೊಟ್ಕೊಂಡು ಅಲ್ಲೇನೋ ಅವರು ಒಂದು ಮಾಡ್ತಾರ ಆಮೇಲೆ ಇದು ಇವ್ರದ್ದು
ನೋಟಿಸ್ ಅಲ್ಲಿ ಟೆನೆಂಟ್ ಹೆಸರು ಹಾಕಿಲ್ಲ ಅವರು ಓನ್ಲಿ ಶೆಡ್ಯೂಲ್ ಹಾಕ್ಬಿಟ್ಟು ಮನೆ ಮುಂದೆ ನಿಲ್ಸ್ಬಿಟ್ಟು ಹೇಳಿದ್ದಾರೆ
ಏನಂತೆ ಇದು ನಾಗರಾಜ್ ಇದು ಮೇಘಾದು ಅಲ್ಲ ಇದು ಈ ಕಡೆ ಇರೋದು ಮೇಘಾದು ಫೈಲ್ಸ್ ಇದು ಇದು ಅಮ್ಮ ಇವ್ರದ್ದು
ರೀಚ್ ಆಯ್ತಾ
ಟೆಸ್ಟ್